Nancy, you ready? Good morning. We are on the record in case number 2021-103, electronic application of East Kentucky Power Cooperative Incorporated for general adjustment of rates, approval of depreciation study, amortization of certain regulatory assets, and other general relief. My name is Kent Chandler. I'm the chairman of the Public Service Commission, and I'll be presiding today. Joining me today is Commissioner Talina Matthews and Vice Chair Amy Cubbage. For those in the hearing room, please set your cellular phones to silent mode or turn them off. In light of recent increases in COVID cases, we continue to take precautions, including limiting the number of persons in the hearing room, social distancing, and cleaning the witness table between witnesses. Disinfectant wipes have been placed at the witness table. We ask each witness to wipe down the witness area with the wipes at the conclusion of each witness's testimony. For those witnesses who will testify at this hearing remotely, please assist with audio clarity and avoid feedback issues for the video conferencing hearing by muting your microphone if you are not speaking, using a phone for the audio and a computer for the audio. If you are using phone for audio and computer for video, turn off the computer audio. Otherwise, there will be feedback. If you are in a room with several people on their own computers, turn off the computer audio for all but one computer. If another participant is in a nearby location, close the doors between those locations. Once in the GoToMeeting software platform, go to your settings to ensure the microphone setting is on the microphone you are using. Use wired headphones or wired earbuds for better sound quality, and because wireless devices may lose power depending on the length of the hearing. Keep a charger nearby in case your battery runs low, and please alert the commission immediately if you are experiencing technology failures that prevent your participation at any time in the proceeding. The hearing today is for the purpose of taking evidence on EKPC's proposed wholesale rate adjustment, request for amortization of regulatory assets, relief from reporting requirements, and tariff changes. At this time, we will have the entry of appearance of counsel.
Good morning, Your Honor. David Samford on behalf of the applicant, East Kentucky Power, with the law firm of Goss Samford PLLC in Lexington, Kentucky. And with me today is Miss Allison Hoeniger.
Morning, Mr. Sanford. And for the Attorney General?
The Attorney General, Mike West, and in the audience we have John Horn as well.
And for Nucor Steel Gallatin?
Chairman Chandler, congratulations. Nice to be in front of you. Vice Chair Cubbage and Commissioner Matthews. Mike Kurtz, Jody Kyler-Cohn for Nucor Steel, Bain Kurtz and Lowry, 1510 URS Center, Cincinnati, Ohio.
Thank you. And for App Harvest Moorhead?
Thank you, Your Honor. Jim Gardner of Sturgill, Turner, Barker, Maloney, in Lexington for App Harvest Moorhead Farm, LLC.
Thank you, Mr. Gardner. And Ms. Benzel?
Mr. Chairman, Nancy Bensel for Commission staff.
Okay. Now, I've been advised that public notice has been filed in the record. Is that correct?
Yes, Your Honor. I believe it was filed on Wednesday of last week.
Okay, thank you. And there are pending confidentiality motions, and then I think the other pending motion was, we had an order entered on that yesterday. Is that correct, Ms. Benzel?
Yes, on Ms. Kelly testifying virtually.
Okay,
Yes,
thank
Chairman.
you. All right, at this time, we're gonna, well, we would ordinarily open it for public comments, but Ms. Benzel, have we received any requests for public comments?
No, Chairman, we've not received any requests.
Okay, and we did, that was on the website at least at 6 o'clock this morning, I think, or 6:15, for the opportunity for people to sign up to provide those comments, correct?
That's correct. I believe it was on last night also.
Okay, all right, we'll go ahead and skip that then. Thank you. All right, if there's nothing else, Mr. Sanford, if you can call your first witness, please.
Thank you, Your Honor. East Kentucky Power calls Mr. Anthony Campbell.
Morning, Mr. Campbell.
Good morning.
Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Thank you. Please be seated. And Mr. Campbell, will you state your name and address for the record, please?
My name's Anthony S. Campbell, and I'm CEO of East Kentucky Power Cooperative at 4775 Lexington Road, Winchester, Kentucky.
Thank you. Mr. Sanford, you may ask.
Thank you. Good morning, Mr. Campbell. How are you today?
Good, thank you.
Did you cause certain testimony and responses to data requests to be filed in the record of this case?
I did?
Do you have any corrections, additions, or changes to those testimony or data request responses?
I do not?
If I were to ask you the same questions, would your answers be the same today?
Yes.
Is it your desire and intent to have that testimony and those responses to data requests incorporated in the record of this hearing?
Yes. Thank you.
Your Honor, at this time, I'd like to go ahead and introduce East Kentucky's Hearing Exhibit 1, which is the joint stipulation, if that would be okay.
That's fine.
Thank you.
Mr. Campbell, could you please identify that document? Have you seen that before?
Yes, I have. It's a joint stipulation settlement.
Okay, and would you mind to flip over, I believe it's on page, maybe page 11?
Yes.
Is that your signature that appears on that?
I don't have a signature on my copy.
Okay, there's actually 4 different pages, 11, due to
Oh, sorry.
it being signed in counterparts.
Yes, it is.
Okay, and so is this the stipulation, settlement, agreement, and recommendation that was tendered into this docket, as far as you know?
As far as I know, it is.
Your Honor, I'd move this is exhibit number 1.
I assume there's no objection.
Your Honor, with that, I tender the witness for cross-examination.
Thank you, Mr. Sanford. Sustained your entry of that. I think we'll go in the same order that we made the entry of appearance, so for the Attorney General.
We have no questions for this witness.
Okay. Mr. Kurtz,
No questions, Your Honor.
Mr. Gardner,
No questions, Your Honor.
Ms. Wenzel.
Yes, we have a few questions. Thank you. Good morning, Mr. Campbell.
Good morning.
If you can't hear me or if you don't understand my question, please let me know.
Okay?
One of my first questions is, in the settlement, there's a settlement provision that the proposed rates will go into effect on October 1st, correct?
Yes, ma'am.
And previously in this case, the commission entered an order establishing a suspension date up through and including October 5th of 2021. So is EKPC asking the commission to enter an order before October 1st, essentially at the end of September?
Well, let me put a little color around that. I don't know that it has to be on that certain date, and I'll defer that to my CFO, Ann Bridges. But I will say, I know we had a lot of discussion in the negotiations of the settlement, and we talked about moving it to January. So back in 2010, when we did the rate case, and it was critical that we got it done at a certain time because our equity was so low, and we had some challenges with the banks. So we did it in January, and we had a pretty aggressive January. In other words, coldness, the magnitude of the bills were high, and it really caused a mismatch of our owners and East Kentucky, which caused a lot of problems really to the end consumer. And I'm talking residential more than I am industrial. We worked through those challenges, but it was very difficult. So what we really wanted to do was make sure it's in a shoulder month. So the end consumer doesn't get hit with that high bill right at January, right? When they struggle with that anyway. So that's why we really wanted it October 1st, was not as much for us as it was for the end consumer, residential consumer.
So when you're saying shoulder month, then the natural consequence would be that any rate increase, because the usage would not go up as much as it would, say, in January. So
That
if
is
the rates
correct.
went up in October,
That
the
is
bills would not be as high as if it were in January.
Yeah, it's just a better time to do it. If there is some mismatch, we can work through that mismatch, and the end consumer's not hurt by that. Not that they were hurt long-term, they weren't, we worked it out, but we just found that it was a bad time when everybody's usage is high.
Mr. Campbell, do you know what tier is established in EKPC's debt covenant?
No, I'm sorry, I don't. I know our tier with the commission is 1.5, and I'll defer that to Tom Stacknick in his testimony. I could guess, but I don't think that's what you want.
No, I very much appreciate that, thank you. While I'm asking a couple of these questions, let me get some housekeeping out of the way so that we can be as productive as possible. We have some questions about the regulatory assets. And I know that Ms. Burgess discussed them in the settlement testimony very briefly. Mr. Scott sponsored adjustments that involved them, and then Ms. Carpenter had more details on them. So if we were to look for more information about the balances, the background, the history, who would you suggest would be the best person to be asking the questions to?
Well, I would suggest Ann Bridges, our CFO, can answer those questions for you.
And also for the generation, the generation maintenance tracking mechanism.
Yes, and also Craig Johnson
John.
will testify, and I think he would be an excellent candidate to ask those questions.
And finally, the earnings mechanism that's proposed in the settlement, would that also be Ms. Bridges?
Yes.
Mr. Campbell, as you know, in the original application, EKPC stated that it could justify a approximately $49 million revenue increase, but was only requesting a $43 million revenue increase.
Correct.
And that $6 million difference was attributed to certain cost containment in training, travel, and the use of outside consultants.
Correct.
When in the settlement, there's no provision in there that addresses that $6 million cost containment that were initially proposed. So my question to you is, why start the settlement at $49 million? Why not start it at $43 million if you can justify that $6 million cost reduction?
I don't know that I can do a really good job because I wasn't in the settlement negotiations, but I can say what you explained of the cost containment control that we're proposing from the 49 to 43 is why we proposed just the 43. There are other things going on in there, like we're anticipating some load growth. That load growth will offset what we really needed. And then at some point, like 2024 or 2026, can't remember the date exactly, the Smith 1 coal plant regulatory asset depreciation rolls off. So we just didn't think we needed the 49 million. For us, why we started at 49 to 43, I think Ann Bridges, she was in the negotiations, could answer that for you much better than me.
Well, I think probably this one that I can put to you in the sense, how is it fair, just, and reasonable to exclude an expense reduction in the settlement that EKPC was willing to use if the commission had approved the rates as filed?
Well, I think it's fair, just, and reasonable to have that in there because we proposed that up front, that we didn't feel that we needed that extra revenue. One of the reasons we didn't really feel that we needed that extra revenue was because we would over-earn, and then we would have to find a mechanism to get that revenue back into the end consumer's hands. And we don't have a real clean way of doing that. Now, we've been paying some capital credits back to our end consumers, to our owners, but that's not a real good mechanism to get it back into the hands of the ratepayers. One of the things I was really happy about with the settlement was we came up with a mechanism to get that back into the hands of the ratepayers. Whether it's fair, just, and reasonable in the settlement to start at 49, I don't know. I can't answer that, but I will say, I think it was fair, just, and reasonable when we proposed the 43 million.
I'd like to follow up on something you said about the capital credits. With the earnings mechanism that's proposed, and again, this is Ms. Bridges' settlement testimony, but in there, she distinguished that the earnings mechanism would not prohibit EKPC from continuing to make capital credits. Can you walk me through the process of capital credits?
Sure, well, I can do the best I can with capital credits. So when we over-earn, we have cash, extra cash, and in the last couple of years, for the first time in our history, we've actually pushed that cash back through to our owners. It hasn't been a huge amount, but it has been enough that it was helpful to our owners, certainly. And it doesn't impact our margins to push that cash through. But it's probably not as clean as getting it back in the ratepayers' hands, and we would rather do that. Quite frankly, giving people capital credit checks, small capital credit checks, probably is not as good to them as it is just push it through on their rates and lower their rates at the front end. Because that's what they really look at is, hey, what am I paying? Not am I getting a check at, a year later or 2 years later. So I think the earnings mechanism is really well thought out. The challenge will be putting something together that really works, that is a mechanism that funnels that through, that our owners can push it through. That will be a little bit of a challenge, but we're prepared to work through that, and our owners are too, to push that through to the end consumers. Did I answer your question, or did I avoid it? I'm sorry.
It's okay, I can ask some follow-up questions.
Okay.
I think it'll work. When you talked about pushing through, is it the case that with capital credits, EKPC pays the capital credits to the owner-member co-ops, and then the owner-member co-ops decide for themselves whether or not then to flow the capital credits through to the distribution co-ops members?
That is correct.
So, and then with the earnings mechanism, the way that is set up, it will be a complete flow-through down to the end customer.
That is correct. That is the intention of that.
And are there tax implications with the capital credits?
No, there's not tax implications.
No.
We have an 85%. If we have something over the 15% revenue stream for East Kentucky Power Cooperative out of our gross revenue stream, which last year was about $780 million, then that would thrust us into a taxable entity. But we're not even close to that. And a lot of the reasons we're not close to that is because we funnel all of our benefits from PJM through the FAC clause.
I have some questions about the environmental surcharge tier that was agreed to in the settlement. And recognizing you may not be able to answer, I trust that you will tell me who you think can best answer it. In the settlement, there was a proposed 1.475 tier for the environmental surcharge. And just to clarify, this is as opposed to the 1.50 tier for base rates. Now, there was a reference, I believe, in the settlement testimony that EKPC had agreed to a lower tier for the environmental surcharge to reflect recent commission decisions where the commission lowered the tier on environmental surcharge cases for investor-owned utilities. So that's what I will first start asking is, was there a decision that Commission's treatment of the investor-owned utilities and the environmental surcharge, did that impact the decision to have a lower tier for the environmental surcharge in the settlement?
So Ann Bridges is the one to talk about that. She was in the settlement negotiations. I would say that that probably did have a positive impact on moving it down. There were some interest rate changes in that environmental surcharge, in that we're going to use the QUIP. Well, during QUIP, we're going to use the interest rate that's low, which we're borrowing right now in our, I want to say cushion of credit, but it's not. It's, I can't think of, our credit facility that we have right now. And then once we move that into long-term debt, we'll move that interest rate through. But we felt that that was fair, and could put a lot more color around that in the negotiations of that, and how we felt comfortable. We got comfortable with that reduction.
Okay, thank you. Staff has no further questions.
Vice Chair Cubbage, any questions?
Yes, just one series of questions. On page 6 of the settlement, where EKPC is asking for relief from existing reporting obligations, and it's asserted that they are obsolete, could you explain to me why you believe those are obsolete?
Well, Ann Bridges would be much better to discuss that, but there are some things that are just overdue. I mean, we're still doing some reporting, but it has absolutely no impact on East Kentucky. There's no money movement, and so I'm going to defer that to Ann Bridges too, to give you more detail.
Thank you. I have no further questions.
Commissioner Matthews?
I don't have any, thanks.
In a different chair, but some things haven't changed. I have a few questions. The earnings mechanism, are you generally aware of the earnings mechanism that was agreed to in the settlement?
At a high level, I
stipulation?
am.
So let's go back to the $6 million amount, approximately $6 million amount that Ms. Vincel was asking you about, that was discussed in the application discovery. Mr. Collins, intervenor testimony, I think Mr. Scott discusses it in greater detail in his rebuttal testimony, but the company said that you all thought you could find about $6 million in savings, right? And so that's what you actually created the rates from, was that $43 million, but determined that the revenue requirement per the cost that you expected to incur in the test year plus certain adjustments was about $49 million, right?
That is correct.
So let's say you do find $6 million, right? That $6 million that you all thought you could find as savings are not reflected necessarily in this stipulation. Is that right?
In my opinion, that is correct.
Okay. But if you found the $6 million, let's just look at two scenarios in isolation. The first would be that you actually reduce this by $6 million because you think that you can make those adjustments in reality, that you can spend $6 million less. If you make that adjustment in this case, the rates that are charged to customers under the billing determinations, the assumption is that rates are going to be about $6 million lower for all of East Kentucky's customers, correct?
That is correct.
Okay. But under this earnings mechanism, let's say everything happens the exact same way, but that $6 million is included in the rates like you're proposing now, but you still find the $6 million in savings, right? If that, let's just say, everything else works out the same way, you earn a 1.5 tier, the only savings that goes back to customers is the amount of tier over 1.4. Is that correct?
It's my understanding that is correct.
Okay. But if you have a tier of 1.4, 1.45, 1.5, 1.6, it doesn't matter, in excess of your debt covenants, I think it's approximately 1.2. The amount of your net margins that are reflected in tier also are taken into account in your calculation of member equity, right?
Yes?
And you have to, by your debt covenants, take an amount out of net margins to add to your member equity, correct?
I don't believe we have to let our equity grow. In fact, we have a plan not to let our equity grow. So we're going to cap our equity at some point, but we have to have that cash coming in. Then we need a mechanism to get it back. And so our plan was originally, and it's not a really great plan that some of our owners didn't like, was we would funnel that money back through a capital credits. So our intention is not to let equity continue to grow up, right? To grow. In fact, as far as concern of debt covenants, I'm looking for it. Hold on, let me just look here real quick, and I'll give you a firm now. Showing my age. Our debt service coverage will be the concerning thing with all the rating agencies and our banks, because equity will continue to grow. We have no intention of doing that at East Kentucky. It may grow, our board may let it float up a little, especially if we have capital projects come down the road, which are gonna drive that equity down. But one way or another, we were gonna get that money back to the end consumers if we over-earn, either through capital credits, or now we have a mechanism to get it back through to the end consumer, right at the end of the line, through lowering their rates.
Right,
Or
but-
credit.
So I'm asking though, the step before paying a capital credit or reducing the overall amount of member equity. I'm asking, are you aware of your debt covenants or your loan obligations require you to take a certain amount of net margins or net tier or, whatever designation it may be, and take a percentage of that and turn it into retained earnings or retained equity?
No, I don't believe we are. Actually, Tom Stacknick would be the person to ask, but no, I don't believe we're required to do any of that. We have to meet our covenants every year with our gross revenue. And then the next year, we'll have cash, and we can do what we need to do with that cash, which, if you continue down the path that we're doing, our equity is gonna continue to grow, and then our debt service coverage will become the issue. But we have no intention of keeping all that cash. We want to get that back to the end consumer.
Yeah, and I'm not saying you can't still pay or reduce the overall equity amounts, right? Some sort of equity headroom over what you all feel comfortable keeping. I'm just asking, do you know if any of the covenants require you to put some into that amount, even if you ultimately use that to end up paying capital credits?
No, I don't believe they do. Tom Stacknick can clarify that for sure.
And then, who can I talk to about how the tier credit is actually gonna work out?
I'm sorry, could you repeat that?
Yeah, who can I talk to about how the tier credit, the earnings mechanism, is actually going to work out with what the filings at the commission are gonna say, whether it's gonna be a one-time credit per year, a kilowatt hour credit, once a month? Is it gonna be based on demand? Who can I talk to about the specifics around that earnings mechanism?
So Ann Bridges, our CFO, is who to ask. I will say, we're working through how we're going to do that right now, and we haven't met with our owners. But we did talk with them when the board met and voted on the settlement, but we are gonna have to work through some more. We may not have all your answers, but we have to come up with those mechanisms.
Okay, and if I wanted clarity, I know Mr. Scott addressed it in his rebuttal testimony. I think Ms. Bridges discussed it some in her direct. Who can I talk to about that $6 million amount to get specifics on what East Kentucky's, why they proposed it the way you all did, why you all proposed it the way you did? Who can give me the most color around that from sort of the application through rebuttal testimony?
Yeah, I think you're right on track. I think Ann Bridges and Isaac Scott are the two that really worked on that. Michelle Carpenter might be able to throw a little color in too, when we were really looking at what do we really need and trying to minimize what we asked for. Being a cooperative, we don't want to ask for or take any more than we have to from the end consumer.
Okay. That's all the questions I have. Mr. Sanford, do you have any redirect?
No redirect, Your Honor.
Okay. Any other questions for Mr.
No
Campbell?
further questions.
Okay, thank you. Thank you, Mr. Campbell.
Thank you.
Your Honor, may this witness be excused? He has some other things today.
Yes,
That's
sir.
fine.
Thank you, Your Honor.
Mr. Sanford, would you have any additional witnesses? Would you like to call your next witness?
Be happy to move for a directed verdict, Your Honor. Our next witness will be Miss Ann Bridges.
Okay. And Mr. Sanford, I'd like to ask you, Ms. Honaker, and all the attorneys, especially the ones that will be participating remotely, as you all provide direct to the witnesses, will you please ask them the question of what they have in front of them, especially those that are testifying remotely, whether it's a copy of their testimony or a copy of the entire record, I don't know what it may be, but do you all mind to do that through your direct examination?
Sure.
Thank you. Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Do you-
Okay, thank you. May be seated. Please state your name and address for the record.
My name is Ann Bridges. I'm the Executive Vice President and Chief Financial Officer for East Kentucky Power, 4775 Lexington Road, Winchester, Kentucky.
Thank you, Ms. Bridges. Mr. Sanford, you may ask.
Good morning, Ms. Bridges. How are you today?
Doing well. How are you?
Good. Did you cause certain testimony and responses to data requests to be filed in the record of this proceeding?
I did.
And if, do you have any corrections, additions, or changes to those responses and testimony?
I do have one change to my supplemental testimony, specifically on page 6, line 7. It should read, over the past several years, EKPC has not achieved its authorized tier. The reason for this correction is that East Kentucky did achieve a tier in excess of 1.5 in the years 2013 and 2014.
Okay. With that addition or correction, if I were to ask you all the same questions, would your answers be the same?
Yes, they would.
And is it your desire and intent to have your testimony, your supplemental testimony, and the responses to data requests filed in the record of this hearing?
Yes.
And would you please let us know what materials you have in front of you today?
I have in front of me copies of the joint stipulation along with my testimony, both my supplemental direct, as well as I have some, an annual report with me as well.
Okay.
Just some notations.
Sure. You're honored to tender the witness for cross-examination.
Thank you, Mr. Sanford. For the Attorney General's office, Mr. West,
We have no questions for this witness.
Mr. Kurtz,
No questions, Your Honor.
Mr. Gardner,
No questions, Your Honor.
Ms. Vincent, do you have any questions for?
Yes, we do have a
Bridges?
few questions. Good morning, Ms. Bridges.
Good morning.
And I'm going to have a standing request for all of EKPC's witnesses. If you can't hear me or you don't understand the question, please feel free to ask. I'm going to start with a couple that I asked Mr. Campbell about. Mr. Campbell indicated that you could give some more color to the settlement provision for a effective date of October 1st for the rates, and that this was part of the negotiations. To the degree that you can, will you expand upon that?
Yes, East Kentucky does its billing on a calendar month. So for a cleaner cutoff for billing purposes, we were requesting an October 1 implementation date for service rendered on and after.
Thank you. As I asked Mr. Campbell, as initially proposed, EKPC indicated it could justify a $49 million revenue increase, but was only going to ask for $43 million and proposed rates based on $43 million rate increase, correct?
That's correct.
Okay. And can you speak more to the $6 million in cost containment that was identified in data requests?
That $6 million, that was actually somewhat of an aspirational response as to what possibly could be cut. In the direct testimony that I gave, while we could have requested the $49 million, we chose to only ask for 43 just because we were coming off of the pandemic and we were wanting to keep the rate increase as filed as close to 5% as possible. So that's where we got to that, and actually I addressed that on page 9 of my direct testimony. We also asked that if there were any adjustments that either staff or the interveners found that would come off of the $49 million starting point.
And so is that the reason why the settlement began at $49 million?
Yes, it is.
I guess that, again, as asked Mr. Campbell, if approved as filed, EKC would have had to make certain cost containments to address the $6 million difference between what it could justify and what it would request. So how is it fair, just, and reasonable to anticipate that there's $6 million in reductions that could be achieved, but not to include that in the settlement?
Again, we were in the settlement, we felt it was appropriate to start with the higher number. You know, in the settlement, we got down to 38.3 million, which was less than our original ask. So, you know, we believe that the 43 million, as proposed in the application, was a fair, just, and reasonable request, considering the impacts on our in-use members.
I really don't want to beat it. I was going to say beat a dead horse, and I'm sorry, I just said that out loud. If EKPC proposed a $6 million cost containment and believed it would not impact reliability, then why would it not be appropriate for the commission to go ahead and reduce the settlement amount by the $6 million of the identified or aspirational cost containment?
Well, we believe that the $38.3 million settlement that we landed on would be a fair, just, and reasonable settlement of all components of this case. So that's actually a lesser amount than, you know, starting off the 49, but we do believe that amount is a fair, just, and reasonable request. And we don't believe any further downward adjustments are warranted.
Do you believe EKPC still intends to make those reductions as they can that were proposed in training, travel, and reduced use of consultants?
Well, East Kentucky Power, just in its normal operating course of business, you know, very mindful of the spend that we make. So not only in those categories, but any other categories, we are going to do what we can to contain cost. As in Mr. Campbell's testimony, you can see over the years the various initiatives that we have implemented, and we will continue to look for areas of cost savings wherever we can.
And can you tell me what tier is established in EKPC's debt covenants?
The tier, it's actually a margins for interest covenant, which is like tier, but it's only on secured debt, and that's a 1.1 margin for interest, and that is on the credit facility. There is not in some of our old agreements, there was a best 2 of 3 years. If it's failed in any 1 year, the credit facility is failed. That's also in our indenture as well.
And to make sure I'm understanding, so that the 1.1 is
It's
MFI?
MFI? Yes.
That's every year.
Yes.
Is there a fair comparison between MFI and tier?
MFI usually is about 0.01 or 0.02% higher than the regular tier.
So again, I'm not trying to put words in your mouth, but to impute a tier, it would still be right around 1.1.
That's correct.
So in your testimony, you had discussed the consequences if EKPC was approved for a tier less than 1.50. Can you explain how EKPC will achieve the 1.5 tier if the revenue increase of $38 million to the base rate is authorized? Okay, that was a long compound question. Let me re-ask it. If the commission approves the settlement as is and the revenue increase is $38 million, how will EKPC achieve its 1.5 tier?
Well, the 1.5 is looked at by our rating agencies as a very positive. You know, looking back at the last 5 years, we have not achieved a 1.5 tier, even though that is the amount that is authorized in our base rate. So really, for it to be authorized, we have been running around the 1.3, between probably high 1.2s, high 1.3s. So, you know, we believe that that is the minimum for base rate purposes that would give us some room, so to speak, to meet within our, both our debt covenants and our credit rating agencies.
In the settlement, as I asked Mr. Campbell, in the settlement, the environmental surcharge tier is set at 1.475. And I believe it's in your settlement testimony that, and correct me if I'm wrong, that part of the reason for having this tier level is to reflect some of the commission's recent decisions regarding return on equity for investor-owned utilities.
That's correct. It's our understanding that a lower rate of return was granted for the IOUs. That's why we agreed to a lesser return or lesser tier component on our environmental surcharge.
And do you believe that EKPC, as a generation transmission co-op, has a similar risk in the environmental surcharge as an investor-owned utility would have?
I would say that both the G&T cooperatives and the IOUs comply with the environmental surcharge statute. So from a risk perspective, I'm not sure that there would be a lot of difference.
So what type of risk does EKPC face in its environmental surcharge that would justify a 1.475 tier?
We, you know, that would be, you know, we believe that we could justify a certain return on our weighted average interest rate. And, you know, we believe that 1.475 would be acceptable for us to apply in that context.
I'm going to try to keep things generally organized in my thoughts. If I skip around, I hope you'll understand.
Sure.
In your settlement testimony, excuse me, you referenced that the cost of service study was updated pursuant to the settlement. I want to make sure I understand. Are you referring to make sure I pronounce his name, Mr. Mackey's?
Yes.
His revisions?
Yes.
And in those revisions, EKP accepted 3 of Stephen Barron's, excuse me, recommended adjustments?
That's correct.
I have several questions about the earnings mechanism, and I hope I'm not stepping on questions the chairman wished to ask. The details of the earnings mechanism, there's not a great amount of detail, so we need to get some more information to understand it. We now understand that there will be a bill credit if EKPC's margins exceed the 1.4 tier. Will the bill credits be issued on an annual basis or on a monthly basis?
That is still being worked out, but we intend for the bill credit to be complete, whether it's on a one-time or a monthly, to be completed within the next calendar year.
So 2022?
So 2022, if East Kentucky were to get a tier greater than 1.4 in 2021, we would expect the refund to be completed in 2022.
And at what point do you believe the parties will file additional details regarding the earnings mechanism?
We would file the details by April 30th. That would be when our audit is complete and the numbers have been justified.
I wasn't very clear there. Let me go back. If the commission were to approve this as it is, there's a considerable amount of details that impact the bill, how this all works, that are to be determined. So do the parties intend to file additional information or have an additional agreement before final order in this case?
What we had suggested in testimony is that we would file a tariff specifically stating the over-earnings mechanism. Also, the tariff that our distribution cooperatives would also file within 30 days after receipt of the final order in this case. On the wholesale side, we're looking to do the flow-through as a percentage of revenue basis by rate class.
So knowing that with the flow-through, but as applied to the customer bills, what would the methodology be? Would it be revenue? Would it be kilowatt hours, usage?
That would be something that we would work out with our owner member cooperatives to determine what would be the best route for them to flow that back through to the end-use customer.
And the so the parties have, again, I don't want to put words in your mouth. I want to make sure I'm understanding. What the parties have agreed to the best of your knowledge, a more general framework of the earnings mechanism with the complete details to be determined by EKPC?
That's correct, to be filed with the commission after this case, yes.
And not to go too far down the road, but I would expect that if the commission approves the earning mechanism under this scenario, that when a tariff filing is made, that a case would be open to investigate it. And I would presume the parties would, to this case, would wish to join that case. Has there been any discussion of that by the parties?
There was no discussion of an additional case. We interpreted that we would make a tariff filing explaining the details of the mechanism.
Move next to the generation maintenance tracking mechanism. So there appears to be a 75%, 25% split in this. Could you tell me, let me back up and make sure I get this clear for the record, that with the generation maintenance expense, there's a budgeted amount that's been agreed to be recovered in rate. EKPC will track its actual spending and on an annual basis do a comparison between the actual generation maintenance spending and the budgeted amount, and would either establish a regulatory asset or a regulatory liability depending on whether actual spending was higher than or lower than the budgeted amount.
That's correct, and we intend to make a filing with the commission showing the gross amount over the 81 million basing, what I call levelizing point. If we, let's say for round numbers, had $1 million over, we would record a $750,000 regulatory asset. If it were, lower, we would have a regulatory liability. The details of all of that would be filed with the commission annually.
Well, I'm going to go back and do this, unpack this little by little. How was the 75% determined?
That was a negotiated amount.
And what happens to the other 25%?
The other 25% would just be absorbed through margins, would just flow in margins.
So as we discussed, there'll either be a regulatory asset or a regulatory liability.
Yes.
And as I'm sure you know, EKPC cannot establish a regulatory asset or liability without prior commission or without commission approval. So at what point in this process would EKPC request either regulatory asset or regulatory liability?
We were hopeful that if the settlement were approved, that because this has been somewhat spelled out in the stipulation, that in order for it to be less administratively burdensome for the commission, that may be an automatic regulatory asset or regulatory liability tracking with an annual filing that would suffice to establish that debit or credit.
So implicitly in this, then EKPC is requesting the establishment of, to establish either regulatory asset or liability.
That's correct, as part of this mechanism.
And would it be a regulatory asset or liability for every year of tracking?
It would be netted among years and then trued up in East Kentucky's next base rate proceeding.
So then is it EKP's expectation that the commission would review the reasonableness of the amounts in the regulatory asset or liability in the next rate case?
Yes.
And does EKPC propose to amortize that tracking mechanism in the next rate case or between now and the next rate case?
We would propose to, just to track it, either a net regulatory asset or liability, then request recovery or refund, whichever it may be, in the next base rate proceeding. And at that time, the specific number of years would be identified.
So then, I think that's answered, it would be amortized in the next rate case?
Yes.
In the settlement agreement, one of the issues is an issue that AppHarvest Moorhead had raised, both in this case and in a separate case with Fleming Mason, that has to do with negotiating commercial and industrial lighting. That particular demand-side management program was discontinued in 2019, correct?
That's correct.
And why was it discontinued?
It's my understanding that it was discontinued because it was no longer could pass the cost-benefit test.
So in light of that decision in 2019, then is it appropriate to continue moving forward with that in this case? Or is it part of ongoing negotiations?
We have agreed to work in good faith with AppHarvest to develop an agri-tech tariff. There seems to be a need for such tariff. We are going to look within that particular tariff if there are any type of lighting mechanisms that could be of benefit to AppHarvest and other similar customers.
And to the best of your knowledge, do you know how many AppHarvest parent entity, how many individual AppHarvest companies either are or will be or propose to locate within EKPC service territory?
AppHarvest Moorhead is in service, and I'm aware of 3 other affiliates looking to be a part of East Kentucky.
I'm going to move to the stipulation and settlement. I'm just going to call it settlement agreement if the parties are open to that. We will have a post-hearing data request. We would like to receive the settlement exhibit C, and this is the revenue summary by rate class present in settlement rate revenues. We would like to receive a copy of this in Excel version with all of the supporting calculations. And within the Excel, of course, all of the formulas, rows, columns, unprotected and accessible. And consistent with commission policy, after the hearing, the staff will issue a post-hearing data request, and this will be one of the items we include.
Okay.
Can I have you turn to Settlement Exhibit C? The page 1.
Let's see, I don't. Just a moment, I don't have I didn't print the exhibits to it.
We can make the copy, or I can give you mine.
Yes.
Okay, I have Exhibit C in front of me.
Thank you. As you can see here, rate E has a 5.2% increase. Rates B, C, G, large special contract, and STEAM have a 2.6% increase. And pumping stations have a 0, no increase. So why is the increase for rate E higher than for the other rates?
Rate E is our largest class of customer, and based on the way the cost of service fell out, so to speak, and based on settlement with our interveners, that is where the 5.2% is where kind of the bulk of our service is. I believe that came down from, subject to check, about 5.5 in the application.
And is that higher increase to reflect that other classes were subsidizing rate E, so try to address that issue?
Partly so. Part of that was the rate E needed a little higher increase than some of the other classes.
So to better align the cost of serving that rate with the revenues.
That's correct.
And why was there no increase for the pumping stations?
That contract is not, the contract does not allow for any increases in that particular class.
And the substation charges for rate E and G has increased. What is the basis of that increase?
That was also just a result of the cost of service study. Probably any details of the cost of service study would be better addressed by Mr. Mackey.
I do have some questions for him, so I will ask him those. Thank you. I have some questions about the regulatory assets, and Mr. Campbell suggested that I might have you answer them. If you're unable to answer them, please tell me who can best.
Okay, I'll see what questions they may be, and
And tell me if you're familiar with this, that there are 4 categories of expenses that the commission has traditionally approved for regulatory assets. I will walk through them. I'm not going to ask you to name them. The extraordinary non-recurring expense that could not have been reasonably anticipated by the utility or included in the planning. An expense resulting from a statutory or administrative directive. An expense in relation to an industry-sponsored initiative. And the 4th is an extraordinary non-recurring expense that over time will result in a saving that fully offsets the cost. And EKPC has asked to include or amortize and include 4 different regulatory assets in rates. The Smith 1 regulatory asset and Spurlock, Dale surcharge, and Dale, I believe, the ash ponds. I'm sorry, it's the asbestos ARO. I would like to start with the 2 Dale regulatory assets. Both of these this regulatory asset, starting over here, the Dale regulatory asset for the environmental surcharge projects 5 and 10. Are you comfortable discussing them, the background to them?
I actually probably not the background. That would probably be Mr. Scott or Ms. Carpenter would be able to respond to that better than I.
I think I will hold my questions for them, if that's acceptable. And if anyone defers a response to you, then we can recall you. Is that acceptable?
That would be fine.
Let's do that. Ms. Bridges, can you tell us why the 2.6% increase was picked for the rates where it was 2.6% increase?
Could you please ask that again?
Sure. Why 2.6% for the rate increases for rates other than E?
That was a product of our settlement.
And how does it align with the cost of service?
It was fairly aligned with that, and we believe that we are very comfortable with the way that agreement took shape.
Can you expand upon it? Or let me ask you, who is in the best position to expand upon the 2.6% increase? Would it be Mr. Mackey or Mr. Scott?
Mr. Mackey.
Mr. Mackey? I'll follow up with him on that. And these questions may be better directed to Mr. Mackey, but I will start with you. In a scenario in which the commission found additional adjustments were required to the revenue requirement, whether an increase or a decrease, and these adjustments were both reasonable and supported by substantial evidence in the case record. Given the framework of the 2.6% increase for particular rate classes, would it be preferable to maintain a similar percentage of increase if the revenue requirement were to change, or would you adjust all rate classes proportionately? Essentially, would any of the increase be absorbed by other rates and keep these others at 2.6%?
I think that would be something we would need to evaluate depending on the particular circumstance.
Well, are there any rate classes or components that EK could believe should not be changed from the settlement in the event of an adjustment?
I think East Kentucky would like to keep this same, what I would call, level of a proportional adjustments among the various classes.
And if the commission were to modify the rate design as proposed in the settlement, how would, does EKPC have a recommendation to distribute the allocated revenue between the rate class components?
I really am not sure. Again, we would probably need to evaluate what the particular circumstances would be.
So if, for example, demand versus energy. I believe right now, is it a 2-to-1 ratio of demand to energy?
That, I believe, is correct. Again, that would be probably better confirmed by Mr. Mackey.
Okay. Staff has nothing further.
Vice Chair Covich?
I do have a few questions. And obviously, if you're not the right person to answer them, you can just let me know. I'll ask them to later witnesses. First, and it's mostly on pages 4 and 5 of the settlement, there's, at least 2 categories of items that are kind of to be determined at a later date with the App Harvest, demand side management and the tariff, or the Agritech tariff, as well as the Tennessee Gas Pipeline Company contract. I guess more generally, and then I can ask some more specific questions, how would you expect, do you have any expectations of what kind of revenue changes might occur as a result of later negotiations, and how that might impact the adjusted base revenue?
As far as the 2 items for App Harvest, I don't see those having any direct impact on the adjustments at hand. What we have done is commit to work in good faith on both of these items with App Harvest to evaluate the applicability of the demand response program in PJM, as well as developing an Agritech tariff that may be of benefit to the App Harvest companies.
And on the Tennessee Gas Pipeline, I noticed on the Schedule C, it's currently allocated a 0% increase. Do you expect it to go up, go down? Any expectation at this point?
Actually, what we have committed in the settlement agreement is to work with 2 of our member systems, Fleming Mason Energy and Taylor County. They are the direct server of Tennessee Gas Pipeline. Those contracts are between Fleming Mason and Tennessee Gas Pipeline and Taylor County and Tennessee Gas Pipeline. We are not parties to those agreements, but we are going to talk with both of our members about that and to see if they are interested in doing any modifications to those agreements.
Okay, so I guess just for clarity, I know we've got, like I said, a 0% increase,
Right.
and that's figured as part of the adjusted base revenue. We don't have an expected risk at this point that those revenues could drop and impact the 38 million.
No, we don't see any impact of this on the 38 million at all.
Okay. Now, on the reporting obligations, I know you were listed as someone who may be able to walk me through that. It's proposed here that they appear to be obsolete. Could you, and I apologize for being new and maybe not understanding why, could you explain why these particular reporting obligations are obsolete?
A lot of these, like for example, the first one with respect to the tier and debt service coverage, that has been in existence since our 2006 rate case. And a lot of these moving down the line, the Smith regulatory asset, that was also something that came into effect in 2010 when we requested regulatory asset treatment there. We have been doing periodic, sometimes they're monthly, sometimes annual filings that we really don't believe have any benefit for the commission even at this point. And I think there are other venues just in our general filing of our annual reports and things that may take some of the place of this. We just don't believe that maybe even for the commission that these are longer worthwhile.
I don't have any further questions.
Commissioner Matthews?
I have a couple. Sorry, I forgot how to talk behind a mask. Just help me understand the timing issue, and that if the suspension date is October 5th, so you would, I guess, prefer an order by September 30th, so that rates would go in effect on or after October 1st. Given our lean and mean staff, and, you know, the fact that there are 4 major gas utilities in for rate cases, and then the 16-member co-ops having their accompanying cases to this one, if that were not to meet the September 30th, and I won't be here to stop that, I won't be the impediment, don't know who will. But does that mean that rates would go into effect on or after November 1st?
Our preference is to do a calendar month
Okay.
because of our billing.
Okay. And again, I recognize the shoulder month concern, even though our shoulder months haven't been shoulder months lately, they've been warm, you know, peaks in Septembers and Octobers. And then just on the, I guess I'm trying to not say what I'm thinking, which is, you know, the relief from certain existing reporting obligations. Do you think this was the appropriate venue to address those? Or perhaps those would have been better addressed between the company and the commission, rather than, you know, in a stipulation? I mean, it just seems a little that it doesn't fit.
We just saw this as a, I guess, a vehicle to make the request, and that's why we put them in the application and then carried them forward in the stipulation agreement. Perhaps individually, they could have been requested, you know, we could have maybe made several filings requesting that. We just thought from an administrative perspective, this was an opportunity to request relief.
I don't have any further questions.
Good morning, Ms. Bridges.
Morning.
I have a few, I'll try to track maybe along what Ms. Vincent did so that we're a little bit efficient. I'd like to start with the environmental surcharge. So is it your understanding that investor-owned utilities earn a return on the capital they employ for the public convenience and necessity?
It's my understanding that they have a return on their environmental surcharge assets as we do a tier on ours.
Right, I mean, I'm taking up even a
Okay,
30,000
sorry.
foot view. They invest capital for the public convenience, and in return, they have a defined service territory, and the commission gives them a return on their investment.
Yes.
Effectively, right? That's commensurate with relative risk, and in the same geographic area balance with customer concerns, right?
Yes.
Okay, that's not the business model of East Kentucky, correct? You don't have investors that are employing their capital for the public convenience and then earning a commensurate risk return.
That's correct. We have our members.
Okay, and the ROE for investor-owned, the equity return for investor-owned utilities, that's their cushion, correct?
Correct.
And for you all, you basically are looking at what the expenses are, you're setting rates on that, plus a cushion based off of tier. Is that right?
Correct.
Okay. And tier's not necessarily calculated based off of commensurate risk like investor-owned utilities ROE. Is that fair?
That's fair.
It's just a set number, and then whatever the interest is in that given year times that set number, that's what looks at tier, right? Not all tiers are created equal. It depends on what the utility's interest is. Is that correct?
That's fair, yes.
Okay, so when interest rates are at 10%, a 1.5 tier is materially different than when interest rates are at 3%. Is that fair?
Yes.
So, the environmental surcharge, and it's been a while since I've looked at it, but my understanding is costs are recovered, costs are passed through the month after they're expended by the utility. Is that your understanding?
Yes.
Okay, and then is there an annual true-up for East Kentucky in which they, for that, for the factor that they charge on the bill, that if there's an over or under recovery of the environmental surcharge, that's trued up the next year as
That's
part of the factor?
Excuse me, that's actually trued up monthly. There's an over-under recovery monthly.
Okay, so just taking a step back, you spend dollars in the fourth month of the year, right? You spend dollars in April, you're able to recover those dollars in May, and if you over or under recover those dollars in May, there's a change to the factor for the expenses that you had in May to account for that over or under the next month in June.
Yes.
So that's materially different than how you all are proposing in the stipulation to set rates in this case, right? That you're taking a test year of billing determinants and a test year of expenses. You're coming up with what you believe to be a good tier at 1.5, and then you're coming up with rates based off of that, those test year expenses and as compared to those billing determinants. Is that right?
Yes, I believe that's the case.
And there aren't true ups. If you earn a 119 or a 17, that's what you earned, correct?
Correct.
Okay, now you all have proposed, and we'll get to it in a second, the earnings mechanism where anything over a 1.4 in terms of tier is passed back. And we'll talk about that in a minute. But we're talking about effectively, environmental surcharge is a formula rate where it's trued up monthly and costs are recovered the month after. Whereas we're doing traditional rate making with test year on base rates, right?
Yes.
And the only difference in cushion is between a 1.5 for this traditional, a little more riskier relative to the formula, a 1.5 tier here, and a 1.475 tier for the environmental surcharge. Is that correct?
That's correct.
And you said, is there a difference in any of the loan covenants for the debts incurred for purposes of environmental cases? Is there anything different, or is it still the 1.1 MFIR?
It's still the 1.1. There is no difference between environmental projects and non-environmental projects.
Okay, and so I can appreciate the interest in having a 1.1, debt covenant where you fail it, right? You fail it, you're in violation, and wanting to set rates because of that on a 1.5, because you don't know any given year what the highs and lows may be, right? But I guess I'm a little struggling to having a 1.5 tier when, for the environmental surcharge, or a 1.475, when your MFR is 1.1, when you are recovering costs the month after incurring them and have the ability to true it up the following month. Why there needs to be effectively the same amount of cushion. I get it's 0.025 different, but effectively the same amount of cushion for the environmental surcharge as what's being proposed in here to set base rates off of. So could you speak to that?
Well, one item, our rating agencies look at both the fuel adjustment clause and the environmental surcharge very favorably, in that, it's an ability to do recovery monthly versus waiting for a base rate increase. And, historically, we have had a 1.5 tier for surcharge purposes. So, we believe there should be a certain component of return on the capital assets included in the surcharge. We were willing to come down from the 1.5 to the 1.475 for the stipulation, but do feel that there needs to be some recognition of a return on our weighted average interest associated with those projects.
But it's not necessarily a return, right? I mean, tier doesn't represent a return on investment or a return on interest. It's a cushion to ensure
Right.
that you meet your debt covenants. And what I'm curious is, do you think that you need that much cushion for the purposes of the environmental surcharge to meet your debt covenants? Is there a risk in the environmental surcharge that if it's set at 145, I'm making up numbers, not 145, 1425, 14, that if it's anything less than proposed in the stipulation, that there's an actual risk that you get anywhere close to that 1.1 MFIR at over a year?
Again, we believe that the 1.475 is an appropriate amount, so.
No, and I appreciate that. The MFIR is on an annual basis, correct? It's on a 12-month calendar basis. So if you're able to true it up every month and recover it the next month after your expenses, is there an actual risk if it's set at even 145 or 1475? Is there ever any real risk? And I get that, you know, if aliens come, maybe, but is there any real risk that you get anywhere close to an annual 1.1 MFIR at a 1.475?
I don't know in isolation that would be the case.
And your MFIR is on an overall basis. It's not broken up between the environmental surcharge and base rates. Is that correct?
That's correct.
And so, taking a step back, my expectation is at least at some portion of the fact that you have a 1.5 for the environmental surcharge historically has probably made up for the non-environmental surcharge capital and loans that are taken out. Is that fair?
Well, I mean, as we're looking at just our overall tier in our total tier in the last several years, you know, we've been in the high 1.2s to high 1.3s overall.
Right. And
So,
I guess what I'm asking is the 1.5 effectively brings up all non-environmental surcharge tier. If it's at 1.3 and you know you're earning basically a 1.5 on the environmental surcharge, the law of averages are that non-environmental surcharge debt is actually below the 1.3 level. Is that fair?
have to kind of work through that, but
If it's averaged with 1.5 to come out with 1.3, it would have to be below 1.3, right?
right.
The regulatory assets and liabilities with the 2575, the generation maintenance
Yeah.
expense, the normalizing that expense. So taking a big step back, if, let's just say the proposal was to have a normalized amount in the test year, right, that your rates are set on, let's just call it $10 million, making up a number. You have a normalized amount in your test year. If it wasn't tracked for regulatory asset or regulatory liability recovery at all, right, then in the years that you don't earn, or in the years that your generation maintenance expense is $11 million, right, that's higher than your normalized amount, so it's going to hurt, all things being equal, hurt your tier. But the next year, that will be, if it's $9 million, you might have spent an extra $1 million in cash the year before, but you've saved $1 million in the year after, and it balances out, right?
Right.
Okay. And though your tier may have been low the first year and high the second year, your cash is indifferent. The only difference you have is effectively the time value of money. Is that fair?
Fair.
Okay. But with this tracking mechanism, you're spending that $11 million, 75% of that money, you've already, it's a cash outlay. You're out the cash, right? Because you had to pay people to do this. You thankfully got to defer, right, 75 million of it, but you're missing out on the cash. It's just not a hit to your bottom line. Is that fair? The 7.5 million?
Well, it was already a hit. The additional $1 million outlay was already done. But we would be able to defer the $750,000.
You're out the cash, but it doesn't affect it's not an expense realized in that year.
25% of it would be.
Okay, so 7.5 million, you're out the $1 million in cash. 7.5 million does not show up as an expense in that given year. It's deferred. The 2.5 million is an expense realized in that year, right?
Correct.
Okay. So then the next year, it's at 9 million. You have $7.5 million that is going to offset that regulatory asset, and you've saved that cash, right?
I'm trying to follow you here. but-
Okay, sorry, so normalized generation expense and rates is $10 million. Year two, it only actually cost you 9, right? You get the cash back, your cash is equal, right? You're now only out the time value of money for your cash. But you've deferred, you've added back the 750 to your regulatory asset, and the 250 goes to your bottom line, right?
That's correct. In the year that we went above,
Okay.
in your example, the 10 million, if we went 1 million, or trying to think of what number.
Well, so here's what I'm curious about, and this is what I'm really getting to. I'd like to know how it works in relation to the tier credit, the earnings credit.
The two are separate.
Well,
And I'll try to, the one is strictly looking at the generation maintenance. And there's an 81 million and some change level that we are setting as part of our base. Anything above that would be 75% tracked as a regulatory asset. Likewise, anything below a regulatory liability. That's one component. The earnings mechanism is totally separate once you get to the, almost what you would call the last entry of the year, to see where everything stands from a tier perspective.
So what I'm curious about is that if you, let's just say, in this hypothetical, that you set the generation maintenance expense to a normalized amount of $10 million, and then in every year, it's $9 million, right? You save $1 million a year compared to your base rate, your test year levelized expense. Only 2.5 million of that per year, or sorry, I keep saying 2.5, but it's only 25% of that per year is actually going to be passed back through the tier credit, because 75% of it is actually being deferred as a savings and not going to the bottom line for calculation of tier every year. Is that right?
That's correct. It would be in a regulatory asset or liability. I think in your case, it's a liability.
Okay, and so you're saving the cash, which is great, but customers are only getting the benefit of 25% of it through the tier credit. Is that right?
And our customers, if we had a net regulatory liability in our next base rate case, that would be considered as a recovery at that time
Okay.
through our next base rate proceeding. What we call the earnings mechanism is a yearly pass-through, so to speak, to our members that would allow them to get anything above the 1.4 immediately.
So I'm curious though, it feels like you're saving cash in those individual years, right? You're passing, possibly 25% of that cash back through the tier credit, but you're saving cash in all those years. But if it comes back in as a regulatory liability and you begin to amortize that regulatory liability, that's going to be an offset to rates, right? The regulatory liability, even, let's just say you don't amortize it. Let's say you include it as a regulatory liability in rate base. So it's an offset to rate base, right? It actually will decrease revenues in the future, right?
It would actually be considered as an offset, so to speak, to our other adjustments in the next base rate case. It would be considered, we would be giving it back in our next base rate case, is how this is envisioned.
Okay. And I have a couple questions about this. I think you described it, the $6 million as aspirational. I'll be the first to say that when I read the application, it seemed like you were saying, we believe we will find $6 million in savings, and therefore that's what we've set our rates on. Only kind of after maybe intervener testimony did it start getting referred to, in my opinion, as aspirational, or well, we threw that out. But that's what the rates were set on, was the $43 million, right?
Yes, what I was saying was aspirational, was selecting only travel and the consulting fees, that those were, asked to be specific as specific as we could. Those were the two items that that's the two items that I say are aspirational. They're not specifically targeted to make up that difference. I can't tell you specifically that would make up the difference, and it wasn't meant to be any type of concession.
And maybe it was, maybe it's sort of a hope to start low and, offset what interveners might start saying adjustments might be. But my question is, in addition to what's proposed in the stipulation, does East Kentucky expect that they will save an additional $6 million from cost containment measures?
No, East Kentucky, the 38.3 in the stipulation is what we expect to be considered a reasonable adjustment in this case and a reasonable level of revenue going forward.
So taking a step back, your testimony said that you expected you all could find $6 million in savings. Are you now saying you don't expect that you all could find that $6 million in savings?
We will always look for savings, but, we could have justified the 49 million. We chose to not ask for that amount initially. But we did, because we could have justified that, did request that any adjustments start from that higher number. We did not want to go much above the 5% increase to our members, particularly in light of just the timing of everything.
If what you're saying is that you were willing to just forego $6 million in order to limit the increase to 5% for your customers, that's one thing. But that's not necessarily what the testimony said. It said, we will find $6 million in savings to make this work. So is it more the former or the latter?
It is, again,
Your Honor, if I could, I've got her testimony on this subject right here. Would you like me to refer to?
No, I read it last night. My curiosity is, your testimony was what it was. You were asked questions about it. You started talking about the $6 million and breaking it down with travel. And then Mr. Scott's rebuttal testimony said, well, all this started based off of a single data request response. And I didn't even read, be perfectly honest, through the pendency of the case, read the data request response. I read your testimony, and I thought you were saying we can find $6 million in savings. We just haven't necessarily identified it as test year adjustments. And that's the distinction, is we hadn't identified it as test year adjustment. We expect we can save $6 million. And all I'm curious is, do you expect to save the $6 million, or were you all effectively saying, we don't want to go over the 43 and we will find ways to make it for $43 million?
we were going to find ways to make the $43 million.
Okay. That's fair. I asked Mr. Campbell earlier, and if Tony Stacknick, is that right? Is that how-
Tom?
Tom.
Stacknick.
I wrote Tom. I don't know. I just said Tony. Tom Stacknick. If he's the right person for this, please tell me. But I was asking Mr. Campbell about what happens in any given year when there's a tier above the 1.1 MFIR, right? And whether there's a requirement in the covenant that a portion of that be retained, at least initially in that year, retained in as retained equity or member equity. Are you aware of any provisions like that?
I believe, and this is subject to confirmation with Mr. Stacknick, I believe we cannot pay capital credits per our debt covenants unless we have at least 20% equity.
Okay, so you have a minimum equity amount, but you're not aware of whether you have each year a specific amount of your tier that has to be put in that year in member equity?
I'm not aware of that,
Okay.
no.
I have one more for you. I'm sorry, Ms. Bridges. Oh, I think Ms. Vinsel asked you a question earlier about the rate E increase. And I think she was asking about the 5.2% that's proposed in the stipulation, and you said you thought it was higher than that.
It was higher in the original application.
would you agree that the application subject to check was 5.3% for rate E?
It could very well, subject to check.
So I think it was like a $38 million increase that's being proposed, maybe 38.1 million in, I think it's Exhibit C, I have it here. It's a $34.3 million increase. $34.3 million to rate E at 5.2%. Do you know what the initial allocation was? And I'm looking at page 18 of Mr. Mackey's direct testimony, where he has that rate E is a 5.3% increase, and it's 34,925,736. So about
That's correct.
$600,000 difference. So there was, there's a $4.5 million reduction to the rates here, right? And only 600 of it went to rate E, with rate E being about 75 to 80% of East Kentucky's revenues. Is that right?
That's right.
Okay. And then, is rate E, and I have some questions for Mr. Mackey, because I can't find a couple of schedules that I'd like from him. But was rate E under-earning that bad, that it kept the same, effectively kept the same percentage increase, and everybody else went down?
I believe, and this also would be more appropriate for Mr. Mackey, but there were some modifications made to the cost of service study that did not seem to impact rate E as much as it did some of the other classes upon the modifications.
Okay,
So-
and that was in the rebuttal testimony, correct?
That's correct.
And the rebuttal testimony that was filed after the initial settlement had been determined, is that correct?
That's correct.
And then, finally, I have a question about the contract, and I don't know who falls under contract, but in the direct testimony, contract was 8% proposed increase. You remember that?
Yes,
And now it's a 2.6%.
yes.
Do you believe that's due to the change in the cost of service
Yes.
study?
Yes.
Mr. Sanford, those are all the questions I have. Do you have any questions?
Just a few, Your Honor. Yeah, this won't take 4 or 5 minutes, I think. So, Ms. Bridges, let me ask you that the joint stipulation that was filed here, in your opinion, was it the product of compromise?
Yes.
So if you were to look at any single element, East Kentucky may agree or may not agree with it in an esoteric sense, correct?
Correct.
But if you take the settlement agreement as a whole, in your opinion, is it fair, just, and reasonable?
Yes, it is.
Okay. Let me also follow up on some of the questions that you were asked about the difference between the $49 million increase that could be justified and the $43 million that was requested in the application. Could you please, do you have your testimony in front of you?
I do.
Would you please refer to page 9 of that testimony, beginning on page 11?
Yes.
Could you read that question and then read the answer that continues through the end of that page, please?
Yes, beginning with, please discuss the basis for the requested 43 million rate increase.
Yes, ma'am.
While EKPC could justify a higher award, the board and management are mindful of the impact of any rate increase, the impact any rate increase has on its owner members and their retail customers. At the same time, it is important to assure that EKPC does not lose ground in terms of maintaining a healthy financial condition. In light of these factors, EKPC's objective in preparing this case was to keep the total rate increase to approximately 5%, which it was able to do. In the event that any intervener or the commission should find that any negative revenue requirement adjustments are necessary, EKPC would respectfully request that it first be offset by the revenue it has voluntarily chosen to forgo. In other words, EKPC hopes for the end result of this rate case to be as close to a 5.2% increase as possible.
Okay, so would it be fair to say that when East Kentucky's board authorized the filing of this application, it sort of had the end in sight? In your testimony refers there to a 5.2% increase. That was really the goal, correct?
That's correct.
Okay. And so in order to achieve that 5.2% increase, the revenue request would only be about 43 million.
That's correct.
Okay. So in your experience, how many years have you been observing and participating in commission proceedings?
Off and on since 2005.
Okay. So in your experience, is it usual for a utility to put in its application and its testimony that it thinks it could justify a higher revenue requirement than what it's actually asking for?
No, this was a little bit of an unusual, I guess, circumstance. Typically, a utility will ask for what it can justify through its revenue requirement calculation. Being mindful of the service territories that our members serve, plus 2020 being the year that it was, we really wanted to hold our rates to around a 5% increase, and that's where the 43 million was derived.
And for purposes of entering into the stipulation is consistent with the testimony that the adjustments begin with that 49 million figure, correct?
That's correct.
Okay. If the commission were by chance to reject a portion of the stipulation and begin to, in essence, put a $6 million adjustment on top of the stipulation, would that fall under the category of no good deed goes unpunished?
Yes, it would.
Let me talk a little bit about the stipulation as well. There is, on one hand, there's the request to keep the 1.5 tier, and then on the other hand, there's an earnings mechanism.
Right.
Let me first ask you, do you think that there's any sort of maybe relationship of how those will work?
I think the 1.5 is what we believe is necessary to keep us in good stead with our rating agencies and keeping our interest rates low. In the event, the earnings mechanism is a way to, what I would say maybe give our members an immediate credit if we were to earn in excess of 1.4. So that would be what we would consider, I think we are in agreement to give back to our members quickly in the event we do earn more than the 1.4, because a 1.4 tier for us would be adequate for both our lenders and our rating agencies.
Okay. You were also asked, I believe, about provision in the joint stipulation that has to do with the commercial industrial lighting and
Yes.
how that applies to AppHarvest.
Right.
Just to sort of clarify, the commercial and industrial lighting tariff that failed to meet the California test,
Right.
that wasn't limited to any particular industry, correct?
That is correct.
Okay, and so the commercial or the industrial lighting tariff that's being considered in the context of the joint stipulation is more narrow and limited in focus, is it not?
It would be looking at to what the particular agritech members' needs are, and then evaluating another cost-benefit California total resource cost test looked at upon that.
Okay. And obviously those negotiations, those discussions haven't taken place with AppHarvest, correct?
That's correct.
But is it possible that a lighting tariff within a more narrow, limited context may make more sense than a general industrial lighting tariff?
Yes.
Okay. Your Honor, those are all the questions I have.
Thank you, Mr. Kurtz, Mr. Gardner.
No question, Your Honor.
No questions?
Ms. Vincel?
No follow-up.
Thank you, Ms. Bridges. Step down. I think Ms. Vincent would ask if Ms. Bridges could stick around for a while, since we may have some questions that other folks can't answer.
I'd be happy to do so, Your Honor.
Thank you. We will take a short recess until to 5 minutes after 11, and then we'll come back and try to work through until a little bit after 12. Thank you. We're back on the record. Mr. Sanford, do you have another witness?
Yes, Your Honor, we'd like to call Mr. Isaac Scott, please.
Mr. Scott, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please be seated. Mr. Scott, please state your name and address for the record.
My name is Isaac S. Scott. My address is 4775 Lexington Road, Winchester, Kentucky.
Mr. Sanford, your witness.
Thank you, Your Honor. Mr. Scott, did you cause certain testimony and responses to that or request to be filed in the record of this proceeding?
Yes, I did.
And do you have any corrections, changes, or edits to that testimony or responses to data requests?
No, I do not.
If I were to ask you the same questions today, would your answers be identical?
Yes,
Is it your desire and intent to have that testimony in response to data requests to be entered into the record of this hearing?
yes, it is.
And could you please identify any materials that you may have taken to the stand with you today?
Okay. I have a copy of my direct testimony, several of the application exhibits that I sponsored, my rebuttal testimony, a copy of the settlement, copy of the supporting calculations for the settlement, and all my data responses.
Okay, thank you. Your Honor, I tender the witness for cross-examination.
Mr. Sanford. Mr. West.
No questions for this witness.
Mr. Kurtz.
No questions, Your Honor.
Mr. Gardner, back in the back.
No question.
All right, thank you. Ms. Wenzel.
Yes, I have a few questions. Before we begin, Mr. Scott, staff put a packet of PSC exhibits on the witness stand in addition to providing to counsel. It looks like you have them now. Thank you, counsel. We'll be referring to them a little later in it. I wanted to make sure you had them before we began. I'd like to start with a question about known and measurable changes. And as you know, in the application, EKPC has used a historical test year that ended December 31st, 2019, but also included known and measurable changes. The proposed cutoff date was June 30th, 2020. Is
That's
that a
correct.
correct? Thank you. Could you tell me, in the testimony, there was some discussion about commission precedent or examples that were followed that used a similar 6-month period for applying known and measurable changes. Is that a fair assessment?
Yes.
And were there any other reasons that EKPC decided to use a cutoff date 6 months after the historical test year for most of the known and measurable changes?
I believe it would be accurate to say I was relying on my experience and past practice, nearly 23 years of working for the commission. We generally stayed in that window. There were always exceptions, and there had to be justification for those exceptions.
For the adjustment to wages and salaries, that was one of those exceptions, correct?
To an extent, the reason I picked it up into the calculations, the board of directors made that change effective just before the end of June. We had to go out I felt the best way to get the calculation was to base it on an actual payroll, and that's why it went beyond June. But it was picked up because the effective date was set by the board back to June.
And am I correct then that first payroll that reflected the change was that I believe it was September 18th, 2020?
The September, yes.
And can you expand a little more on the basis for moving that date out? You talked about the payroll change. Can you just give me a little bit more of an explanation of why EKPC decided to apply it to that first payroll that reflected the change?
The board actually approved the change, I believe it was in July, and it took some time to actually get the process, get the systems updated so it could be picked up. Also, the reason the very first payroll was not picked up was we have a few employees that rather than got a base wage increase, received lump sum. And they were paid in the first payrolls in September. And if we had left those in there, I would have been annualizing lump sum payments. And it was an attempt to try and be as accurate as we could. I will readily admit there are drawbacks to using one payroll, but we felt it was better to work from the one payroll, to work from a payroll, and that was the cleanest, like a better term, that we could come up with.
And to follow up on your statement about the cleanest and using the one, I will tell you, as a post-hearing data request, we are going to request salary and wage data by month from September 2020 until the present. And I'm going to read the entirety of the request again. It will be in writing to council. So provide salary and wage data by month that shows the number of full-time equivalent and part-time equivalent employees by employee group, hours worked by regular and overtime, and total salaries by employee group. I'm going to give Mr. Sanford a moment to capture all that.
Thank you.
And Mr. Scott, in your rebuttal testimony, you disagreed with one of the Attorney General New Corps' witness, Lane Collins' recommendations that other post-employment benefits, OPEB, be annualized.
Yes.
And you said you believed it was a violation of the matching principle. Can you expand upon that?
I made that distinction several times in my rebuttal to Mr. Collin, and it was always going from the basis that he was carrying things out to December 31st, 2020. He was going a full year out. That's the primary reason on any of those.
And subject to check, can you confirm that the actual cost of OPED for EKPC for 2019 is approximately $3.28 million?
I believe, subject to check, that is correct. I know we have provided the number, so.
And in 2020, it was $1.058 million.
As of December 31, 2020,
That would appear to be yes.
I believe that was where the number is. The amounts are recorded monthly, so
Can you tell me, is a majority of that reduction in OPEB from 2019 to 2020 attributable to the move from a Medicare Advantage plan to a self-funded plan?
I believe I'm going to have to defer the specifics to Ms. Carpenter, but the OPEB that Mr. Collin was working from, I believe there is an actuarial study that showed changes. It's more than just the moving some employees from self-funded to Advantage plan. I do know that, but I can't tell you by how much.
Okay. Again, acknowledging that Ms. Carpenter may have the information, are you aware if that information is in the record that staff can refer to?
Yes, the study, I know the study was supplied.
Also, in Mr. Collins' testimony, he alleged that EKPC does not use the authorized depreciation rate for the production plant accounts that were agreed to in case number 2010-00167. We'll just call it the 2010 rate case. Do you have a response to Mr. Collins' allegation?
Based on the information I have seen, EKPC's last depreciation study was approved in 2006. Since that time, East Kentucky had been following an approach of looking to the service life. So from the extent of actual depreciation rates that were the rates established in the 2006 production, East Kentucky was using the service life calculation instead and had consistently disclosed that in any filings where that question came up. It was disclosed in the 2006 rate case. I believe it was disclosed in the 2008, and it was been disclosed in all of the auditors' reports.
Okay. So I want to make sure I'm understanding correctly. For the test year, the actual depreciation expense, not the adjustment, the actual depreciation expense, was it calculated using the depreciable lives that were approved in the 2010 rate case?
It would be working off of service lives. It would not be tied to the 10 case because the depreciation rates, authorized depreciation rates, are older than 2010.
So it sounds like you're using the service lives from the 2006 depreciation study?
They would be based more to that. I'm getting a little out of my area, so I better, to keep everybody in good shape, I better stay back.
I appreciate that very much. Should I ask Mr. Spanos this information, or who should I ask this information?
Mr. Spanos might be the better witness on that.
Can I ask a question, Ms. Vincel?
Yes, please.
Are you aware of the commission ever approving service lives for East Kentucky's generation or production assets?
Explicitly, I don't believe the 2006 order went that far. That was how it was interpreted.
Yeah, I'll just say, I've not necessarily seen it in a time period in which the commission has ever said, this is the service life. I've seen them approve depreciation studies that have assumed service lives, but usually depreciation rates are based off, a number of factors, including salvage value, both interim and terminal, and these dang Iowa survivor curves. But never just, this is the date it's expected to retire. We say that's a good date for the service life. Is that your understanding?
My understanding would be you would probably not find a commission order that says that.
Okay, but you're saying that the depreciation rates, the book depreciation that the company has had over the last, let's say, 15 years has been a straight line depreciation based off the company's determination of production service lives.
It is straight line, and it would be based on the production of the service lives on production plant, yes.
As determined by the company.
It's rooted in the 2006 study. Assets since then would be determined by East Kentucky, yes.
Okay, and do you know if there have been changes to those assumptions of service lives between that approved depreciation study now?
For assets that were in existence at that time, I don't believe there have been any changes in the estimated service lives.
Okay, but just to be clear, the depreciation, for book purposes, the depreciation rate that's being used is a straight line rate based off of service lives, not the rates approved by the commission in the 2006 rate case.
For the production plant, straight line, it would be based off service lives, not what was approved in the depreciation case. It wasn't There was a depreciation rates case and then a separate rate case in 2006.
Okay, and I've always been told, the couple times I've paid attention in accounting classes, that there can be a difference between book and tax depreciation. Do you know if you all are consistent in the assumed depreciation rates, that you all are being consistent between those two?
We don't have to deal with tax depreciation
At all.
because we're not subject to income taxes, thank goodness.
Well, and the only reason I ask is Miss, I should have asked her more questions about it. Ms. Bridges mentioned that you all use MFIR as your calculation, and the difference usually between MFIR and TIER are extraordinary items and income tax differences. And she said there's usually a couple of differences between the two, so it must be the extraordinary items. So I apologize, Ms. Bensel, go ahead.
Thank you, Chair. Mr. Scott, I have some questions about the interruptible service credit,
Yes, ma'am.
the rate, and the cost justification. I know that you sponsored an exhibit ISS-3. Are you the best person to ask about that, or is there anyone else?
I did the calculations, so I probably better start with me.
All right, that's very good. Thank you. Let me start with rate D, and I don't think you have that in front of you. A staff's reading of rate D is that starting with 400 annual hours of interruption, the interruptible credit decreases by about 70 cents per 100 annual hours of interruption.
The gaps between 200, 300, and 400 hours are 70 cents each, yes.
And what is the basis for that gap, that decreased rate?
The difference, that, I'll be very direct with you. The difference was established many years ago, and we have tried to find the documentation, but I believe it is recognizing that fewer hours being eligible for interruption justified a reduction in the credit. How it was arrived at that 70 cents was the appropriate, I really cannot tell you. But it is, I'm sure it is relating to the fact that someone that could only be interrupted a maximum of 200 hours in a year shouldn't get the same credit as someone that could be interrupted 400 hours. The calculation is normally looked to the 400 hour and, if necessary, adjusted accordingly.
Thank you. In front of you, you should have the PSC exhibit packet.
Yes, ma'am.
If I can have you go to exhibit ISS-3. And again, this is, I'm just going to explain what it is right now. This is EKPC's cost justification for the interruptible service credit.
Will it be acceptable? I have the copy of my ISS-3 in front of me. I don't
That's-
see ISS-3 immediately, and this, I'm sure it's
I think
here.
it's the last page.
Very last page?
Because
Okay. We have it either way.
I was going to say, I can vouchsafe that staff has not done anything to this exhibit, and it should be the same exhibit that you have.
It is.
I'm going to go ahead and label this PSC Exhibit 1. So on what source did EKPC base its avoided cost estimate of interruptible power?
The estimate was based off of the price of a generic single-cycle turbine. That information, I'm trying to recall, I believe we got the pricing information from EIA, I believe. Yes, the EIA Outlook. And it was based on a single-cycle turbine of approximately 237 megawatts. The particular item as listed here was a GE 7FA, and the reason it's that specific, that was the description within the material we were pulling from.
Okay.
And that started with the initial installed cost using estimates from, information from EIA, and then determined debt rates estimates on depreciation, those things.
And so I want to make sure that I'm understanding, so that in the EIA document that you pulled this from, they went to a specific model type, not just that generic single cycle combined.
It's, I say it's generic in that it's what is initially out there. My understanding is that as you get into getting a turbine for a specific purpose, it starts changing some things. And that's what I mean by generic. It was just what's available in a listing somewhere. It was not designed specifically for East Kentucky.
Right, and that you're building to my next question, which is if EKPC were to be short on capacity and needed to self-build, would it build a similar combustion turbine?
If that were determined to be the most cost-effective asset to add, yes, but it would go through an evaluation. There might be a need to, depending on the circumstance, we might look at different types of assets, maybe combined, or I believe Mr. Barron referenced a special high-speed, high-start one. It would have to depend on exactly the circumstances.
Is there any other witness, I'm thinking of perhaps Mr. Cruz, who could address that question in your opinion?
I believe that would be a good place, yes.
Okay. And you mentioned Mr. Barron. Mr. Barron had recommended that the contract class 10-minute interruptible credit be the PJM net cone. Is it your sense that, well, first to begin with, that the contract class 10-minute interruptible credit should be PJM net cone?
My opinion is that is a change from the way interruptible credits have been set in the past for East Kentucky. As I expressed in my rebuttal, I'm concerned when a credit gets so large that it offsets the demand charge for that part of the load.
I've got some more. I think I'm going to save them for Mr. Cruz, though, if you don't mind. You provided testimony about the ratchet provision in Rate G.
Yes.
Can you first explain what the ratchet provision is?
Ratchet provision is in our Rate G and our Rate C. And what it states is that, well, may I do a comparison?
Yes, please.
Rate B does not have a ratchet. When we build demand for Rate B, it's whatever the actual is for that month. There's some comparison of whether it meets contract demand or not, but it's pretty much what is going to be billed will be whatever was actually used that month. The ratchet looks at the demand for the given month and the 11 previous months and takes whatever is the highest of those 12. So if you have a customer on a ratchet and they have said, if they have a fairly stable load, it probably doesn't hurt them to be on a ratchet. But if they are in a fluctuating situation, it may not be the best rate for them. In other words, if, let's say for the 12 months ending this month, if a ratchet customer's highest demand was in February, that will be the demand billed each month until the following January unless something higher hits. It doesn't go, it goes down only when the 12-month, when that 12-month window has expired.
And we know that, again, one of the requested changes is to include this in the tariff. And the question really is, why not just handle this through each special contract?
We were anticipating that it is going to become more frequent.
Oh, can you tell me why you anticipate that?
Several, well, RHG is generally available. We have been using it to try and attract larger customers, especially high load factor customers, and to offer them the best tariffed rate, we've generally looked to RG, which has the ratchet. Startup windows for especially large industrials, it's rare that they would start out and just have a steady upward ramp of their demand. And we felt like this was the appropriate time to put something in like this on G to recognize that, say, a first year, it's going to be erratic. It's similar to what has been incorporated, I believe, in the Diageo contract. We had to do a waiver in the first year because we realized their demands were going to be fluctuating. And rather than lock them in per the tariff language, we had to put a clause in the special contract. We could do this by special contract, but we felt it was going to become frequent enough that it was worth sending the signal to people that we were willing to consider it. That's one way we use our tariffs with our, especially larger with the larger contracts we work out with our member systems, is that we see the tariffs as giving people a public idea of what we're willing to initially consider. And it was to send the signal we were willing to consider that if the circumstances warranted it.
Thank you. Sticking with rate G,
All right?
rate G has a minimum demand of 15,000 kilowatts.
Mhm.
Can you tell me what the basis is for that minimum?
As I believe I've said in one of the data responses, we were advised several years ago that because of what we were offering rate-wise on that, and the idea of making it attractive to larger industrials, that there should be a limit. Unfortunately, that tariff has evolved over time, and several groups didn't pay as much attention to it. The rate originally was the contract rate for what is now International Paper's electric service. That was at that time was one-time situation. The tariff was, the rate was incorporated into our tariffs in the past. It still was designated essentially to International Paper. But then in the, I believe in the 2006 rate case, the designation was taken off. So it was just left there. It was poor tariff language structure, really. We should have been a little more careful then. And because of the extra benefits that are in that rate, plus who we're trying to attract with it, we had been advised as part of the 2008 rate case not to go below 15, but we never carried that through into the tariffs and decided we needed to do that to be fair to everybody, let them know what we really were planning to use that for. There have been exceptions, and if circumstances warranted, we would still consider exceptions and work them into special contracts.
Again, you've done a good job anticipating my next piece, which is if it's not in the tariff right now, has the KPC denied customers the opportunity to use rate G? if their minimum demand was less than 15,000? To the best of your knowledge.
To my knowledge, we have not denied anyone. I believe I'm correct in that we have worked with one customer when they first went on that rate, and they were actually a little below that. Their load has since grown into it, so they would be at the minimum now. We would not be going back if anybody that's on, all of our customers on G currently would meet that 15 with no trouble.
I'm going to move on to rate B now.
All right?
EKPC proposes to revise
Mhm.
TRFB to essentially codify EKPC's current practice of treating minimum demand as contract demand. Can you first explain what the difference is between the two? Is there a significant difference?
In the way we've been approaching it today, there really isn't, but that language was established many, many years ago, and it may have been in vogue then, but quite frankly, when we were looking at it, it was kind of like, what the heck is minimum when you've got a contract? So it was as much to try and clean some things up for everybody concerned.
So, right, it sounds like this is just more of a terminology, an artful phrasing, rather than distinct differences. Would that be a correct?
I think that's a good representation, yes.
Other than administrative efficiency of dealing with this in this rate case, is there any other reason why EKPC did not make the change prior to this case?
We have been aware of it for some time, but we felt like it was better. A little bit of this from my experience, again, in my previous life, that it just seems like it's better to address tariff changes of this nature when you're doing a base rate case, rather than come in and pick it up as a standalone, because then there's always questions of, well, does that change something else? Does that change a revenue flow? This should not change revenue flows, but that always becomes a question if you do it standalone. So we felt like a rate case was the better vehicle to try and take care of this.
And I have a similar question about the power factor adjustment. It's a change in terms from actual demand to billing demand.
Yes.
Is this another case where it's artful phrasing and not a distinct difference?
I believe that would be a good characterization, yes.
I know you've been waiting for this. We're going to move to regulatory assets.
All right,
And we're going to use the packet that's in front of you.
okay.
I'm going to start with the generation maintenance regulatory asset liability that is implicitly being requested in this case.
Yes.
Because we don't have good data on this, let me ask you, let me back up. Are you familiar with those 4 categories of expenses for which the commission typically grants approval for a regulatory asset?
Yes.
So, and I can go over them if you'd like, but which of those 4 categories would be applicable to the generational maintenance regulatory asset?
I just said that I was familiar with them, but for some reason I've suddenly drawn a blank on the narrative on the 4.
I've got them handy for you. Would you like me to read them to you?
If you would, please.
I'll be glad to. The first is an extraordinary non-recurring expense that could not have been reasonably anticipated or included in the utilities planning. The second is an expense resulting from a statutory or administrative directive. The third is an expense in relation to an industry-sponsored initiative. And the fourth is an extraordinary non-recurring expense that over time will result in a saving that fully offsets the cost. And if you would like, I can ask that question as a post-hearing data request.
I think it would be best if we could do that by post-hearing, if that's all right.
Oh, no, of course, it's fun. And in fact, if there's anything that I ask that you think might be better handled that way, please let me know.
Okay.
I just have to make sure I make a big note to myself, please. I'd like to first start talking about the Smith One regulatory asset.
All right.
And to the degree that, let me tell you something, tell me if you know this to be a fact or not. I will represent that the Smith One regulatory asset was first approved in case number 2010-449.
That sounds correct.
And the basis, that category expense, was that it was under that extraordinary non-recurring expense that could not have been reasonably anticipated or included in the utilities planning, and also as a non-recurring expense over time that will result in a savings that fully offsets the cost.
That sounds correct.
And both of those is because the Smith One unit was retired.
The Smith One unit was canceled.
Canceled, I'm sorry, thank you, canceled.
Yeah, we never got it built.
Can I have you turn to, it's a PSC exhibit. It's actually two of them. The first one has Goss Sanford letterhead, and it was filed in, and it references it here, PSC case number 2015-358.
I have it.
And we've also got the final order for 2015-358. For purposes of identification, I would like to label the letter from Goss Sanford as PSC Exhibit 2, and the final order in 2015-358 is PSC Exhibit 3. Now, I want us to walk through the stipulation because the balance, and particularly the amortization period remaining life, is at issue, and it had been in dispute prior to the settlement. Can I have you turn to, in what I've labeled PSC Exhibit 2, the letter from Goss Sanford? It starts on page 4. And I'm not going to have you read this entire thing because it goes on long. But if you can read through and confirm that I've got an accurate representation. The purpose of this, tell me when you're on page 4.
Oh, I'm sorry. Now, we're talking about 4 of the stipulation itself, correct?
Yes, yes.
Basically, Article 1.
Article 1, yes, and,
Okay, I'm with you.
okay. And to be more generalized, let me go over here. It's in section 122, begins on 4 and goes over to page 5.
I'm there.
In this, and let me back up and do some foundation. This was a stipulation entered by the parties in that case that set forth, among other things, the Smith One amortization period and subsequent recovery, or request for recovery. Now, under this agreement, the Smith One regulatory asset book balance was to be amortized net of expected mitigation and salvage efforts beginning January 1st, 2017, correct?
Yes,
And EKPC, in fact, did do this, correct?
we have done that, yes.
Okay. And when I say the mitigation and salvage efforts, it's the actual results of EKPC's efforts, particularly the net PJM capacity market benefit?
The net PJM market benefit was one component, and mitigation and salvage was another component. But yeah, they are both part of it. The amortization of the regulatory asset for accounting purposes picked up mitigation and salvage to determine the amortization.
Thank you for that clarification. And the amortization period was a 10-year amortization period, correct, that the parties agreed on?
That's what is in the section, yes.
Okay. And can I have you go down to section 1.25?
I'm there.
Okay, what this says is, at the next general rate-based proceeding, EKPC was to request that the rates be adjusted to reflect the amortization expense, and that the adjustment would be spread over the remaining months of the 10-year amortization period that began on January 1st, 2017. Again, we've got some more provisos and caveats that address the fact that the PJM delivery years may not align with the historical test year. But moving on from that, when we look at this, I'm sorry, I'm getting ahead of myself. Let me move back. So let me have you bring up, it's PSC Exhibit 4, I'm going to call it. It's your Exhibit ISS 1, Schedule 120.
I have it.
Okay. And I'm going to ask you some questions. They may be very simple, but we really need to get to the bottom of a couple of things. I hope you will bear with me on this.
This is a unique treatment for a regulatory asset. I mean, that was pretty much what I think everybody understood when this was started, so yes.
Can you, what made it so unique?
It is unique in that traditionally, if you were setting up a regulatory asset and going ahead and starting to amortize it for book purposes, when you came in for a rate case, you would be looking, if there was nothing that had to be changed in the regulatory asset balance, and you're actually going to incorporate an adjustment for the test year. This gets into the headache of, was the regulatory asset originally in your previous rate case? And I'm working from, my statements are from the concept that it was not, like this would be. When you're including it, you would have taken the outstanding book balance of the asset and determined what was left of a reasonable amortization period, and that would be the amortization expense. What is unique about the Smith 1 solution was that East Kentucky took the position, and I believe it is reflected in the stipulation and the commission's order, that first, that Smith 1 should be recovered. It was reasonable we were prudent in what we did at the time, but it was prudent at the time the plant was canceled to cancel. By being prudent, it was reasonable to recover that in some fashion. And that fashion was a combination of three pieces. Any mitigation and salvage that we could accomplish. The net PJM capacity benefit, which was identified originally from the case when we joined PJM. And the balance to be through base rates. That's unique in that it is not dependent in any shape, form, or fashion on the book amortization of that same regulatory asset. It's as if you've got two separate things running not necessarily side by side, but two different concepts side by side. And then when you come to a rate case, you try to put the two together and come up with how to go forward.
Would you say from that explanation that the basis of the difference between the intervener's recommendation of amortization period of 84 months differs from EKPC's recommendation for amortization of 63 months?
That's where the big difference is coming from. Had there not been the stipulation, I would not have come back in my rebuttal and said otherwise, because that would have been consistent. But we believed that by the commission's adoption of that stipulation, that the 10-year window, I know there's nothing absolutely permanently fixed, but that was something we could rely on. So to try and, what I believe was function as closely in the spirit of the settlement as we could, that we should be able to expect the amortization to be finished by December 31, 2026.
Right.
And that's where the big difference is coming in, is because of the way these two, they're just different approaches.
Let's walk through that, because Lane Collin, one of the intervener's witnesses, has asserted that the pro forma regulatory asset balance of a little over 73 million, it overstates the actual balance, and that's because according to Lane Collin, EKPC did not calculate any amortization of the regulatory asset from January 1st, 2020 through the end of through September 30th, 2021. So let me see if I can take a step back. Can you show me where on Schedule 1.20 that particular period is accounted for?
There's no recognition of the book amortization in 1.20.
Okay.
Because it's not part of Section 125 of the stipulation. I mean, I don't disagree there, but again, the stipulation does not require a reconciliation with the book amortization. It establishes what amortization is to go through rates to take care of that third piece of the recovery pie.
I'm sorry, I thought the chairman had a question.
Well, I do, I don't want to interrupt you, Ms. Bensel, but that doesn't make sense to me. So you started amortizing that regulatory asset when?
The book amortization began on January 2017.
And you recognized that amortization, correct?
That amortization showed up in the calculation of our margins each year, yes, sir.
Okay. And you were allowed to do that outside of a rate case because you were also recognized at least close or in excess corresponding income through the PJM revenues, correct?
The net PJM capacity benefit was considered to be covering that expense since it was not built into our existing rates.
Because otherwise you wouldn't have been allowed to amortize it, right? It would violate the accounting standards because there's not an offsetting amount of revenue. Is that fair?
I have a little trouble saying that's an accounting standard.
Well, ASC 980, I'll restate it. ASC 980 allows the amortization of the booking of a regulatory asset as long as it's presumed to be able to be recovered.
Yes.
And that's where the PJM revenues came into play, to basically offset or to recognize those PJM revenues so that you could recognize the amortization expense of the Smith regulatory asset. Is that fair?
That was the basic concept, that there was the offset. Otherwise, had we not had let's say we did not have the PJM capacity benefits, we would have still had the reg asset sitting on our books, and we'd be asking for the entire amount because we wouldn't have started amortizing it. Normally, There are exceptions, but you normally would not start amortizing a reg asset unless you had some revenue stream there to help offset it.
Right, so you have the regulatory asset, you net it of salvage, then you have a balance of the regulatory asset. You start amortizing it at the beginning of 2017 at a specified amortization expense. How is that amortization expense calculated?
Amortization expense is calculated by the net value of it, that taking off the salvage, and dividing it by the time period expected to be amortized. In other words, the very first month's amortization expense would have been the amount divided by 120.
120, to represent the 10 years in the settlement agreement.
Yes.
Is that fair? So what is different between what this January 27 amortization and the January 1, 2020 amortization that you were just discussing with Ms. Vinsel?
This goes back to the stipulation agreement in section 125. It explicitly spells out how we're to figure the amount available to be recovered in rates. The assumption is that mitigation, salvage, and the PJM benefits up until that point cover an amount, provide for the recovery of so much of the Smith asset. The amount to actually be left to recover has to be calculated in a specific way, and it is not tied to our book amortization. That's just the nature of the nature of the stipulation.
Okay, so you're saying that the book value of the regulatory asset changes not based off of the actual amount of it that has been amortized, but of the net PJM revenues and the salvage value.
Under 125, that's the essential, that's in a nutshell the calculation. You start with that amount and amortize it over the period remaining of the 10-year.
Was the net PJM revenues in excess of the amortization expense from 2017 to the end of 17, 18, and 19?
Let me see. They are not an exact match, I know that much. It probably would be better to give you, if we could take that as giving you a schedule as opposed to hearing data request of comparing the two.
Yeah, and I'm just looking for, just to restate it for Ms. Vinsel's benefit, whether the recognized PJM revenues between January 1, 2017 and the end of 2019 were what they were, and then what the amortization expense was over that 36-month period for that regulatory asset. Okay, so there was a balance on January 20th.
Yes.
But that balance doesn't matter for purposes of the rate case, is what you're saying. The stipulation says the balance that had been amortized down to and netted of salvage is not necessarily the balance as of January 1, 2020 for purposes of amortizing it forward. That balance is net of salvage and net of the PJM revenues.
The amount that would be considered for an amortization expense to build in for base rates is, as you said, it would be the net capacity benefits, subtract the book balance, subtracting all the capacity net capacity benefits, and subtracting all mitigation and salvage.
Okay, and then you all, I think your position is 63 months is what the remaining amortization period is out of the 120 initial period. Is that right?
Comparing the expected effective date of the new rates with the end of the 10-year period is 63 months.
Okay, and your understanding is that the 84 months has more to do with that recalculation that occurred on January 1, 2020 that Mr. Collin discussed.
My understanding of the 84 months is, like I was saying, would be the more traditional amortization. How do I say this? That would be the more traditional approach, but that wasn't what was in the stipulation.
And when you say traditional, you mean it was amortized for 36 months, took a break from being amortized for the last year and a half. There's 84 months. You're not saying that. You're saying it should have gone 36.
It would have continued to have amortized, and you would have figured up what. there was still book amortization going on, and it's still going on today. But the timing, to me, the problem was that Mr. Collin was suggesting that by using 84 months, that was pushing out beyond the 10 years that was established in the stipulation.
Okay. All right, I apologize, Ms. Insel.
No, thank you, Chairman. I think you got most of the questions that I had. Well, in addition to the post-hearing data request referenced there, staff has two other post-hearing data requests. The first is to provide Schedule 1.20 calculated upon 84 months of amortization beginning in January 1, 2020, and calculated through December 2026. So that more traditional.
Well,
Can you not do it?
no. I just want to make sure I'm understanding the request. Start figuring it at January 1, 2020
Yes,
through December 2026.
yes.
Okay. Thank you.
And then the second post-hearing data request is to provide the balance of the Smith 1 regulatory asset. I'm just going to say for each month in 2021 and for the remainder of 2021.
Okay.
Does that make sense?
Yes.
I will move on to the Dale regulatory assets for the environmental surcharge projects 5 and 10.
Okay.
And to give a little background again, and tell me if this correlates with what you understand, that this regulatory asset was approved in case number 2015-302.
That sounds correct?
This arose because the Dale Station was being retired in 2015. And that impacted these two projects. The projects were in the environmental surcharge mechanism.
Yes.
And because the mechanism only applies to facilities that are utilized for the production of energy from coal.
Yes.
So once Dale was retired, these projects could not flow through the environmental surcharge mechanism any longer.
That was the commission's decision, yes.
And so of those four categories of expense, this one was approved as an expense resulting from an administrative directive because Dale was retired because it wasn't able to meet certain environmental regulations,
Correct.
the MATs. And EKPC has requested to include, I'm just going to round up to $380,000 in amortization expense and over a 2-year period.
Yes.
So the total balance, of course, then is, again, rounding up $750,000. So why did EKPC select a 2-year period to amortize?
Well, you have the situation that Dale was fully retired by 2019, and we're into 2021 for possible effective time. We've gone 2 years without any, beyond the final retirement. It didn't seem reasonable to stretch it out significantly longer. When Dale was initially retired early, it had approximately 3 years left anyway. And we just felt like, given the timing, 2 years was reasonable.
And there's a second Dale regulatory asset, this one for an asbestos ARO. See if I can cut through this one pretty quickly. Again, this was confirmed in case number 2014-432, and it was approved as the type of expense that resulted from an administrative directive.
It sounds familiar, yes.
this also has a 2-year amortization period. Is the reasoning for that 2-year period the same as for the Dale surcharge projects?
Essentially, it is the same because looking at the time periods, we're past, 2 years past the full retirement.
Next, I would like to go to the Spurlock maintenance regulatory asset. And on this one, again, I'm going to ask you to refer to PSC exhibits. First one is the Schedule 1.26 that you filed in the application. I will label that PSC Exhibit 5. We also have a letter from RUS that was filed as an exhibit to Ms. Carpenter's testimony. I will label that PSC Exhibit 6. And then finally, we have an order in PSC case number 2019-146, and I will label that PSC Exhibit 7. So,
I do have them. I'm sorry, I do have them.
No, okay, good. The first question I have about this particular request for recovery is EKPC requesting that the commission authorize the establishment of a regulatory asset for Spurlock 2019 maintenance and requesting recovery, or is it only requesting recovery?
I believe the best way to read this is that it was a request for recovery.
Because, would you agree that this particular regulatory asset has never been approved by the commission?
There has not been a formal request to create the reg asset. I would say that based on the commission's order in 2019-146, we were left with the impression that approach RUS. And we did.
Okay, we'll take this step by step through this.
Understand?
Well, let's go back and look at this as if you were KPC was making a request for a regulatory asset.
Okay.
Which one of those 4 categories would the Spurlock maintenance program come under at this point in time?
At this point in time. I'm just going back to the section of the order where that's laid out. I need to refresh my
Of the
memory on that.
2019, okay, please take your time.
I believe I would have to say that the closest would be more in line with the first option, but that it's not an exact match to it as it is written.
And is this because these are recurring maintenance expenses? Or the commission found that these were recurring maintenance expenses?
It's,
And I want to be clear, I'm not asking you for a legal
oh,
opinion.
I wouldn't dare to offer you a legal opinion.
I know your counsel would object.
I was just about to, Your Honor, but she saved me the trouble.
Were these expenses recurring maintenance expenses? due to the aging of the facilities.
The aging of the facilities would be requiring them, and as they're all getting older, it does become a little more difficult to figure out exactly how much to anticipate in a given year.
But, no, I won't ask that question. Can I have you turn to, it's your schedule, 126 and PSC Exhibit 5. The staff has looked through the case record of this case, and we cannot find any breakout of the balance, the $7.2 million balance that's for recovery is sought. To the best of your knowledge, is there a breakout of that filed in this case?
To the best of my knowledge, we may not have the detail may not be there. I don't think there was I don't think I have a supporting work paper on that, so I'm sure that's you probably would like that, so.
I was going to say, I feel like you're anticipating what I'm about to ask you for. As a post-hearing data request, could we have the supporting work papers, a schedule that breaks out this amount, the Spurlock 2019 maintenance expenses? And per our usual, we will request it in an Excel spreadsheet format. I want to make sure I'm not going over what we've already discussed. Can I have you refer to the order in 2019-146,
Okay.
PSC Exhibit 7? If I could have you turn to page 9.
I'm there.
Under the discussion, and I'm not going to make you read this, but you can read it along with me, that what the commission said there was based on the request to amortize the proposed regulatory assets without concurrent rate recovery, that EKPC does not request regulatory asset treatment for the purpose of future recovery of a current expense. Instead, as it discusses it down below, the proposal was to normalize expenses, which is typically done in a rate case for rate-making purposes.
I see that.
And the very last sentence on the page, it reads that nothing precludes EKPC from normalized maintenance including normalized maintenance expenses in either a historic or forecasted test year.
I see that.
And then turning to page 10, and this is the fourth line down from the top of the page. To the extent that EKPC would include regulatory asset amortization in its test year as a stand-in for normalized expenses, regulatory asset treatment would be all the more improper.
I see that.
And then down in the second paragraph, we said, while the commission may authorize regulatory asset treatment for the future recovery of current expenses, RUS is the more appropriate regulatory authority to petition for departures of standard accounting practices.
I see that.
And then down at page 11 in the conclusion, the commission found, based on the evidence of record, I'll move on, the commission found that EKPC's request to establish regulatory assets for present and future major maintenance expenses without the need to first, the way this was predicated with future expenses would not come before the commission for approval. But the commission denied EKPC's request.
I see that.
So is there a distinction here between the Spurlock regulatory asset that was approved by RUS and the normalization of 2019 maintenance expenses at Spurlock?
Could you repeat that, please?
Sure. I'm going to read it to make sure that I said, is there a distinction between the Spurlock regulatory asset approved by RUS and what the commission perceived as the normalization of, or the commission found was normalization of 2019 maintenance expenses at Spurlock?
I think I'm going to have to ask that that be deferred to Ms. Carpenter.
Okay. Can I also have you now turn to the RUS letter? It's PSC Exhibit 6.
I have it.
Looking at the second paragraph, and I'm just going to read aloud if you'll follow along with me. Starting with the second sentence in that second paragraph, it should be noted, however, that our approval is based upon the understanding that the Kentucky Public Service Commission authorizes the subsequent recovery of these costs. If the commission does not allow the recovery of these costs, the deferred amount must be written off immediately in its entirety. Be advised, however, that you must obtain RUS's approval prior to making any changes to the approved plan. So would you agree here that if the commission denies recovery of this particular asset, that EKPC would have to write off?
That's consistent with the RUS's instruction here.
Staff has nothing further. I would like to move that PSC Exhibits 1 through 7 be introduced into the case record.
Are there any objections?
No objection, Your Honor.
So ordered. 1 through 7,
1 through 7.
and you've already provided pre-identified ones to Ms.
Yes.
Candace. Thank you. And you've already moved for your East Kentucky number 1, that's correct? Vice Chair Covich?
No questions?
I don't have any questions.
I have a few, I'll try to run through them quickly. Mr. Scott, just brass tacks kind of questions here. Maybe easier for you to understand me. You passed on, I think, to Ms. Carpenter, the question of whether the expenses underlying that Smith 1, or that Spurlock regulatory asset and the expenses referenced in 2019-146 were the same, is that right?
On that question, yes.
Okay. But you would agree that in 2019-146, the commission did deny for at least those expenses that that East Kentucky was talking about in that case, regulatory asset approval?
Regulatory approval was not granted, yes.
Okay, and what is your understanding from reading the order? I mean, you've got a lot of experience here at the commission and now working with the commission from outside, that this order expressed that East Kentucky should do as it relates to RUS.
My understanding of the situation is that we took the suggestion of you need to approach RUS about this accounting treatment, and that was the direction we took.
Okay, so do you have the order with you there still? You mind to
Yes.
go to page 10 of it? Because I don't disagree that it seemed the commission did, at least say, insofar as you want to do this, you need to go see RUS. I think the question is what maybe the commission was saying, what relief it should seek at RUS, maybe the confusion. Because if you see on page 10, it discusses, do you see where it starts off, while the commission?
Yes, sir.
And I'll just read it for efficiency's sake, but tell me if you disagree with anything I say, if I mess up. While the commission may authorize regulatory asset treatment for the future recovery of current expenses, RUS is the more appropriate regulatory authority to petition for departures of standard accounting practices. EKPC essentially requests modified regulatory asset treatment to effectuate a departure from the requirements of 7 CFR Section 1767.16 J3 Romanet 3. Do you see that?
Yes, sir.
And to expense recurring but long-lived maintenance costs over multiple accounting periods. So does that sentence, in your opinion, describe deferral accounting or changing those accounting standards so that it doesn't have to expense those items, it can capitalize those items?
I think my read of it is more, probably a little bit more general of you needed to go talk to RUS about accounting, what the accounting requirements were. And should you get a deviation as provided in the USOA?
Right, but the commission denied regulatory asset treatment, is that right?
As proposed in this case, regulatory asset was not granted, correct?
And I know what you said, that you read this order as being general, but the commission was very specific as to the exact CFR and item that it says you all are seeking to effectively request modified treatment for, right?
What I meant by general was that the general direction was if you need some treatment change for a specific part of the USOA, you needed to talk to RUS. That's what I meant by being general.
That's fine, but that's not what East Kentucky got from RUS, right? It didn't get a deviation from accounting principles. You all just asked, as the letter indicates, and I'll go to it here, it's the second part of this, it's the letter to Mr. Campbell, that it says, in the very last sentence of the first paragraph, EKPC plans to establish a regulatory asset for $7,244,184 and recognize this amount over 8 years beginning in 2020.
That's what the letter says, yes.
So this letter doesn't approve changes in accounting treatment under their ability to change the USOA or the RUS accounting standards. It just granted regulatory asset approval. Is that fair?
Just note the same objection to the extent it's calling for a legal answer.
Yeah, I completely understand. It says to establish a regulatory asset. I guess that's what I'm asking. The letter just says that's what Mr. McNally's letter is seeking. Is that fair?
Note that it's hearsay. I mean, the application would speak for itself.
The letter says exactly what the letter says. I completely agree, but I can't just, the letter says regulatory asset. I can go and ask my question and say that the letter says regulatory asset. But I just want to make sure I understand, you've been doing this for a long time. A regulatory asset is not necessarily a deviation from standard accounting practices. It's a deferral of expenses so they're not recognized in a given year. Is that fair?
That would be fair.
Okay. And then my last question, and I'm going to ask it to Ms. Carpenter, but you would agree that the Schedule 126 that you provided and supported, that amount for the regulatory asset is the same as in Mr. McNally's letter, or the letter to Mr. Campbell regarding Mr. McNally's letter?
It is consistent. That's where the 8-year amortization came from.
Okay, all right, thank you very much. I want to go back a second about the capacity payments for a second, the conversation you were having with Ms. Vinsel. The 10-minute interruptible payment, do you interrupt, do you get paid on how much of the load is interrupted in that time period? Is that how much East Kentucky pays for that credit?
For any amount of time that an interruption is called for, we provide a credit to the customer for the amount of time interrupted. If it is an economic interruption, the customer does not necessarily have to actually shed the load. They can, what is called buy through, and go to the market, and whatever the market prices are what they are. There are some adjustments made in the billing so that there isn't a double billing for them going to market. If there is a physical interruption called for by PJM, the customer has to shed the load, and as long as those requirements are met, they get the credit for the period of time.
Yeah, and the credit is on a per KW basis, is that right?
Yes.
And how is that KW basis measured? Is it the amount of load shed, or does all the load shed, and it's just the entire, I don't know, past month's demand or the highest peak demand? How is that determined on a KW basis?
I'm not really the right one to ask of how it's measured, but it would be current, it is the current month. It's not looking at anything historic.
Okay. You're basically paying them instead of going out and getting replacement generation. You're paying somebody an amount to shed load instead of finding additional generation. Is that accurate?
That would be a simple view of it, yes.
Okay, and so you're effectively avoiding the cost of that additional generation. Is that correct?
We would be avoiding the cost of supplying, yes.
Great. And so what, should that credit be set then at the utilities avoided cost?
I'm going to fall back on some of my experience and say that avoided cost is not always the same thing across the board. There's different situations where the avoided can be something different. And traditionally, interruptible credits have not been set at, for example, even before we changed our QF tariffs to be PJM market-based, that avoided cost figure was not the same as the avoided cost utilized for interruptible credits. Rightly or wrongly, that's been my experience.
Right, and let's forget about
And
how
I'm
to
not,
calculate.
and I'm not saying that that's right or wrong, but that's been my
Yeah,
experience.
and I'm not even asking about how the avoided cost should be calculated, but would you agree that that's effectively what that credit is supposed to represent, is the utilities avoided cost?
At a broad sense, for what I'm qualified to say, it would be looking to avoid it. I think you'd have better luck getting a better answer from probably Mr. Cruz.
Okay, that's fine. And then the same question on your rebuttal, do you have a copy of your rebuttal with you?
Yes.
Do you mind to pull it open to, I think it's page 20 of your rebuttal testimony? Before I started talking, I should have made sure I had a copy of your rebuttal testimony in front of me.
I'm
I
there.
do, somewhere.
I've got a copy if you need one quickly.
Okay, I can pull it up. Thank you, Ms. Mansell. Page 20 of your rebuttal testimony, I think starting on line 18.
Yes, sir.
Okay. And then that section goes through page 21, line 2, is that right?
Yes, sir.
Okay. And as I'm scrolling quickly to get there, you discuss this credit there, and it says, and correct me if I'm wrong, it just says, in any event, I find it extraordinary that Mr. Barron should suggest that any interruptible demand credit should be equal to the firm demand charge. At no time does he assert that this is a fair, just, and reasonable rate situation. EKPC's rates are supposed to be designed for it to have a reasonable opportunity to recover its cost to serve its customers. It cannot be considered fair, just, or reasonable that a customer should have a significant portion of its load priced at a net rate of 0. And what I want to ask is, if you're paying them to shed their load, and you're paying them the avoided cost that it otherwise would have cost you to go out and get replacement generation to serve KPC's other load, what load is there that you're charging $0 for? Can I ask it a different way?
Yes,
If you-
please.
If you, and I'm the royal you, I don't think that's a real saying, but if East Kentucky interrupts a customer, they don't have load. Is that right?
if they are interrupted, if they are economically interrupted, there's still a load there that has to be provided somewhere. It's just not from our generation.
Right, but they buy that through, so
Yes.
you would agree that that's not, as you say, priced at a net rate of $0. It'd be priced at the market rate they buy through at, correct?
Yes.
But if they're otherwise interrupted, there is no load for any price to be added to, is that right?
If there's a physical interruption, that part of the load does not exist.
Okay, all right, that's fair. So, I think that you also discuss, on page 7, if you don't mind to turn there. The normalization of capacity benefits revenues. You see that at the bottom, starting on line 16, page 7 of your rebuttal testimony?
Yes.
Okay, and I think you take issue with Mr. Collins' proposal on that, in this section, and that ultimately was nothing regarding the normalization of those capacity benefit revenues was included in the stipulation. Is that your understanding?
Okay. When you're speaking of the settlement, for the stipulation settlement for this rate case,
That's correct.
to my understanding, there is no adjustment for the capacity benefit in there.
Okay. And when I say you take issue, you specifically, I think you say on line 21 that you believe his adjustment violates the matching principle. Is that
Yes.
right? Okay. And you do spend some time in your testimony talking about your perspective on the matching principle, but you said earlier in the testimony something like the matching principle requires that expenses, revenues, and rate base amounts all have to be in some sort of corresponding time period. Or if you're going to pull the expenses here, then you need to at least reflect some revenues from that, from corresponding revenues from that time period. Is that accurate, or is that in the neighborhood?
The matching principle does try to keep all the components on the same period, but does allow for known, in a historic test year, does allow for known and measurable adjustments that might, you can have known and measurable that will go a period beyond for example, a test year without violating the matching principle, as long as you don't go too far out.
Okay. And you could even go too far out as long as what you say here in your testimony on page 2, starting at line 5, you say that the primary rate-making principle is known as the matching principle, where adjustments to the test year are not made unless all revenues, expenses, rate base, and capital items have been adjusted to reflect the same time periods.
Yes.
Okay, so if you have an individual expense, are you saying that if there are individual revenues, an individual expense beyond the test year, that those corresponding revenues, if you're going to make the adjustment for the expense, you should make the adjustment for the revenues? Is that what you're saying?
If there are revenues associated with that same expense, you generally would need to pick them both up.
Okay, and that's fair. My curiosity is, you said that on page 7, that the normalization of the capacity benefit revenues violates the matching principle, but you didn't say why it violates the matching principle. And so I'm just curious, those are revenues, is my understanding. So what corresponding expenses, rate base, or capital does that have that you believe should have been included if you normalized that revenues like you proposed?
Unfortunately, I was repeating the same explanation as for some other parts, so I didn't respell it out completely. My objection here was going out all the way to December 31, 2020.
Right, but that's only part of it. Going out is one thing. We said you could go out as long as you included the corresponding expenses, revenues, rate base, or, capital items.
In conjunction with a 6-month window. From my perspective, and looking at past practice, 12 months is too far out.
Okay, so just
And
let
there's
me,
not a corresponding expense item to offset against this.
okay, and that's why I want to make sure that the 6 month is a limitation that you added from your experience. But in terms of actually matching those 4 items, revenues, expenses, rate base, and capital items, there wouldn't necessarily be anything that needs to match to a normalized capacity revenues benefit. Is that fair?
There wouldn't necessarily be, right, some of these, sometimes the known measurables do not have a corresponding. You can pick them up, but the problem is you can't go too far out without throwing the balance out of whack.
Okay. And then my last question is the depreciation. The depreciation expense that the company is proposing in this case, is based on the depreciation rates in Mr. Spanos's proposed depreciation study. Is that correct?
Yes,
And does the company anticipate that if the commission approves this stipulation or approves the depreciation study proposed by the company, that it will actually use those depreciation rates for book depreciation and not depreciation rates based off anticipated service lives?
we will use the rates in the study.
Mr. Sanford, I don't have any additional questions. Do you have any redirect?
I don't believe I do. Well, let me just ask one real quick. This goes back, Mr. Scott, to the questions I think you were asked towards the beginning of your cross-examination by Ms. Nensel. She asked you about the generation maintenance expense, the tracking mechanism, or the mechanism that's in the stipulation. You recall that? The maintenance expense provision from the stipulation.
I'm not recalling, but I can go ahead and, let me go ahead and try and answer.
Okay. I believe that she had asked you if, well, let me back up. The maintenance expense mechanism that's in the stipulation, it in essence functions as a tracker in between base rate cases. Is that correct?
The reg asset side of it, definitely, the reg asset reg liability definitely functions as a tracking.
Okay. And so the use of a regulatory asset or a regulatory liability is the means to effectuate that?
Yes,
Okay. And one of the criteria for approving a regulatory asset would be an administrative directive, correct?
yes,
And so the commission obviously is an administrative agency.
yes.
So if the commission were to approve the maintenance expense tracking mechanism, that would satisfy the regulatory asset criteria to be approved by an administrative agency, correct? Or an administrative directive, I think.
As I understand it, yes.
Okay. Thank you, Your Honor.
Any additional questions, Ms. Vincel?
Can I just get one clarification? I think it sounds like we have a post-hearing data request that needs to be withdrawn because the witness answered the question. If he agrees that he answers it in full.
I'm sorry I lost you.
Earlier when we were talking, I had said we would issue a post-hearing data request asking which of those expense categories would apply to the generation maintenance. And I understand.
I understand, yes.
Administrative directive.
Yes.
But I have one to replace it with. A post-hearing data request, staff would like EKPC to provide a copy of Mr. McNally's January 22nd, 2020 letter to RUS that is referenced in the letter from RUS.
Understand, yes.
Cleared up one, you got another. It's the no good deed goes unpunished. Anything else, Ms. Vincel?
Nothing further.
Mr. Matthews? All right, we will take a recess. We'll take a recess until 12:40. We'll take a recess to 1:30, try to get back a little bit on schedule. Yeah, 1:30 prompt.
Thank you.
Record in case number 2021-00103. Before we take before I ask Ms. Honaker to introduce her next witness, Mr. Kurtz, you had something you'd like to bring up?
Thank you, Your Honor. At the lunch break, I learned that neither the bench nor staff have any questions for new core witness Barry Kornstein. So I asked that we be authorized to stipulate his testimony into the record and that Mr. Kornstein be excused from appearing.
And does EKPC have any objection? No. How about the Attorney General's office?
No objection.
Mr. Gardner?
No, Your Honor.
And Ms. Vincel, does staff have any questions for Mr. Kornstein?
No, we have no questions for him.
Okay. Happy to do that as to his testimony, and he can be excused from the hearing.
Thank you, Chairman.
Any other routine matters to take care of? Okay. Ms. Honaker, would you like to call your next witness?
We'll call Michelle Carpenter.
Ms. Carpenter, if you please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Okay, please have a seat. State your name and address for the record, please.
Michelle Carpenter, business address is 4775 Lexington Road, Winchester, Kentucky.
Okay. And can I ask if the AV, can we turn that microphone up? We've had problems where we thought we were doing something great by putting enclosing the witness box last year, and then it's just that much harder to hear everybody. So could you try that again, please, with your name and address?
Michelle Carpenter, business address 4775 Lexington Road, Winchester, Kentucky.
All right. Thank you, Ms. Carpenter. You may just have to speak up some. Ms. Honaker, you may ask.
Ms. Carpenter, did you cause testimony and responses to data requests to be filed in this case?
I did.
Do you have any corrections or additions that you wish to make to any of those?
No, I don't.
If I were to ask you those same questions today, would your answers be the same?
They would.
And could you tell us what you have in front of you, what you've brought to the stand with you?
I have a copy of my testimony and the data request I sponsored.
Okay. And is it your desire and intent to incorporate your testimony and data request responses into the record of this proceeding?
Yes, it is.
Witnesses available for cross.
Thank you, Ms. Honaker. Mr. Kurtz? Mr.
No
West?
questions.
No questions.
Mr. Gardner? Ms. Vincel, do you have any questions for Ms. Carpenter?
I've got just a few questions for her. Good afternoon, Ms. Carpenter.
Good afternoon.
Most of my questions you've been answered, with the exception of the few that the witnesses passed to you. So let's start with the OPEB. So staff noticed that in 2019, the OPEB was 3.2 million approximately, and that it was reduced in 2020 to 1.058 million. No, I was going to say, I see you're flipping. I wanted to make sure I waited until you were at a page you needed to be at.
I'm there.
So, as we'd asked earlier, is the majority of this reduction and the cost, OPEB cost from 2019 to 2020, attributed to a change from Medicare Advantage to a self-funded plan?
It was a big part of it. We have a number of prior service cost adjustments that are going through there that total over a credit of $2 million, as opposed to $751,000 the year before. And that was provided in AG New Core Request 57. So, other components also changed, but prior service cost was probably the largest.
I'm sorry, I only caught AG and 57. Can you tell me which request that was, the first request?
I think it was the first request.
So AG 157. So would it be fair to say that if the 2020 amount, the lower amount, more accurately reflects going forward, that if EKPC was allowed to use in the test year, the $3.2 million as the basis for OPEB, would it be fair to say that EKPC would over-recover on OPEB in rates?
Not necessarily. Net periodic is made up of different components. And so there's a service cost and interest component as well. And those vary from year to year based upon plan experience, demographics, several different assumptions. So those ebb and flow. And so the adjustment that was proposed was related to what was specifically known to be a reduction. And the prior service costs, those are being amortized over several years, I think between 11 and 13 years. So those are known changes that we know will be going forward for the next 13 years. And so since the others ebb and flow from year to year, we couldn't definitively say that they would remain at the levels that are shown in 2020.
We'll probably come back to OPEB here just to give you a sense.
Okay.
I had asked Mr. Scott about the Spurlock 2019 maintenance regulatory asset. And my question was predicated on the distinction in the order that the commission issued in the 2019 case. So, and I know that he deferred to you on this. Is there a distinction between the Spurlock regulatory asset approved by RUS and a normalization of the 2019 maintenance expenses?
Can you repeat that question again?
Is there a difference between treating these treating the Spurlock 2019 maintenance expenses as a regulatory asset as opposed to normalizing the expenses in the test year?
We went in for specific recovery of 5 projects at Spurlock, and those were ones that met the criteria of being major maintenance or non-major items that weren't expected to have to be replaced. So those were specific instances that we asked for recovery there. Normalization now, we've already gotten those deferred, and so we have a separate mechanism. We've requested amortization of that regulatory asset. So I'm not sure exactly what you're wanting there, if you need to redirect the question.
I appreciate that. This is what I'm trying to get to, is to make sure that I'm understanding correctly. Because the commission in the 2019 order discussed going to RUS basically to capitalize these costs rather than we denied a regulatory asset. And instead, EKPC obtained a regulatory asset approval from RUS, but has not obtained one from the commission. And for our purposes, we wanted to make sure that the distinction between a normalized expense and treatment of this as a reg asset, if EKPC could point to any particular distinction. Does that help?
I think I would like to make the point that whenever we went to RUS, we were under the impression that we were being referred to RUS to get that treatment. The sections of 1767 that were referred to in page 10 pointed to plant additions and retirements, which also talked about non-major components that were retired outside of the depreciable plant that was on the books, and those items are typically expensed. And so we followed that in 1767-13, I believe it is, that RUS has a process for getting deferral of expenses. So in good faith, East Kentucky did go to RUS to get specific approval. And those were specific projects, whereas in our application to the Public Service Commission, we were asking for broader authority. We were asking for not only current but future projects that met certain criteria. And, with RUS, we did go just for specific projects.
So turning back to the OPEB, would an average amount, or computing an average, more accurately capture the ebbs and flows in OPEB? For example, using a 5-year average?
I haven't looked at that to know how that would play out.
Just to the best that you can say, are you aware of what the ebbs and flows look like for the OPEB?
When you talk about the net periodic benefit expense, it can change dramatically when there is a prior service cost adjustment, a plan amendment, or different things, features of the plan that can change from year to year. So it can ebb and flow based upon those things, and that's a going forward type of thing. So I don't know that necessarily looking backwards is the way to get the right number for an average.
That is all the questions staff has for Ms. Carpenter.
Ms. Tubbs?
Are you familiar with paragraph 5 of the settlement agreement or stipulation that was entered into? It's the,
Not
the 75% allocation of regulatory asset and liability. How did the parties come up with 75% versus eating the 25%? How did that work?
That was part of the negotiation process, and I wasn't involved in that.
Okay. It's the only question I have.
Ms. Carpenter, I have a couple of questions on this regulatory asset for the Spurlock major maintenance expense. But before I get to the actual regulatory asset, let me ask about the normalization of expenses in this case. In any part of the application, is East Kentucky proposing to normalize those expenses in the test year?
Can you repeat the question, please?
It's like the type of expenses, let's even be more general. The type of expenses underlying the same type of expenses that are related to the 2019 Spurlock Major Maintenance and Minor Items of Property account. Is East Kentucky proposing to normalize those expenses moving forward in this case?
I think the base average that was used in the stipulation agreement was with those projects removed. In other words, they went with our GAAP maintenance expenses and doing that 5-year average. So they're not part of that base. So is that what you're asking?
I think it is. I guess what I'm asking is, taking a couple of steps back, are you familiar with the application that East Kentucky made in 2019 regarding the major maintenance expenses here at the commission?
Yes, I'm familiar.
Okay. So the problem, insofar as there was a problem, is that it was a significant amount of expenses that were going to be recognized in 2019. And the company would have preferred, all things being equal, that they not be expensed, but that they effectively be, whether it's through some measure, effectively be capitalized. Is that your understanding?
We were wanting to defer them to expense in later years, yes.
And the proposal was actually to go ahead and do a reg asset and then immediately start deferring upon each year upon the creation of those regulatory assets as if they were being capitalized over a 7 or 8 year life. Is that right?
That was part of the original request.
Okay. And so, just so we're clear, it was effectively to use regulatory accounting under ASC 980 to defer them in any given year and then immediately start amortizing them, for all intents and purposes, identically to the way they would have been treated if they were capitalized costs. Is that right?
Sounds right.
Okay. And the commission order talks about, I don't know if you're aware or have it in front of you, talks about doing something like this or normalizing those type of expenses in a base rate case. Are you aware of that?
I'm aware.
And so what I'm asking is, did the company or did East Kentucky propose to do that, to normalize those expenses in this case?
Not initially, no.
Okay. And is that normalized in the stipulation?
It's part of the maintenance component that's in the stipulation.
Okay, so the accounts, now I'll find my copy here of the stipulation, sorry. The, paragraph 5, page 3 of the stipulation, generation maintenance regulatory asset liability. The parties agree that the normalized generation maintenance expense reflected in Exhibit A is $81.067 million per year. You're saying that that 81.067 includes the accounts that were referenced as major expense items in the application in 2019-146.
The application that was made in 2019 did not specify particular projects. So it was more of a concept, whereas what we went to RUS with was specific projects. When we received approval from RUS for regulatory asset treatment, that $7.2 million effectively was removed from expense and formed a regulatory asset at the end of 2019. So that lesser expense number is what was used in the calculation to arrive at the 81.067. It's in the stipulation agreement.
So we know that the $81 million number, is that that's a 5-year average or 4-year average, something like that, is that right?
I believe so.
Okay. So but it's a normalized amount, it's not a single,
Right,
it's not a 2019 number, for instance, right?
right.
So at least for 15, 16, 17, and 18, if 15 through 19, it's my understanding, 15 through 19 are the years used to normalize it, they would have included those types of categories of expenses, because they weren't, there was no accounting, there were no reg assets for those years for those type of expenses, correct?
Correct.
Okay. So, moving forward, as a general matter, those expenses are normalized, right?
Per the stipulation agreement, yes.
Okay. So the proposal is that they're normalized, and then there's a tracking above and below the normalized amount, and that's the 75-25, right?
Correct.
Okay. And I think you said earlier, it's, what RUS approved was deferral accounting. Is that right?
Correct.
Okay. Is it your understanding or experience that RUS has, as the order sort of alludes to, as the 2019-146, has established procedures to request departures from accounting methods or principles?
Repeat that.
In your experience or in your understanding, are you aware of whether or not RUS has established procedures to request departures from accounting methods or principles?
Yes.
Okay. And would you agree that regulatory treatment, reg assets or reg liabilities are not necessarily departures from accounting methods or principles? They're in accordance with accounting methods and principles. They're explicitly allowed by the ASC.
They are allowed by ASC 980. However, from RUS perspective, they, in 1767, I want to say it's .13, they say particular types of transactions that require approval, and regulatory asset treatment is one of them. So that's the process that we went through. So they do have a prescribed method for that.
Okay. For requesting from RUS approval for a reg asset?
Yes.
Okay. But can RUS also allow the utility, allow East Kentucky to treat those major maintenance expenses as capital costs instead of expenses?
RUS doesn't prescribe the level of granularity that utilities capitalize their assets. They do say that once you've made the determination of what you're calling an asset, you've identified your retirement units, then things that aren't in those retirement units are considered expensed when replaced. So they leave it to each utility to make that distinction.
And East Kentucky years ago, because of the level of its accounting, the granularity, chose to describe those or characterize those as being expenses rather than capital items. Is that fair?
Right. In other words, we capitalized at a higher level, which means they were larger assets. And so if a small part of that asset is replaced in the interim, that small part is expensed because the larger asset is still in service.
And if you wanted to change that now, you all, East Kentucky, would have to get explicit approval from RUS to do so. Is that correct?
I don't know that we would have to have explicit approval from RUS to do so, but it's a major undertaking to try to go back and revalue vintage assets. We've been looking at that currently, and it's a rather large project.
Okay. Just to be clear, and Mr. Scott just had requested that you clarify this instead of it falling on his shoulders, but the 7.244184 in his schedule 1.26, that's the same amount as referenced in, that you're understanding, it's the same amount that's referenced in the letter to Mr. Campbell from RUS, is that right?
Yes, it is.
Okay. And then earlier you were talking about going to, just so that the record's clear, going to RUS, and I think the quote I have is to get that treatment. That, you took the commission's direction, go to RUS to get that treatment. Is it your understanding that that treatment, when you were referring to that treatment, you meant deferral accounting?
Right.
And if I have questions about retained equity, is Tom Stacknick still the person to ask, or should I also ask you first, just so that we don't have to call you back if he says, Ms. Carpenter was the person to ask about that?
In what regard?
Well, so the question I asked Ms. Bridges and Mr. Campbell, which is, are you aware of any of the loan covenants or the indenture or anything like that that requires that a portion of each year's net margins or tier be included in a retained equity or added as a matter of some percentage of that net margins or net MFR or tier be included in retained equity or classified as equity?
Anything related to our debt covenants, I would defer to Tom Statnick on.
Okay. Thought I had one more note for a question for you, Ms. Carpenter, but I may have lost it, so you may get lucky. Yeah, I've lost it, so thank you very much. Ms. Honaker, do you have any redirect?
I don't have any.
Anything else, Ms. Vincent?
We do have staff has a post-hearing data request.
Okay.
We would like to request a schedule with the last 5 calendar years, totals for OPEB.
Fair enough.
And staff has nothing further.
Commissioner Matthews? Vice Chair? Nothing else? Okay. All right, Ms. Carpenter, you may sit down.
Thanks.
Ms. Honaker, do you have another witness?
John Spanos?
Mr. Spanos, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please have a seat. State your name and address for the record.
John J. Spanos, 207 Senate Avenue, Camp Hill, Pennsylvania, 17011.
Ms. Honaker, you may ask.
Mr. Spanos, did you cause to have direct testimony, rebuttal testimony, and responses to data requests filed in this proceeding?
Yes, I did.
Do you have any additions or corrections to make to any of those documents?
No, I do not.
If I were to ask you those same questions today, would your answers be the same?
Yes, they would.
And do you wish to incorporate the direct testimony, rebuttal testimony, and your responses into the record of this proceeding?
Yes, I do.
And did you bring any materials up with you? If you did, can you kind of tell us what those are?
I brought my depreciation study and my direct testimony and rebuttal testimony with me.
Okay. Witness is ready for cross.
Thank you, Mr. Kurtz. Mr. West?
No questions for the Attorney General.
No questions, Your Honor.
Mr. Gardner? Ms. Vincil, any questions for Mr. Spanos?
Yes, just a few. Good afternoon, Mr. Spanos.
Good afternoon.
I'd like to follow up on one of the questions that I asked Mr. Scott. And this is in regard to using the depreciation rates in the 2006 study versus the later use of service lives in depreciation. So was the test year, I just want to confirm this, that the test year actual depreciation expense was calculated using the service lives that had been used by EKPC subsequent, I'm not sure exactly what date it started, but not the depreciation rates in the 2006 study, but the service lives that EKPC has been using. And I turned that into a compound question, so let me make it simpler.
Okay.
In the test year, in the actual depreciation expense, did EKPC use the service lives of its assets?
And are you asking of the 2019 time period or the 2006 time period?
In the 2019 time period.
It's my understanding that they utilize the information from the depreciation study, which is a component, has a component of an end-of-life asset or probable retirement date and an interim survivor curve, which has a service life. So it's a combination of both. So it's just, I think that's a little bit of clarity to make with how the depreciation study is put together. It combines an interim survivor curve and an end-of-life component to develop a depreciation rate.
And we are referring to the 2019 depreciation study that you prepared, correct?
Yes.
So I just want to make sure that I'm understanding, the actual expenses and then the pro forma adjustment. Whether or not the actual expenses use let me back up. The pro forma adjustment used the 2019 depreciation study, as you said, the end of life and the interim curve.
I believe that's how it's put together. And also, just to be clear again, that the rate also has a net salvage component built in as well. But that is how it's developed. All three of those parameters help you develop a rate, and that was used in the calculation.
You may not be able to answer this, but I will ask you, do you know which of EKPC's witnesses could answer whether EKPC used the service lives in the test year actual expenses, not the pro forma, but the actual expenses?
I'm not sure, and I'm not sure who you would ask, sorry.
I'll just keep asking
Yeah.
it then. Okay, one moment, please. Staff has nothing further.
Thank you.
Vice Chair?
Could you explain to me the concept in your rebuttal testimony of intergenerational equity?
Sure. The concept is that the utilization of the assets and the recovery of those assets should be taken, they should match. And generations of customers should pay for the benefit of using those assets. So the concept that I'm talking about in my rebuttal testimony is the fact that the full service value of an asset includes not only the original cost of that asset, but the cost of removal and gross salvage component, which those two components happen at the end of life. So you must recover through the entire life cycle of those assets, all of those costs, and the customers that receive benefit of those assets are the ones that should be paying for those assets, not having, as proposed by Mr. Collin, where you defer those costs till after the asset goes out of service. So ratepayers that would be in service after the asset is gone would be paying for those components, and that's considered an intergenerational inequity. So the intergenerational equity component is to include all those costs, recover it while the asset is in service, and the ratepayers would take on those costs while that they receive the benefit of those costs. And that's the idea that's being discussed in my testimony.
No further questions.
Commissioner Matthews?
I don't have any.
Mr. Spanos, I have a couple on that item. Do you do much depreciation work for competitive firms as opposed to rate-regulated firms?
Primarily, it's rate-regulated firms. I would say that's the majority of my work across the country. I do, I wouldn't necessarily say I testify for many others, but I do additional work for them. So depending on what your questions are, I can.
Yeah, I'm just curious because, your conversation about intergenerational inequity or equity, it seems to be more related to the recovery of cost through rates, because you talk about the impact on ratepayers, right? But in economic, in competitive firms, you don't have a defined customer base ordinarily, right? You may have a gas station in which a person may never go to the same gas station twice, right? There's not a defined person that you're sharing cost amongst that needs to be equitably distributed. Is that fair?
No, that's correct. And it does vary the methods that you do the work when you're doing work for competitive firms, because of the matching principle is still in effect, but it's not nearly as fine-tuned based on uniform system of accounts and the process. So that's kind of a slight difference in how I would perform a study for them or consult with them versus how I would do a regulated utility.
And so you talk about intergenerational inequity or equity as it relates to depreciation generally, but that's really a rate-regulated phenomena, right?
Again, primarily, I think competitive companies still are trying to match their costs to their expenses, or their expenses to their utilization of the asset. So there is that concept still in place, but they're not bound by it like a regulated utility would be, or directed by, or it's a guideline for.
That's what I was going to ask. I was unaware that there was a USOA jail we'd go to if we weren't bound to it. So
sorry. Yes.
Okay, I appreciate that. And I just to Ms. Vincel's question, and I think you answered this, but I want to make sure, because we're going to eventually be back at some of the first people until we get an answer on it. You proposed the depreciation rates. You calculated the depreciation rates that are proposed. Take a step back. You calculated the depreciation rates that are applied to the investments, to the rate base, to make the depreciation expense in this case. Is that right?
That's correct.
Okay. So the company proposed, and I believe the stipulation includes the depreciation expense based off your rates in the 2019 study, correct?
That's correct.
There was a pro forma adjustment, as I understand it, in the test year to reflect that change in rates. Is that your understanding?
That's
in depreciation rates, excuse me.
That's my understanding, yes.
Okay. Are you aware of, so we've got the pro forma adjustment, which we've got what the rates are proposed to be as a result of the pro forma adjustment, but that adjustment is to a test year depreciation amount. depreciation expense amount. Are you aware of whether that test year depreciation amount is the calculation of depreciation expense based off the depreciation rates from the study in 2006, or the service life conversation that I had this morning with Mr. Scott?
I'm not positive of that answer. I haven't looked that closely. My focus is getting the depreciation study completed. I believe all of those information was based on the concepts that were part of the 2019 depreciation study, but that's my comfort level. I haven't looked specifically at those numbers.
Okay, and you deal with folks at the company, right? You deal with folks at EKBC. I know, and while I remember, I don't know, I know you've had some interaction with Ms. Carpenter, I think, over time in
Yes.
order to create your study. Based off your experience, do you know who you would think at East Kentucky would know that answer?
My closest contact is Ms. Carpenter. So, I don't want to say she's the one that would have that answer, but the majority of the interaction I have and the development of those rates would probably be either her or Ms. Bridges. Those are the two that I've kind of dealt with the most related to depreciation topics.
Okay.
And I know that they've both already testified, but
No, I appreciate that, Mr. Spanos. Thank you. You're the depreciation person. I'm still waiting for your competitor to someday file testimony. I think you may be the only one. So I appreciate it. Ms. Honaker, do you have any redirect?
I do not.
Okay. Anything else, Ms. Wenzel?
I have nothing further.
Okay. Can Mr. Spanos be,
Excused?
I was going to say let go, but excused, yes, that'd be great.
I prefer that he be excused.
All right. You can be excused and step down, Mr. Spanos. And is Mr. Sanford calling the next witness? So while we're changing over here, Mr. Sanford, since I think Mr. Spanos may have called it, I think we've exhausted our witnesses who we originally thought might be able to answer the one question that we keep asking. And so I know we'll be taking at least one more break today and coming back tomorrow, of course, for a couple of the other witnesses. And I would just ask if maybe first thing tomorrow morning, if you all could huddle up ahead of that to see if there's somebody who can speak to the question we keep asking and make them available tomorrow, we'd really appreciate it.
Sure.
Thank you. And you, at your pleasure, call your next witness.
Sure, you'd like to call Mr. Tom Stashnick, Your Honor.
Please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Thomas J. Stacknick, business address is 4775 Lexington Road, Winchester, Kentucky.
Thank you. Mr. Sanford, you may ask.
Thank you, Your Honor. Mr. Stashnick, did you cause certain testimony and responses to data request, and I think even rebuttal testimony to be filed in the record of this proceeding?
Yes, I did.
Do you have any corrections, additions, changes, edits to that testimony or responses to data requests?
No, I don't.
If I were to ask you the same questions today, would your answers be the same?
Yes, yes, they would.
Is it your desire and intent to have that testimony in response to data request incorporated in the record of this hearing?
Yes, it is.
And did you bring any materials with you to the witness stand today?
Yes, I brought my testimony and rebuttal testimony and data request answers, as well as a couple of excerpts from Ms. Bridges and Mr. Scott's testimony.
Thank you, Your Honor. Tender the witness for cross-examination.
Thank you, Mr. Sanford. Mr. West, any questions?
No questions.
Mr. Kurtz?
No questions, Your Honor.
Mr. Gardner? Thank you. Ms. Vinsel, do you have any questions?
Yes, just a few questions. Good afternoon.
Good afternoon.
The first question I would like to ask is about the short-term investments and the number of days of operating expenses in cash.
Yes.
So, this is the scenario. If EKPC sold all of its short-term investments, what would the impact be on EKPC's total number of days operating expenses held in cash?
Then it would be limited to just what we have in general funds, which generally runs anywhere from $15 to $30 million, which would be 10 to 15 days of cash.
So, in comparison to the amount of interest expense savings that would occur, would the impact of selling all of the short-term investments be significant to EKPC's day-to-day operations?
Yeah, one of the main things we go by is Fitch Ratings, who suggests that we have a minimum of 30 days operating cash on hand in very liquid investments. So we would immediately drop below that, which Fitch would find to be very risky.
So the Attorney General and new course witness, Lane Collin, suggested or stated that EKPC is losing money on short-term investments.
Yeah.
What would you say? Is EKPC losing money on short-term investments?
There is a cost to keeping the short-term investments. There's about a 1% spread between what we can borrow in our credit facility and what we earn on those investments. So if we were to sell them, there would be a little bit of an effect on margin.
Staff has nothing further.
Vice Chair?
No questions?
No question.
Mr. Stacknick, you ready to talk about retained equity?
Oh, sure. I thought that question might come up.
Is East Kentucky under any obligations, once it earns a specific tier, MFIR, or net margins, that it retain a portion of that as member equity?
Yeah, the indenture provides that we can pay capital credits as long as after the payment of such capital credit, we maintain 20% in debt to total capital. So we wouldn't be able to distribute more to members, then would bring that down to 20%. So as long as we're over 20% debt to total capital, there would be no restriction.
Okay, and so taking a step back, though, that's overall equity. Is there, I'm just gonna make up numbers for sake of simplicity. Say you earn a 1.6 tier, in a given year, right? And your MFR, let's just say tier and MFR are the same. You earn a 1.6 tier, which is a 1.6 MFR. Your indenture requires, or your debt covenant requires a 1.1 MFR, right? And your net margins are, again, making up a number, $50 million. So none of your covenants, none of your indentures, you're under no legal obligation to take a portion of that and retain it as just a portion of that year and put it into your overall equity amount.
Just to the degree that would be necessary to maintain that 20%.
Okay, and so is it, I guess this is going to sound silly, do you have to put, is it automatically 20% every year you have to add to it, or do you have to keep an overall 20% amount?
After any payment of distributions, we need to remain at that 20%. We cannot make a distribution such that it would bring our equity to capital below 20%.
Okay, so it's not a maintain, it's a maintain 20%, not a, here's what I'm really asking. If you had a formula rate, just making things up, if you had a formula rate, and every year you were guaranteed to earn a 1.1 MFR, right? You could never go below a 1.1. And you pass back to customers everything net of 1.1. You're saying that all you would have to do with whatever that net margin is, whatever that additional over the 1.1 MFR, you wouldn't even necessarily need to give in year have to put anything into retained equity, as long as that retained equity account, after you paid capital credits, maintains a 20%. You could technically just pass that money back to customers or use it to write down a regulatory asset?
As far as our covenants are concerned, that would be correct. I'd have to do more analysis to figure out how that would affect our overall ratings and our rating agency's view of our credit. If they saw that we were returning that much capital and not keeping it in the business, that might affect our ratings in other
And
ways.
just to be, I'll be very clear on why I'm asking, because I don't want to scare anybody. What I'm trying to
Yeah.
ask is going back to this original question. I've had to go to the extreme to sort of ask it to get
Yeah.
clear. Going back to this original question about the $6 million, we think we can find savings, but we want to set our rates on a 1.5 insofar as we actually have a tier in excess of 1.4, we're going to pass that entire amount back, right? So assume the company actually finds $6 million in savings, right? And that's going to be $6 million, let's just make it up, $6 million in excess of a 1.4. And so that $6 million, that hypothetically, would be passed back to customers through this earnings mechanism in the stipulation. Does that make sense to now?
That's my understanding, yes.
What I'm trying to find out is that actually going to be $6 million that's passed back to customers? Or does a portion of it have to be retained according to some sort of obligation or indenture or debt covenant that the utility is under?
I would say no, that whatever amount above the 1.4 tier is earned can completely be passed back to the customers.
Okay, there's not a portion of it that has to be retained or anything, just net of 1.4, whatever that cash amount is, can be passed back through this earnings mechanism.
Yes,
Okay, as long as in any year that you pay a capital credit, you maintain a 20% equity level.
yes.
Okay, thank you very much. All right, that's all the questions I have, Mr. Sanford. Do you have any more?
I don't think so. Let me just make maybe one question, because I think we're saying the same thing, but let me make sure. The 20% equity, that applies to distributions, correct?
Yes, we cannot make any distributions. Not sure if it actually says capital distributions.
Okay, but the
But
only.
if we were to earn a 1.4 tier and our equity is over 20% going into the year, our equity would only go up from there.
Yeah, so the only form of distribution a co-op can make is through through capital credit retirement, correct?
Yes.
Okay.
Now, you've got me curious, but this earnings mechanism is separate from what you're discussing.
Yes.
Yeah.
But not to testify, Your Honor, but I'm just trying to make the point.
That wasn't the point of your question, is
It's
what I'm
not,
doing.
the earnings mechanism isn't a distribution. Right.
Mr. So let me ask Mr.
I would say, yeah, it's a return of that year's earnings.
Mr.
so.
Stacknick, let me ask, is this pass back through the earnings mechanism in excess of 1.4? That's not a distribution that requires that 20% equity amount under the debt covenant?
I do not think it would be.
Okay.
Yeah.
And just so that the record's clear, the 20% equity amount, where are you right now on an equity percentage?
I'm more familiar with equity to assets, which is 21.2%. So equity to total capital would be a bit higher than that.
But would you say over the last couple of years, would you say East Kentucky has fairly recently met that 20% threshold?
Yeah, 2 years ago, I believe, was the first time we met that threshold, and we paid a small capital credit, and we also paid a small capital credit this year because we were over that threshold.
Okay, all right, thank you very much, Mr. Stackney.
No
Any more
questions.
redirects?
No.
Yeah. Any more? Any questions? Ms. Vincel, any questions?
No more questions.
Mr. Matthews, Vice Chair? Okay, thank you very much, Mr. Stackney. Can you be excused?
Yes, he can be excused.
Thank you very much. Thanks. We'll take a second. Ms. Honaker, whenever at your pleasure, call your next witness.
Rich Mackey.
Mr. Mackey, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please, thank you. Please be seated. State your name and address for the record.
Richard J. Mackey,
with Power System Engineering. My work address is 10710 Town Square Drive in Minneapolis, Minnesota.
Okay. Ms. Honaker, you may ask.
Mr. Mackey, did you cause direct testimony, rebuttal testimony, and responses to data requests to be filed in the record of this proceeding?
Yes, I did.
Do you have any additions or corrections to make to any of those documents?
No, I do not.
If I were to ask you those same questions today, would your responses be the same?
Yes,
And is it your desire and intent to incorporate those items into the record of this proceeding?
yes.
And if you brought materials with you, can you tell us what you brought to the stand with you?
I did not bring anything with me, but I understand that East Kentucky's filed cases in front of me.
Okay. Witness is ready for cross-examination.
Thank you, Ms. Honaker. Mr. West?
No questions.
Mr. Kurtz?
No questions, Your Honor.
Mr. Gardner? Ms. Wenzel?
A few questions, but it's really post-hearing data requests. I'm going to start with the easier ones. We would like to get a copy of the rebuttal testimony exhibit RJM4 and RJM5 with the supporting calculations in Excel spreadsheet format.
Certainly.
And staff would also like to get a spreadsheet that depicts the allocation of the proposed settlement increase to the 16 members in Excel spreadsheet format. However, staff will provide EKPC with a spreadsheet that we would ask be used for this response.
Okay.
So just to let you know logistics, and this is more for your counsel, what will go into the case record will be a PDF of this, but we will separately provide the Excel file for you. And I need to consult with my coworkers one moment. I have one question for you. The settlement revenue allocation rate design diverts from the cost of service, the revised one. Could you explain why it diverts or why it doesn't line up and what changes were made?
So you're asking, just to make sure I'm clear on why the settlement rate design does not follow directly the cost of service study that I filed with my rebuttal?
Yes.
Okay. Yeah, the settlement rate design attempts to, but there was some agreements in coming to the settlement agreement that put some bounds on that. So there was some increases that were assigned to rates B and C that were not identified in the cost of service study. And then there was an agreement that the other rates would increase by the 2.6%. And so then, as a result, rate E had to increase by the 5.2% to achieve the overall settlement rate increase.
Staff has nothing further.
Vice Chair?
No questions.
Mr. Matthews? A couple, Mr. Mackey. So, this is not going to surprise you, but your schedules are very, very confusing. And I think it's because of their cost of service and rate design schedules. But I'm curious, did you provide a schedule in the record that showed relative rate of returns between the different rate schedules for your initial or revised cost of service studies?
No, we didn't, Chairman. The rate of return was not used as a basis to establish the revenue requirement for this case. Rather, it was a tier-based filing, and so it was not necessary to develop a rate of return by rate class. And so that information was not generated, it was not provided.
Okay, and so even ignoring rate of return for a second, right? Overall rate of return and then relative to each class. Did you provide a schedule that explicitly provided the overall cost of service and then each rate class's cost of service and then what their cost of service is compared to their test year revenues to show a revenue sufficiency or deficiency by rate class?
Yes, that
Okay.
was provided.
And where was that provided?
That would be provided in my Exhibit 2 and the last page, I believe, of that exhibit.
Okay.
I can give you a specific reference.
That'd be great. If you could even give me a tab, that would be helpful. And then for that exhibit, you say that's your direct exhibit?
Yes, and it would be the same page, same reference as found in my Exhibit 5, which would be the rebuttal. I'm sorry, Exhibit 4.
Rebuttal Exhibit 5?
I'm sorry, Rebuttal Exhibit 4.
And that's the one of the ones that you'll be providing to commission staff in a post-hearing data request, right? In Excel form?
In Excel form, yes.
Okay.
So Chairman Chandler, the reference you're looking for would be on Exhibit RJM 2, page 17 of 17, and on lines 29 and 30. That will provide you the over or under recovery by rate class in dollars and the percentage.
Okay. And that's your direct testimony, Exhibit 2?
Correct. And then the equivalent page and line number reference for my rebuttal Exhibit RJM 4.
All right. And so which classes had the largest rate deficiency?
So in my rebuttal testimony, the rate class with the largest deficiency would be rate E,
And
at
how about your-
6.1%.
How about your direct testimony?
Direct testimony, it was the contract class.
Okay. And with your direct testimony, is that why the contract class had an 8% proposed increase?
Yes, sir.
And the overall was 5.3 approximately?
Correct.
Okay. And so you said it's page 17 of 17?
Yes, sir.
Okay. In which two lines show the rate sufficiency and deficiency, 29 and 30?
Correct.
Okay, and so what is the increase, decrease as percentage of proposed revenue, or present revenue? What does that represent?
That's the rate increase that would be necessary to bring each rate in line with its allocated cost of service.
Okay. And so the line 29 would just indicate that every class has a rate deficiency for the test year?
That's correct.
Okay. A couple more general questions. Why use AED to allocate production plan?
That's a good question, and it's certainly not always used, but it's used as a way to recognize that generation facilities provide both an energy function and a peak, like, demand function. So for a utility like East Kentucky that has baseload generating units that exist largely to provide energy to meet average demand requirements that are there all the time, it's appropriate to include an average component, but also recognizing that there's peak demand related costs as well, which cause the sizing of units, cause East Kentucky to invest in peaking generation facilities as well as baseload. And so it's really serving a dual component, right? It's serving energy, but it's also meeting peak demand requirements, and the AED is a way to roll both of those into one allocator.
Okay, so as opposed to, let's just say, if somebody allocated on a 1 or 3 or 6 CP basis, where it's only focusing on the contribution capacity, or contribution to meeting peak demand, AED actually looks at the utilization of the underlying assets.
Correct.
Okay, so what's the average part?
So the average part is it's reflective of the system load factor. So if you were to divide the annual energy that East Kentucky produced by the number of hours in a year, which is 8,760, that's the average demand. So it's an approximate of, what is the load that's kind of always there that needs to be served regardless of peak conditions.
And how is that used to allocate production demand?
Yeah, so that's for each rate class. Each rate class has its own average demand, and so that formulates a portion of the allocation factor.
And so, is it as simple as saying those classes with better load factors get a relative better allocation from the average portion of the calculation than those with a poor load factor?
I think it's probably the opposite, because the high load factor customers will have a relatively higher average demand than low load factor.
Okay.
Because
And
their load is kind of always there.
Okay, and then the excess portion of the calculation?
Yeah, so the excess, it's East Kentucky's excess, so it's the difference between East Kentucky's system, like coincident peak, and the average. And that difference gets spread or allocated to the classes based on each rate class's individual excess. And so that's measuring, it's kind of like measuring the variability between a rate class's peak and their average.
Which would then be beneficial relative to, what I'm about to say is to be relative, would be more beneficial to those who have a higher load factor in that their consistent usage is closer to their peak usage.
Correct. They would have less of a gap between the peak and the average, yes.
Okay. Have you supported an AED for production costs before, for the allocation of production costs in other rate cases?
I don't believe I have. This is the first G&T rate case that I've testified in. Prior to this, I've done lots of cost of service studies for G&Ts around the country that are not rate regulated. And for those, I certainly have used an AED method before.
You have?
Yes.
Okay. What do you consistently propose for production costs for allocation purposes? What methodology?
I would hesitate to say that, I guess, because I don't view, when I approach a cost of service study, as that there's one right answer. I strive to engage with the client in evaluation of their assets and discuss pros and cons of different approaches before I settle on one. I don't necessarily recommend one as the only acceptable way.
Okay. And is the AED methodology time differentiated?
No, it's not.
Okay. So that was your first change in rebuttal testimony. The second was to remove the Nucor load from 2019, or that small portion of 2019, as opposed to, I think, your initial study used the small portion of in 2019 and normalized it for the entire year. Is that right?
I would say a little bit differently. What we filed initially had, as you said, a partial year of load for Nucor, and also for that partial year of expenses. But what happened in that process of using the AED that I mentioned, each rate class has a excess determined, which is the difference between its peak and its average. And for Nucor, the peak happened with this new load on at the end of the year, so it's in December. And so because it was a peak related to 1 month that then is used to allocate a full year's worth of expenses, that was the part that was, after we discussed it, determined we needed to normalize that out so that it did not allocate a full year's worth of peak costs that came from 1 month of this galvanizing line being online.
Okay. But then does the removal of that in your rebuttal testimony then lose it, that new load's contribution moving forward from the average and excess allocations? And particularly the excess allocations?
So long as the new galvanizing line is of a similar load profile, it shouldn't affect that.
Okay. You're saying as long as it doesn't materially change the way Nucor uses electricity, the billing determinants that they actually incur, or not the billing determinants, the usage they actually incur shouldn't materially change from one cost of service study to the other.
I would say that's correct, yeah.
Okay. I think that's all the questions I have. I appreciate it, Mr. Mackey. Ms. Honaker, do you have any redirect?
No, I have none.
Mr. Kurtz, Mr. West? Ms. Vincel,
I have one question to ask.
please.
Mr. Mackey, can you explain what the justification was for the increase in the substation charges for rates E and G?
Sure. The analysis in the cost of service study shows that the substation charge is under recovering. And that can be found on page 17 of either my Exhibit 2 or Exhibit 4, and specifically on line number 40. And so that line will show what the per substation cost is on average for rate E, and you'll see it's much higher than the current substation charges. In order to not make an abrupt change, we decided to limit the increase of the substation rate to 5% across the board to get closer to the cost of service result.
Staff has nothing further.
Okay. And I will work with staff to make sure that it's asked correctly, but I do want to make sure that that post-hearing data requesting the portions of the pass-through that were specific in the request, that we want to see, at least for the demand, energy, and customer components, that we see each vector going to each rate schedule, including rate E, so that it's easier, and then for the rate E, how that interacts and goes to each one of the different co-ops. So we'll and that's per the stipulation amounts.
Okay.
Okay. We'll talk about it, Ms. Vincel. That's all. I think that's. Mr. Mackey, do you have any additional questions? All right, Mr. Honaker, Ms. Honaker, that's all the questions I have for Mr. Mackey. You can be excused.
Thank you.
One more? All right, Mr. Sanford, you want to call your next witness?
I'd like to call Mr. David Cruz.
All right. Good afternoon, Mr. Cruz.
Good afternoon. Chairman Chandler, excuse me.
Please raise your right hand. Do you swear or affirm that the testimony that you're about to give is true and correct under the penalty of perjury?
I do.
Please state your name and address for the record.
David Cruz, 4775 Lexington Road, Winchester, Kentucky.
All right, thank you, Mr. Cruz. Mr. Sanford, you may ask.
Sure. Mr. Cruz, good afternoon. How are you today?
So far, so good.
Now, you did not cause anything to be filed into the record of this proceeding,
I
correct?
have no testimony
Okay.
today.
So I'll skip over all the normal formalities, but did you bring anything with you to the stand?
I did. Given I don't have any testimony, I brought a few extra things. I've got a few notes on cone and net cone and how they apply in $1 per kW month. I've got a few comments from Stu Bressler on the previous BRA. I've got Exhibit ISS 3. I've got some materials from PJM on the reliability pricing model. I've got testimony from a number of the witnesses here. I've got some material on the triennial review of the VRR curve shapes. I've got the Brattle Group's assessment of the June 1st, 2022 online date for a combustion turbine and combined cycle. I've got the Gallatin Steel contract. I've got Mr. Barron's testimony, and I have a copy of the rate schedules.
Your Honor, Under this very well-prepared witness for cross-examination.
I hope we don't get to the VRR curve, but thank you, Mr. Sanford. Mr. Kurtz, Mr. West, do you have any questions?
No questions.
Mr. Gardner? Ms. Vincel?
Yes, just a few questions. Good afternoon, Mr. Cruz.
Good afternoon.
Because I started these questions to Mr. Scott, I think you'll know exactly where we're going with these.
I've heard a few of the questions so far.
Okay, we're looking at the interruptible credit, and you're right, we're going to be talking about the net cone. We were referring to Mr. Scott's exhibit ISS 3, and if you have that handy. And in his previous testimony today, Mr. Scott explained that this was based, that cost estimates for the interruptible credit were based upon 2019 EIA outlook for a combustion turbine single cycle. And one of the questions staff had was, if EKPC were to be short on capacity and had to self-build, would it build a single cycle combustion turbine?
So I'm going to take a little bit different path to the answer, if that's okay.
That's perfectly fine.
We've been talking about the interruptible rate credit as something like an avoidable cost type of construct. And I would offer that an avoidable cost construct is not the correct way to look at this. You asked Mr. Scott about the 400, 300, and 200 hour limits on how frequently you could interrupt, okay, and the differences in the cost associated with that. And I would offer that the impact, the number of hour impact for the customer is more instructive on what the credit should be than what our resource is. And if you look at what an equivalent capacity factor for 400 hours of interruption, you'll come up with approximately a 4% capacity factor. If you look at the resource type that would provide energy in a 4% range, you would come up with a combustion turbine, as opposed to trying to come up with an avoided cost. I think the people that originally constructed the interruptible rate, of course I wasn't here when that was done, but based on what I know and the structure of the rate, I think they looked at what the energy impact was, and they looked at what is, so for a simple cycle CT, a 6% capacity factor is about all we see for a simple cycle CT. And then I think that the capacity or the credit that a customer gets as a result of being interruptible for fewer hours is diminished because it's not as comparable to a CT and the valuation of a CT. So I offer that as my explanation, and I'm sure you'll ask me more questions if you, so.
Yes, we will, but that was a helpful explanation. That I appreciate your drawing that out. That was helpful to understand that we're looking at it in a different term.
Okay, thank you.
Nucor witness Stephen Barron had recommended the contract class have a 10-minute, the contract class 10-minute interruptible credit should be the PJM cone, net cone. In light of what you just said, what would your response be to basing the contract class contract class interruptible credit on PJM net cone? I'm sorry, I'm having a hard time getting that out.
So let's start with a few definitions for everyone. And cone is the cost of new entry, and the Brattle report that I spoke to, they do this report with some frequency to determine what cone is and what net cone is. And the Nucor, Mr. Barron accurately reflected that net cone is a reduction to the cone price that takes into account the revenues that resource garners in the day ahead and balancing markets, and it reduces the requirement or the revenue requirement for that resource. All right. Unfortunately, we're going to have to talk about the variable resource curve, reserve curve, because that's where net cone is used. It's an anchor point in the VRR curve, right? It's not a market price in the sense, but it anchors the top of the VRR curve, which is 1.5 times net cone. It anchors the inflection point on the curve, which is 0.75 times net cone, and then it kind of anchors the very bottom offer price, which is, I think, 0.0 or 20% of net cone. And of course, even the VRR curve is not the market price. The market price is what the market clears at. So, so we don't advocate that that we use the market price from the BRA clearing for the capacity market as the benefit that an interruptible customer should receive, because East Kentucky is in the PJM market to optimize all of our assets, of which our interruptible customers are one. We think it's appropriate to give them a credit, as I explained a few minutes ago, and then we take the interruptible or the demand, we take that interruptible customer's interruptible characteristics and bid them into the demand response market to lower our overall cost.
I want to make sure I phrase this correctly. Let's look at a scenario where the commission accepts Mr. Barron's recommendation and bases the contract class 10-minute interruptible credit on PJM net cone. I'm going to say what amount would EKPC recommend we use, but perhaps I should say, is there a particular formula to derive at a rate that EKPC would suggest could be used?
So, and thank you for the question. So I thought this might come up, so so for the 2022-23 delivery year, the net cone was $260.50. And if you want to convert that to a dollar per kW month, you multiply 260 times 365, that comes up to roughly $95,082.50 per year per megawatt. And then to come up with that, you divide that by 1,000 to get it in kW and divide by 12, and I think you'll come up with $7.92 a kW month, or roughly $8 a kW month for it. And I agree with Mr. Scott in that that an $8 kW a month would be too much of a credit, because it would exceed the demand charge that we have for particular customers. The other thing about this is that in previous, in prior discussions today, we talked about, or there was discussion about this, and reducing the load during the peak doesn't make the load entirely go away. We still have to serve that load, right? And it doesn't reduce our transmission plant requirements in any manner, because while we may make that load go away when we're seeing high demands, to avoid having to purchase additional generation or have additional generation, whether in real time or on a long horizon, it doesn't change the transmission or substations or distribution requirements for the system, and given that kind of credit would start to erode the recovery, probably erode the recovery of those assets.
Staff has no further questions.
All right, thank you.
Vice Chair?
No questions?
I don't have time to ask Mr. Cruz a question. I'm only here for about 12 more days. I've waited all day to do that, sorry.
I'm hard of hearing, and it is harder within this little
What I
cone of silence.
Well, then I'd hate for you to miss what I said. I said I don't have time to ask Mr. Cruz a question. I only have about 11 days left at the commission.
Yes, I know that you appreciate my slow southern drawl.
It's like, Mr. Cruz, it's like the Ents said in Lord of the Rings, anything worth saying is worth taking your time to say. Net cone, reference unit, whether it's right or wrong, quadrennial reviews, all of that aside, right? The question I have is, primary question, the initial question is, what is EKPC's position as to its avoided generation capacity cost? And how to calculate it?
So I think this gets into, is this as it relates to interruptible or as it relates to our cogen tariff rate?
Well, and that's the question, right? Is there a distinction? Is there one, to stay with my Lord of the Rings references, is there one calculation to rule them all? Can you come up with a calculation and amend it or discount it for a shorter interruption? I'm just curious, where's East Kentucky's position as to where it starts looking at avoided generation capacity values?
So, and I think that's within the cogen tariff. And as I've testified on the interruptible rate, that's related to EKPC's cost here. The cogen tariff rate is something that is driven by PURPA. And FERC has put PURPA in kind of the RTO space, and they've put PURPA. They've said that the energy rate that is an accurate benefit for paying for is our cost of energy, our LMP cost.
And just to be clear, FERC has said that it's a per se reasonable because it's a market base that they've approved, right?
Not that you can't come up with something else, but that a reasonable approximation of what the value to pay a PURPA customer is LMP. All right. Because we're in the RTO space, they also say if you don't need capacity, you don't have to pay capacity for a PURPA resource. And I would speak to, and we're not, I want to preface my comments about, we're not against solar, okay? But, so East Kentucky, as I'm sure you're all aware, is long in the summertime, okay? We don't forecast to need additional summer resources to meet summer peak till beyond 2030, all right? When you look at our winter peak, solar doesn't contribute to our winter peak because most of the time our winter peak occurs before the before the sun comes up. And so if you look at the solar contribution, we don't need it in the summertime. From a capacity standpoint, we're happy to get the energy, but from a capacity standpoint, with regard to our cogen tariff, and that's why we kind of have the dispatchable and non-dispatchable cogen tariff rates. It's not a dispatchable resource, and it doesn't, right now, it doesn't contribute to our needs for capacity in the summertime. So, and I don't mean to avoid your question, but, you know, if you ask me what are we going to do about our winter, about hedging our winter load, I think in the short term we will look at energy purchase, a firm energy purchase to hedge our price exposure over the winter periods because, well, let me say this. I'm advocating that we use energy purchases, firm energy purchases to hedge our price exposure in the wintertime, and that would put us, you know, as far as capacity, potentially sometime in the 2030 timeframe.
And that is, you know, sort of the crux of the question is that my experience would be that East Kentucky doesn't anticipate or doesn't do their planning in such a way that they intend to be short for their own system peaks. Is that sort of what you're alluding to, that if you become short in the winter, right, that your own demand exceeds your generation, you wouldn't necessarily plan to just take energy, to be a participant in the real-time market and not have that firm, something firm, whether it's still in the ground or a bilateral energy contract as a hedge against market prices?
Right. I mean, and I know that we've answered this. I know I've read Ms. Tucker's response, and she and I collaborated on that. But we've got three options. One is to build, one is to, you know, bilaterals, you know, and a third one could be to be what we call naked and not have a hedge. But we don't have a great desire to be to have a lot of risk, you know, energy price risk. So we'll move in one of those three directions. You know, the market right now, yeah, well, we all know that the PJM market cleared for 23 at $50 a megawatt day in the RTO zone. That to me indicates that there's a lot of capacity in the PJM footprint, particularly the RTO zone. So I struggle with not taking advantage of that for the benefit of my customers.
So a couple of follow-up questions to a couple of the answers you've given. You heard Mr. Mackey talk about the average and excess cost of service study a few minutes ago, right? How he studies the contribution of it's not just peaks of production expense, but he also looks at the utilization of the underlying assets, right? That the cost of production assets are not necessarily allocated to customers based exclusively on the customer's demand at peak times, using the average and excess Did
Okay.
you take that away from that as well?
So I have to say that I would have to defer to the expert on that because while I'm in markets and I have some experience in rate design, I'd prefer to defer to the expert.
And what I'm asking, you heard his response on those.
Right, I did.
Is really what and I guess, I'm curious, you're talking about only paying generation for a capacity contribution to a peak, whether it's a winter peak or a summer peak, not contributions to, a portion of a contribution to a peak, or different demands throughout the year. That if you, I guess what I'm really asking is, are you saying that if you can't contribute to a summer or winter peak, that your capacity, your benefit, your value to the system in terms of capacity is zero?
So, well, I hate to get there, but I mean, there's a new concept called the effective load carrying capability. It's not really a new concept. It's been around for many years, and under the ELCC concept, you start to look at the benefit each resource has on the peak. And today, our peak is, our end in 17 to 18, and of course, the where this is demonstrates a lot is in solar, because at some point adding more solar doesn't reduce your evening peak anymore, and then so the value of adding more solar from a capacity standpoint ultimately diminishes to zero under that construct. That's not where we are today, but so I would say that for us, I would say we need to have some contribution to peak, to our peaks. First of all, I'd say we need to, for us to start paying for additional capacity of any nature, we should have a need for capacity, because otherwise we're purchasing something that we don't need. And that's where I struggle in the summertime, because we're flush with capacity for the foreseeable future. With regard to the wintertime, some of the many of the renewable resources don't provide energy during the peak times and so if it's not providing energy, it looks more like an energy-only resource, and I would say it shouldn't be entitled to a capacity payment if you're an energy-only type of resource.
And taking a step back, this is part of your answer earlier that I wanted to get to. Are you making a distinction between the QF tariffs and the interruptible tariffs as a distinction between whether one should be looking at avoided cost on a standalone retail basis versus a utility that's a member of an RTO?
So I do make a distinction between the interruptible tariff and the PURPA cogen tariff. I think the interruptible tariff fits, or it's a tariff that is a regulated tariff by the Public Service Commission. I don't want to say that the cogen tariff is not, but the cogen tariff has influences from FERC, and whether we're in an RTO, it's not. To me, it's different than the interruptible tariff. And like I said at the beginning, FERC has made different rules for PURPA and cogen tariffs for entities that are in an RTO. And let me around. There's only a few people that are here that were, had any insight into 1978 when Purple Law came out. I joined my first utility in 81. I had been working as a summer employee in the 70s at a utility, but even I didn't know what Purple was at the time. But at the time, generators didn't have access to what one purchaser, and that was the native utility. If they wanted to sell if they wanted to be a merchant generator, they had to sell to the utility. And I would, I want to preface a couple of things. You're getting the David Cruz response on some of these things as opposed to, I'm just going to say you're getting the David Cruz response on it, because on my advocacy for PPAs during the winter, that's my advocacy, and we hadn't gotten there as a company yet. But on PURPA, utilities didn't want to purchase from generators, and there had to be a federal mandate to get to the point where utilities would purchase from merchant generators. Since then, and there were no markets. The only market was the native utility, and that's how PURPA came to be. It's changed the landscape that we work in has changed dramatically since the 70s and early 80s, and I think that's why we've seen FERC change the rules for those utilities that are in a RTO to the point that you can go from 80 to 20 to 5 as far as the required purchase obligation under PURPA.
So let me ask that called the rub between occasional retail and wholesale markets, right? Or looking at the utility for an avoided cost at the retail level and an avoided cost that might be more market-based for two different things, like an interruptible tariff and a QF tariff. Isn't there a risk to the utility, especially the way the direction that FERC is going with demand response and rethinking its opt-outs and Order 2222 by effectively reducing the amount of or limiting the opportunity of certain demand response programs or energy efficiency programs at the retail level, that it appears that, oh, well, we don't have market access, and that isn't there an avoided cost that isn't there a cost you're avoiding effectively by not, let me take a step back. I hope you know where I'm going, but it's cheaper, all things being equal, effectively, to have demand to the utility of having demand response programs run at the retail level as a general matter. You don't have to do, it's much simpler, I'll say it that way, for the utility. My question is, there's a cost that the utility is going to incur if someday demand response and energy efficiency and everything else in a vertically integrated state is then wide open to wholesale market participation. And I guess going back to what you were saying about Mr. Scott saying, well, we shouldn't give them the full, even if it is the net cone or something less or a simple cycle CT, whether it's $6.60 or $8, that we shouldn't give them an interruptible tariff the full amount of the value. But isn't there an inherent risk that by not giving them the full amount of the avoided cost, that there will be then additional pressures to open up these retail states for participation in wholesale markets, and then ultimately cost those other remaining retail customers more?
So we talked about net cone for being roughly $8 a kW month. And if you take the $8 a kW month and convert that into dollars per megawatt hour and say a 22% capacity factor, which is may be short or on trackers and maybe long on non-tracking solar, you come up with $50 a megawatt hour for the back. You're given, if you're going to give a demand or a pay for demand on the cogen tariff, and And then if our average, during this past month of July, the on-peak or real-time average, those 16 hours was $35 and I can't even read my own writing, but $35. So roughly $50 plus 35 associated with the LMP, and that would give you somewhere around $85 a megawatt hour to pay for solar under a cogen tariff. And I think that's, well, I know that's significantly more than I can go out and purchase it on utility scale, which I think there's a cost shift or subsidization, and a subsidization would occur between, to pay that kind of price under the cogen tariff.
I don't take any of my questions as advocating for any particular perspective. What my question is if that net cone, as determined by Brattle in the quadrennial review, and it's probably the wrong reference unit, but we'll deal with that in a couple of years. My question is, then what is the appropriate reference unit or resource for purposes of determining that avoided capacity value that you would pay to something like an interruptible rate? That's really the crux of this whole line of questioning.
So when we set up our cogen tariff rate, what we were attempting to do was to be indifferent to the purchase, such that so that if we purchased, we could monetize it in the PJM market, and it would be an in and an out and wouldn't harm our customers one way or the other. So if you follow me, that's what we were attempting to do. So, you know, and that creates a situation where there isn't a subsidization of somebody that would put a solar installation on our system and take advantage of the cogen tariff. And I don't mean take advantage in a negative way. I'm just saying use the cogen tariff as they're able to. And that gives them the same price signal they would get in PJM to sell it directly to PJM if that was what they wanted to do. And that's so, and that keeps our customers from being harmed as well. So, and this is not unlike what you see many of these synthetic sales where a company will purchase the output of a solar farm. They'll have a settlement at the LMP, and then they use the RECs. So, I mean, that's one of the ways that some of the larger companies are getting RECs, is that they buy the output in a bilateral. They're not trying to use it to serve load. They just buy it as an entity, then they sell it into the market. They settle with the solar developer. They may take a little bit of a beating or not full recovery, but they get the RECs, which is what they were really looking for out of it. So that, and they like, so there.
Using I think, and it's been a while since I've looked, but you all, for QF purposes, use the names escape me. The auctions that occur between the.
Right now, we're paying the third IA, the third incremental auction.
That's right, the incremental auctions. You pay the incremental auction, the auction between, because it's much closer to delivery year instead of it being historically 3 years out, right?
And I think when we started that, we were just bringing on our cooperative solar, and we were going to be in the third IA with that, and we put it on par with what we were doing there. That's my recollection, and so if you were to advocate, and I know we got a case on this, so if we were to advocate to use a different settlement or BRA, I think we could talk about that.
Yeah, and the other side of it is, I appreciate the idea of using the BRAs as a way to say, we know that we can immediately, especially the incremental auctions, we know that we can pay you this price and effectively immediately turn around and sell it for that, right? We know what the amount is, we can go ahead and bid it in at approximately that. And it's a way for you all to have little to no risk in the transaction. The other side is, though, you said we don't have a need for capacity, right? But the reality is that if that's the only way you treat if that's the way you define the avoided cost as the amount that you can monetize whatever you're paying, then you'll also never get the corresponding benefit that a QF could provide in order of providing you generation and energy that you then don't have to build, right? So you all could have a need in 2030, you said you don't have one until, but say you have a need in 2030, if you continue to calculate avoided cost in the same manner, then QFs will never actually, in practical effect, fill that void that you avoid that cost or avoid that generation need that you may or may not have in 2030. Is that correct?
So point of clarification, where we're paying capacity is on the dispatchable QF tariff, and on the non-dispatchable today, we don't pay capacity on that. I think we need to see how this ELCC concept is going to develop and how much value solar can, what kind of compensation we can get from the market for solar and renewables. And once we see that develop a little bit more, I think we can put we can sight in on it better. But MOPR is, we're seeing better. At one point, I was concerned that the minimum offer price rule was going to close us out from bidding in solar at all. And I think that's coming to a better place that would allow us, if there is a value in PJM, to monetize it.
Well, and the ELCC class ratings, FERC has recently approved those. Is that your understanding?
I'm sorry, I didn't hear you.
It's okay. Are you aware that FERC has recently approved the ELCC class ratings for the next delivery year BRA?
I haven't picked up on that just yet.
So, going all the way back, I think that it may not be clear from the record for where that $6.60 from, at least not to me, where that current interruptible capacity credit comes from, the derivation of it. Maybe it was in the last rate case and, it was this reference unit, that reference unit. For that interruptible credit, should it be is it EKPC's position that it should still be based off of a reference unit, overnight capital cost, whatever however the amount is given, but the capital cost for some sort of reference unit from a public, transparent publication like EIA. Is that EKPC's position?
Yeah, that's my opinion. And as I said in the beginning, it kind of ties to the interruptible hours, like the 400 to 300 and 200. Those number of hours tie the reference unit to a peaking type of unit. We use FA in that. Brattle uses a GEH, which is the newer, larger unit. There's differences in the way that they calculate it and we calculate it, and if you'd like, we can get into that, but I suspect that you do not want to go there.
And then, this is the final question, I promise. Is the combustion turbine the most likely next unit that East Kentucky would intend to build, or would it be something more like a combined cycle?
Well, I think the next commitment that we're going to make is for a solar installation as opposed to a CT but it's going to be I expect it to be an energy-only purchase and not have any capacity in it. So, of course, that's with the Diageo contract to support that, but, yeah, it is harder to determine what kind of resource to choose today than it ever has been before. You know, I didn't think that when I came to Kentucky that I would ever mention nuclear, but there are utilities that are getting an 80-year depreciation life on nuclear plants, and if you've got an 80-year depreciation life, that changes the complexion of nuclear. So I'm not, and I didn't say we were going to develop a nuclear plant. I'm just saying it's harder than ever before to decide what to do.
Yeah, your phone's probably ringing. Tom Fitzgerald's probably
My
calling you.
phone's in the-
That's a
my
bad
phone-
idea. So.
My phone is elsewhere right now, because you said, do not show up with a phone.
All right, I appreciate it, Mr.
All right,
Cruz.
thank
Do you have any redirect, Mr. Sanford?
Are you kidding?
Ms. Vincel, do you have anything else for Mr. Cruz?
No.
Commissioner Matthews? Vice Chair?
Mr. Chairman, can I ask Mr. Cruz a few questions, please?
Sure.
Thank you. Mr. Cruz, 200, 300, 400-hour interruptible load, the 400 hours is more valuable in East Kentucky than 300, which is more valuable than 200.
No, the 400 is more valuable than, because I think it's intuitive why 400 is more valuable.
You also have different interruptible notice periods. You have 10-minute, 30-minute, and 90-minute. Is that correct?
Yes, so your contract, we have a 10-minute interruptible. The demand response market in PJM is a 30-minute interruption. When we were a balancing authority, the 10-minute was probably more valuable because we were a balancing authority, and because of the nature of the Nucor load, which can move us 100 megawatts, the 10-minute was a benefit for us to be able to hit our BAL2 as our recollection NERC standards. So that, you know, yes, it's valuable. Since we joined PJM, it probably doesn't have as much value as it was when we were a balancing authority.
But still, a 10-minute interruptible resource is more valuable than a 30-minute, which is more valuable than a 90-minute.
Right, and of course,
Is that?
that's correct.
Okay. For example, the Nucor electric arc furnace, the electrodes that melt steel, that's the 10-minute, because that can shut off pretty much instantaneously.
I believe we can still shut it off from our market operations center with a
By
button.
pushing a button?
Yeah.
Correct. And so Nucor's interruptible. App Harvest is an interruptible customer. How many interruptible customers do you have?
Mike, I'm sorry, I don't recall. I can answer that on a post-hearing data request, but
It's more than just a handful?
it's more than just a handful. We have a number of interruptible customers, and so.
Okay. And the settlement agreement in this case is to keep the interruptible credits for 200 hours, 300 hours, 400 hours, 10-minute, 30-minute, 90-minute, keep them exactly the same as where they are now.
That's my understanding.
And if there was a change, either up or down in the interruptible credit on any of that variety of flavors, that would change the revenue requirements in this case?
Well, I have to think that it would impact our settlement agreement.
But the agreement is keep everything where it is now, as East Kentucky proposed in its application.
I can't say how it would impact our revenue requirement. I'd defer that question to Ann if she comes back up.
But the agreement
Or Ms.
is,
Bridges.
the settlement agreement is to keep the interruptible program exactly as you filed it.
Right, I mean, if that gets changed, I would think that you and the other parties in the settlement agreement would want to reopen that.
Well, it could, in any event. Thank you, Chairman.
Not if it's $8, no. Thank you, Mr. Kurtz. That's all you have? I'm just making a joke, I promise. Mr. Sanford, do you have any redirect now?
No, sir.
Okay, thank you. And can Mr. Cruz be excused?
Yes, you can.
Okay, thank you, Mr. Cruz.
Thank you.
We'll take a short recess. We'll take a recess until 3:45, and then we'll try to push at least until 5 o'clock.
Okay.
Thank you. Ms. Tucker, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under the penalty of perjury?
I do.
Thank you. Please take a seat. State your name and address for the record, please.
Julia Tucker, 4775 Lexington Road, Winchester, Kentucky.
Mr. Sanford, you may ask.
Thank you, Your Honor. Good afternoon, Ms. Tucker. How are you today?
Good afternoon.
Did you cause certain responses to data requests to be filed in the record of this proceeding?
I did.
And do you have any edits, changes, or corrections to those responses to data
I do.
requests? If I were to ask you the same questions right now, would your answers be the same?
Yes, it would.
Is it your desire and intent to incorporate those answers into the record of this hearing?
Yes, sir.
And did you take any materials to the witness stand with you this afternoon?
No, I did not.
Okay, thank you. Your Honor, the witness is available for cross-examination.
Mr. Sanford, Mr. West, do you have any questions?
No questions.
Mr. Kurtz?
No questions.
Mr. Gardner?
No questions.
Ms. Zensel?
No questions.
Vice Chair?
No questions.
Commissioner Matthews?
No questions?
Okay, Ms. Tucker, I have questions on one subject. You at East Kentucky are involved in financial transmission rights, ARR, and FTRs, is that right?
Yes, sir.
Okay. One of the reporting requirements that East Kentucky has been requested to be relieved from is related to, this is from the stipulation, the annual comprehensive report detailing transmission rights, hedging strategies, and PJM benefits and costs. Do you provide any information ahead of that report in any given year? Do you contribute to that report before it's
Yes.
being filed?
Yes, sir.
Okay, and so I'm just curious, is it, on this particular report, given your experience in the ARRs and FTRs, is it what's included in the report that East Kentucky believes is no longer relevant or important for the commission's review and consideration on an annual basis?
Yes, sir. On that report, one of the requirements is to compare the original entry study that was provided in the case where we asked to join PJM. We compare actual results to what was provided in that study. That study's almost 10 years old now. And so the comparison back between what has happened to date, what happens actually, and what was proposed in that study gets to be very difficult. Because one of the comparisons we have to make is what would we have looked like, what would our costs have looked like if we had remained a balancing authority and not joined PJM. So the reason to ask to keep from filing that complete report is that comparison, is that it is, the relevance seems to be, we seem to be past that at this point. We've proven and shown what the benefits of joining the PJM market were. As far as providing the benefits of the market and what the ARRs and FTRs are, that report could readily be provided to the commission each year. It's the comparison back to that original study and what we would have looked like as a standalone utility that gets to be very complicated.
Okay, and it's the basis of requesting relief from that is running and then comparing to that counterfactual. That's
Correct.
years and years, you're just making, I hate to say it this way, but you're kind of making up what would have happened in the interim, what we would have looked at as a balancing authority since then, what
Correct.
other changes would have been made. You're
Yes.
just saying that portion of it has become harder to create and then compare to what your actual experience has been with financial transmission rights.
Yes, sir.
Okay, and so if the commission still had an interest in looking at your hedging strategies, what you're doing annually in the FTR markets or with your ARRs, whether you're self-scheduling, all of that, that's not necessarily, not wanting to report that is not the basis of the request. Is that
That's-
fair?
That's, yes, sir.
Okay, all right. Thank you very much, Ms. Tucker. I've no other questions. Do you have any redirect, Mr. Sanford?
No questions, Your Honor.
Are there any additional questions?
Nothing further.
Can Ms. Tucker be excused?
Yes, she may.
Thank you very much, Ms. Tucker.
Thank
You're
you.
going to step down. I think Ms. Honaker next.
We call Patrick Woods.
Mr. Woods, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, I do.
Please have a seat. State your name and address for the record.
Certainly. Patrick Woods, East Kentucky Power Cooperative, 4775 Lexington Road, Winchester, Kentucky.
Ms. Honifer, you may ask.
Did you cause direct testimony to be filed in this proceeding?
Yes, I did.
Do you have any additions or corrections to make to that testimony?
No.
If I were to ask you those same questions, would your answers be the same?
They would?
Is it your desire and intent to incorporate the direct testimony into the record of this proceeding?
It is.
And did you bring anything to the witness stand for you?
I brought copies of my testimony and exhibits.
Witness is ready for cross.
Thank you, Ms. Honifer. Mr. West?
No questions.
No questions, Your Honor.
Mr. Gardner? Ms. Wenzel?
Yes, just a few. Good afternoon, Mr. Woods.
Good afternoon, Ms. Insel.
I wanted to follow up on some of the reporting requirements that EKPC requests relief from.
Sure.
There seem to be two categories of them, obsolete or changed circumstances. So I'm going to go through them semi-quickly. Please feel free to chime in if I'm incorrect.
Sure.
I have three that appear to be definitely obsolete. The first is the report on the variable interest rates. And is it correct that that reporting requirement was put into place in 1998?
1995, I believe.
1995, thank you.
Correct.
And so it reflected the reality of that particular time period
Exactly.
and would no longer experience that same scenario. So that is why this would be obsolete.
That's exactly right, yes.
And the next two reporting requirements deal with, first, the Smith one, regulatory asset, I'm going too fast, and then the Dale projects, 5 and 10. With Smith one, it was a report on the mitigation efforts.
That's correct, yes.
And because those mitigation efforts are over.
We have exhausted those efforts right now, yes.
And with the Dale projects, 5 and 10, with the request to recover 2-year amortization, that reporting requirement also becomes obsolete.
Exactly, yes.
And then looking at changed circumstances, there's monthly financial filings that I believe originated from a 2006 order.
That's correct.
And again, that reflected a time when EKPC was in a very different financial position.
Exactly.
And the monthly monitoring was necessary in order to ensure that, to watch EKPC's financial condition, but also to look for improvements.
Exactly, yes.
And we've already addressed the PJM reporting issue. There are two that are reports on the calendar year interruptions, one for Nucor and one for AGC.
Correct.
And for both of these, is it correct that they were implemented because EKPC was still fairly new in PJM, or at least the interruptible credit program was fairly new, so that these were both monitoring?
That's correct, yes.
And to your knowledge, have there been any issues that have come to EKPC's attention?
I do not believe so.
And then we have the Bluegrass Station Performance Report, and that was put into place at the same time that EKPC was authorized to purchase.
Bluegrass units, that's correct.
And the purpose of the report is to monitor EKPC's risk exposure in PJM's capacity market.
That's right.
And in this case, EKPC says we have a certain amount of data, the risk is being managed.
Correct.
And the last arises from administrative case 387, and it has to do with price elasticity and forecasted information. And from what EKPC has filed and reported, there's been nothing new to report for a substantial amount of time.
It's been the same for the last few years, and it will probably be the same going forward.
And I think that covers everything. Is there anything else that you think is relevant to add?
Nope, that's it. You did a great summation. Thank you.
Staff has nothing further.
Thank you. Question?
No questions?
If, as I was asking Ms. Tucker, the financial transmission rights report was amended to remove the references to the counterfactual, what would happen, what would, compare what is versus what would have happened had we gone down a different avenue a decade ago. Is that report otherwise still objectionable by EKPC?
Not at all, no.
And just so I'm clear, no significant identification of performance issues was made as it relates to the Bluegrass Station following the transfer of those CTs?
That is correct, yes.
And then finally, the only portion of the admin 387 filings that you want to be relieved from is the one in which you were required to study and review and provide an update on the price elasticity of demand.
That's correct, yes.
All right. Thank you very much, Mr. Wood. That's all the questions I have, Ms. Honaker. Any redirect?
I do not.
Okay. Can Mr. Woods be, well, I say you be excused, but can you, you're going to stay here, I assume, the next day. This is what you get. So can Mr. Woods be excused?
Yes, he can be excused.
Okay, now, thank you.
Thank you.
All right, Mr. Sanford. Yes, Your Honor, I'd like to call Mr. Craig Johnson. All right, Mr. Johnson, do you mind to stand and raise your right hand? Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please state your name and address for the record.
Craig Johnson, address is 4775 Lexington Road, Winchester, Kentucky.
You may be seated. Mr. Sanford, you may ask.
Thank you, Your Honor. Good afternoon, Mr. Johnson. Did you call certain rebuttal testimony in response to that or request to be filed in the record of this case?
I did.
And do you have any corrections, additions, changes, edits to that testimony or responses?
I do not.
If I were to ask you the same questions, would your answers be the same?
They would be.
So your desire and intent to incorporate that into the record of this hearing?
It is.
Do you have any materials that you've taken with you to the witness stand today?
I do not.
Thank you, Your Honor. Witness available for cross.
Mr. Woods?
No questions, Your Honor.
Didn't get to ask. Mr. Kurtz?
No questions, Your Honor.
Mr. Gardner? Ms. Vinsel?
A very few. Good afternoon, Mr. Johnson.
Good afternoon.
You may have heard earlier questions that staff asked about the generation maintenance tracking mechanism.
I did.
And the only real question that I have to ask is that 75%, 25% split. Do you have any thoughts about that 75%, what it means to EKPC in terms of, in general, what it means to EKPC?
I was not in the negotiations, but from what I understand, the mechanism would allow us to kind of take some of the lumpiness out of our maintenance plan. Our maintenance tends to be cyclic. We do overhauls like on 10-year intervals where you incur a large expense in a certain year. So that would be a way to kind of flatten out some of the really peak years versus the normal years.
Staff has no further questions.
No questions.
Commissioner Matthews?
No question.
Sorry, I just realized I forgot to ask if you had any for Mr. Sorry.
I would have butted in if I had.
Mr. Woods, yeah. No, I appreciate it, Mr. Johnson. I just have a couple of questions about your rebuttal testimony.
Yes, sir.
And specifically the Smith units. Do the Smith units 1 through 3 wear differently than your other CTs? Or are they just rare?
Smith 1, 2, and 3, I was the construction manager for East Kentucky Power or Smith 1, 2, and 3. Those units were a joint purchase between us and Kentucky Utilities at the time. So there was supposed to be a proven mock-up of ABB's 11M1 technology. On commissioning, I remember there was nothing but issues on those units. As a matter of fact, I think KU, one of their units through, I don't know what happened, but it kind of self-destructed. And we put a halt on our commissioning on those units until we found out. We were pretty in close connection with Kentucky Utilities at that time, the project teams were. What came down was there were several modifications that needed to be made to those 11 and 2s before we would ever accept them for commercial. So they went through a very extensive commissioning over about a 4-year period where ABB modified the turbine casings, they modified the bearings, they modified blades, they modified the hot gas casings. And it has only been through probably the past, well, really since PJM, that the units where the way PJM runs those units, they bring them to base load and they let them set. That has been very good for the maintenance of those units, but it's still the wear and tear on those units up until that point is pretty substantial. We've already seen through our last majors that we've had to modify turbine casings where they're already starting to eggshell. We've had to do stitching on the casings. We've done a lot of modifications to like changing out hot gas casings, and there's not a lot of OEM support for those units. As you can imagine, if we needed a new casing, I don't think there'd be a place, and it couldn't be repaired in the world, that we could even buy a casing like that. So the units, in one way, they are a rugged unit. They're very, probably our least efficient unit that we have in the whole fleet now. But just the nature of the units and the early cycling of them, and just us working with GE now to really modify them so they are a reliable unit, probably shorten the life of them.
Do you all have an expectation of their remaining service life?
We just completed major turbine overhauls on all 3 of them. And if PJM runs them like we think they run, probably won't see another major turbine overhaul until sometime in the 2030s. At that time, I would advise that, we do an economic analysis on whether it's best to continue operating those units or to replace them with some type of generation.
Whether the going forward capital cost is higher than the replacement cost?
Right.
Okay. Thank you, Mr. Johnson. Is there any redirect, Mr. Sanford?
No, Your Honor.
Okay. Anything additional, Ms. Wenzel?
Nothing further.
Can Mr. Johnson be excused?
Yes, you can.
Step down. Thank you, Mr. Johnson. Mr. Sanford?
Yes, Your Honor. I'd like to call Miss Mary Jane Warner, please.
Ms. Warner, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please be seated. Please state your name and address for the record.
My name is Mary Jane Warner, EKPC 4775, Lexington Avenue, Winchester, Kentucky.
Mr. Sanford, you may ask.
Thank you. Good afternoon, Ms. Warner. Did you cause certain responses to data requests to be filed in the record of this case?
I did.
Do you have any corrections, additions, changes to those data request responses?
I do not.
If I were to ask you the same questions, would your answers be the same?
Yes, they were.
Is your desire and intent to incorporate those responses into the record of this hearing?
Yes, it is.
Did you by chance take any materials to the witness stand with you this afternoon?
Only my responses to the data requests.
Thank you. Your Honor, the witness is available for cross-examination.
Thank you, Mr. West. Say it fast this time, so you don't be.
No questions.
Mr. Curry.
No questions.
Okay. Mr. Gardner, thank you. Ms. Vincel, do you have any questions?
No questions.
Vice Chair?
No questions?
Commissioner Matthews?
No questions.
I have nothing either. Thank you very much.
Thank you very
Given
much.
that no one had questions for you, you may be excused.
Your Honor, Ms. Honecker will have our next 4 witnesses.
I think he was hoping we'd go till the third day and we could just skip out on the third day.
Less attention? All right, Ms. Honecker, please call your next witness.
Scott Drake. Oh, it's already up there.
Mr. Drake, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please take a seat. State your name and address for the record.
Scott Drake, 4775 Winchester Road, Lexington Road, Winchester, Kentucky.
Ms. Honecker, you may ask.
Did you cause direct testimony and responses to data requests to be filed in the record of this proceeding?
I did.
Do you have any corrections or additions to make to any of those?
No,
If I were to ask you those same questions today, would your answers be the same?
I would.
And is it your desire and intent to incorporate those into the record of this proceeding?
Yes, please.
Did you bring any materials to the witness stand with you?
Yes, I have my testimony and my sponsored responses to data requests.
The witness is available for cross.
Thank you, Mr. West.
Attorney General doesn't have any questions.
Mr. Kurtz.
No questions.
Mr. Gardner, no questions. Ms. Vincel.
No questions.
Vice Chair.
No questions?
Commissioner Matthews.
No questions.
The only questions I have, Mr. Drake, are that, are you involved at all in following the Order 2222 compliance that PJM?
Yes, I'm preferably involved in following that, yes.
Okay. And how, I guess, when you say peripherally involved, how is that?
I've had several discussions at East Kentucky Power with Cruz and David Cruz and additional staff about the content of that order.
And the significant portion of your direct testimony is about DERs, energy efficiency, and DSM programs. Is that right?
That's correct.
Okay. And how long have you been doing DSM with East Kentucky Power?
Since 2009.
Okay. And in that time frame, I guess that's about 12 years ago, would you agree that the spending or the programs offered by East Kentucky have sort of waxed and waned and increased and decreased over that time period?
I would say that's correct.
Okay. And some programs have been phased out completely and some have been started. I think ETS kind of quite infamously was a very big program and it's no longer a program at all. Is that your understanding?
That's correct.
Okay. And in that range of, 10 plus years, where in the waxing and waning in terms of DSM programs is East Kentucky today?
Today, our programs are what I would characterize as relatively thin. When we did our cost effectiveness study back in 2019 in association with our IRP filing, due to the market, I guess the energy market and capacity market being a little soft in PJM, that caused a lot of our programs to not be cost effective anymore. So we, at that point, eliminated several programs. We also modified several programs to and remove portions that were not cost effective anymore out of the programs that we kept.
Okay. And did you hear some of the questions and answers between myself and David Cruz earlier?
Yes, it did.
So when you all are looking at the cost effectiveness of these programs, are you all looking at the market signals in a specific time period or over a time horizon? Are you looking at a single BRA clearing price from one delivery year, or are you looking at an average of clearing prices over a number of years?
We look at the avoided cost of both energy and capacity as a forward curve. So we look over the period. I think the longest lifespan of some of the energy efficiency upgrades tend to be about 15 years. So we'll go all the way out to 15 years if necessary. It depends on the type of resource. Lighting is different than weatherization, that's different than other programs. And we do look at the forward price curve on capacity, avoided capacity, and avoided energy in the markets.
Okay.
It's from the forecast.
And you remember Mr. Cruz, I was asking questions, and he was talking about the QF tariff, that currently the QF tariff, especially for dispatchable generation resources, uses, you know, some sort of incremental auction in the nearest delivery year. Is that your understanding?
Yes.
Is that the same reference amount or avoided cost for capacity that you all use for the purposes of determining the cost effectiveness or the payback or whatever it may be of these DSM programs?
We don't use the incremental auctions, we use the BRAs. What we forecast the BRAs to be for the next few years, whatever is the length of the type of resource we're evaluating. But it's not based on the incremental options, it's based on the BRA.
Okay, and so you look at the BRA, and then you look at what you think the BRA is going to be over a time horizon, and then you look at how many years you think the DSM program is going to have a value for. Is that right?
That's correct.
And then do you discount those outer years back to a present value to determine what they should be paid?
We do. We look at a net present value. Everything's taken to a net present value to determine benefit versus cost. So all of your benefits are not only the next year, but several years out of the program. We'll discount that back to net present value because usually when we implement a program, all of our costs is in the first year. When we implement a rebate, if you will, for lighting upgrades, if you will, all the costs is in the first year, but the benefits may be accrued over many years. So we have to discount that back to do a apples to apples comparison.
Okay, and then, let me get this right. Do you all internally have a policy or preference in setting up your DSM programs to mirror or align with those, let's call them programs offered by PJM? Or do you all still use programs that are beneficial to the utility on a retail focused level that may not necessarily pass through at the wholesale level?
We're generally focused locally. We're looking to build programs that are effective locally, that our retail members will participate in. We do not take the eye off the ball of can we monetize those programs in a market. But monetizing them in the market is not necessarily required in order to understand the benefit versus cost, because our avoidance of energy purchased or capacity purchase is a lot of the benefit. So we monetize them by avoidance, not necessarily selling the residual demand response capability or the demand reduction capability into the market.
Well, and that's why I'm curious, because you're generally, and I know it's not exclusively, but generally a winter peaking utility.
Correct.
In a summer, in an RTO that focuses its capacity value or benefit or whatever on a 5 CP summer basis.
Mm-hmm.
And so if you're able to reduce winter peaks, that is certainly a benefit to the utility insofar as it's, you know, avoiding cost of ultimately having to buy additional, whether it's firm energy or building something or buying something to meet your own internal demand, right? But it may not necessarily monetize if you're reducing your winter peak like it might monetize if you're reducing the amount that you have to buy back from the market for your summer peak.
There is some to what you're saying is correct, but the bulk of our avoidance comes off of that summer peak. Whatever is reduced in the summer peak is directly impacting the amount of benefit that East Kentucky gets.
Right.
Savings, avoidance savings that we get.
Even if you're not necessarily selling something into a PJM program, if you can reduce, even if it's behind the meter, if you can reduce that annual demand in the summer or 5 CP demand in the summer, that's less capacity that PJM is going to make you buy in the future. Is that what you're saying?
That's correct.
But focusing on that to the detriment of the fact that the utility actually peaks in the winter, right? How do you evaluate programs that would reduce that winter peak if you're using only the summer capacity benefits?
Well, the summer capacity benefits is the value from the market. So in the winter, we do have the savings from the energy saved. That is an avoidance in the market, if you will, from the energy side. But from a capacity side, really our benefit is from the avoidance in the summer, not the winter.
Right, but if the triggering event for East Kentucky, either having to buy some firm PPA or build additional generation, the risk of that is an additional winter peak or additional demand in the winter. Is that fair?
Restate that, please.
So you heard Mr. Cruz saying earlier, and this was Mr. Cruz talking, right? But Mr. Cruz was saying earlier that if the demand in the winter continues, that East Kentucky is going to have to look at some way of satisfying that demand. Whether, I think he mentioned specifically, you can either put steel in the ground or you can get a firm PPA for it. But that's going to be the actual reality if East Kentucky is going to have to either buy or build to make power. It's going to be to meet that additional winter demand. Is that correct?
I think the summer is the area that we're shorter in the summer than we are in the winter. We're longer in the winter. Is that right? No, I'm backwards on that. We're long in the summer. Is that right? Long in the summer, short in the winter. I get it right. It is something that we would have to look at if we were to develop programs to try to affect the winter more. What we find is in our service territory, we can affect winter demand, but it's difficult because a lot of our, especially in the residential space, our demand comes from heat pumps that are electric strip heat, and there's not much you can do there with electric strip heat. That demand is there. I'm not certain how we would, without discomforting our members, how we would manage, at least in the residential space, of a winter program that really gets a good impact on the winter peak and not necessarily a summer.
And a lot of that's driven by the lack of availability of gas in those more rural areas.
Absolutely.
Right?
We're very electric driven in the winter, unusually high electric heating in the winter compared to most utilities.
Right. And that electric heating plus poor housing stock, the poor housing stock just
Yep.
makes it worse. Is that your experience?
That's correct.
Yeah. Okay. All right. I really appreciate it. Thank you. Do you have any redirect
I
on
do
this
not.
witness? Can this witness be excused?
Yes, you can.
Thank you. You may sit down. Thank you very much, Mr. Gray.
Thank you.
Ms. Honaker, you have another witness?
Denver York?
Mr. York, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
Denver York, the Senior Vice President of Power Delivery and System Operations at East Kentucky Power, 4775 Lexington Road, Winchester, Kentucky.
Ms. Honaker, you may ask.
Did you cause direct testimony and certain responses to today request to be filed in the record of this proceeding?
Yes.
Do you have any additions or corrections to make to any of those documents?
No.
If I were to ask you those same questions today, would your answers be the same?
Yes.
Is it your desire and intent to incorporate those into the record of this proceeding?
Yes.
Did you bring any materials to the witness stand with you?
No.
Okay. The witness is available for cross.
Mr. West?
No questions.
Mr. Kurtz? No questions. Mr. Gardner? Ms. Vincent?
No questions.
Vice Chair?
No questions.
Commissioner Matthews?
No questions.
The only questions I have, Mr. York, are about transmission costs. Would you say that East Kentucky's, even if not in the totality of the expense, but East Kentucky's, just where they come from, that your all's transmission expense is materially different today than it was in your last rate case?
I would think so, yes. I've not looked at the exact cost, but I know that we have increased our operation and maintenance expense as well as some of the investments we've made.
Okay. And then in your expenses that are allocated from the PJM tariffs, are you seeing any significant increases on that front?
From the allocation for the PJM RTEP, for example,
Yes.
I think that would be more appropriate in our transmission planning group, which is under Mary Jane.
Okay. How about the demand for, let me ask this, of the projects that, and this is for somebody else, that's fine too, but of the projects that East Kentucky, transmission projects that East Kentucky has built over the last couple of years, have the drivers been from PJM-related projects, or have the drivers been East Kentucky and its members' own internal demands for whether it's reliability or whether it's, end of life, age systems that need to be replaced, or expanded growth, whatever it may be, internal drivers or external drivers?
Almost exclusively, but not entirely, driven by East Kentucky internal demands for, as you described, reliability, addressing some aging infrastructure as well as some load growth that we've had.
Okay. And given the age of East Kentucky and the age of its transmission system, it's an odd way to ask this, but are we about to enter the heyday of when the system is going to start needing to be, the transmission system is going to start needing to be replaced on a more frequent basis, given the build out that East Kentucky actually experienced when it was created?
Yeah, as most of us, you're familiar with the history of East Kentucky Power and our formation and the development of our transmission system. So yes, we're reaching a point where many of our assets are reaching that age where we question whether they're approaching end of life or not. So we have looked at the age demographics, in particular of our transmission lines, that show us that, we see some investments coming. We're already addressing some of those in cases where we've identified through some non-destructive testing as well as some inspections and field observations where we need to address some of those issues you just described.
Okay. And do you all take an approach that when something gets old, you rebuild it in place? Or do you all, when you do these reviews, especially with an aging system and there's been a change in load here or people have moved away from this place, how do you all take all those into account when you're determining how to rebuild this aging system?
Our process starts with the entrance of a problem statement that it identifies what the issue is. And in this situation, I believe as you're describing, we would start with a certain particular transmission line or circuit has reached the point where it's no longer able to provide the reliable service that our members expect and deserve on an ongoing basis. So that kind of identifies the problem, and then we look at alternative solutions, which could range from shoring up some of the structures, a reconductor, a complete rebuild, or even a retirement of that asset and feeding that load pocket from a different direction or using a different solutions circuit.
All right. Thank you very much, Mr. York. Ms. Honaker, do you have any redirect, Mr. York?
I do not.
Ms. Fensel, anything?
Nothing further.
Mr. York, be excused.
Yes, you may.
All right, thank you very much, Mr. York. And whenever you're ready, take your time. You can call your next witness.
Barry Lindeman.
Mr. Lindeman,
Yes.
please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
All right, please have a seat.
Thank you.
State your name and address for the record, please.
It's Barry Lindeman, East Kentucky Power Cooperative, 4775 Lexington Road, Winchester, Kentucky.
Ms. Honaker, you may ask.
Did you call certain responses today to requests to be filed in the record of this proceeding?
I did.
Do you have any additions or corrections to make to any of those responses?
I do not.
If I were to ask you those same questions today, would your answers be the same?
Yes, they would.
And is it your desire and intent to incorporate those responses into the record of this proceeding?
Yes, it is.
Did you bring any materials to the witness stand? with
I
you
did
today?
not.
Okay. Witness is available for cross.
Mr. West?
No questions.
Skirts?
No questions.
Gardner? I feel like I lean back every time to ask Mr. Gardner. Sir, Ms. Vinsel?
No questions.
Vice Chair?
No.
Commissioner Matthews?
No questions.
I have no questions for Mr. Lindeman, so.
Okay.
Thank you very much for coming. You may be excused.
Thank you.
Ms. Honaker, your third, is this your third or fourth?
This is my fourth.
Fourth.
Mark
Call your next
Horn,
witness.
he may not be in here yet. He might have thought Mr. Lindeman was going to take a little bit longer.
We can take our time. Mr. Horn, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and accurate true and correct under penalty of perjury?
Yes, I do.
Please have a seat. State your name and address for the record.
Mark Horn, 4775 Lexington Road, Winchester, Kentucky.
Ms. Honaker, you may ask.
Did you call certain responses today to request to be filed in the record of this proceeding?
Yes, I did.
Do you have any additions or corrections to make to any of those responses?
No, I do not.
If I were to ask you those same questions today, would your responses be the same?
Yes, they would.
Is it your desire and intent to have those incorporated into the record of this proceeding?
Yes, please.
Did you bring any materials with you to the stand today?
Yes, I have my responses, the current barge contract, and a utility benchmarking report.
The witness is available for cross.
Mr. West?
No questions.
Mr. Gertz?
No questions.
Mr. Gardner? Ms. Vincil, do you have any questions?
No questions.
Vice Chair?
No questions.
Commissioner Matthews?
No question.
All right, I have no questions, Mr. Horn. Thank you very much, Mr. Horn. You may be excused.
Thank you.
And I think this is your last witness, Mr. Sanford, until we ask Ms. Bridges to come back.
Yes, correct.
Okay, thank you. You may call your next witness.
Your Honor, we'd call David Mead to stand.
Mr. Mead? Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
My name is David Mead, East Kentucky Power, 4775 Lexington Road, Winchester, Kentucky.
Thank you. Mr. Sanford, you may ask.
Good morning, Mr. Mead. How are you today?
I'm doing well. How are you?
Good, good. Now, let's see, you didn't file any testimony in this proceeding. In fact, I believe you're adopting data requests. Responses were filed by a couple of other witnesses. Is that correct?
That's correct.
And who are those witnesses for the record?
Mark Brewer and Paul Doloff.
Okay. And you reviewed those data request responses?
Yes.
So are you aware of any edits or changes that would need to be made to those?
No.
Okay, so if I were to ask you those same questions, your answers would be the same?
Yes.
Okay, is it your desire, intent to have those data request responses filed into the record of this proceeding?
That's correct.
Okay, and did you take any materials to stand with you today?
I just have the testimony or the responses that Mark Brewer and Paul Doloff put together, and then just a few personal notes.
Okay. Your Honor, tender the witness for cross-examination.
Thank you, Mr. Sanford. Mr. West?
No questions.
Mr. Kurtz?
No questions.
Mr. Gardner? Ms. Vincil?
No questions.
Okay. Vice Chair?
No questions.
Commissioner Matthews?
No questions.
Mr. Mead? I have no questions for you either. I don't think Mr. Sanford will have any redirect for you, so you may be excused. All right, as a housekeeping matter, just for a minute before we do anything else, I just want to make sure that I understand the witnesses that we do have left. Mr. Sanford, before you close for the company, you do intend on bringing Ms. Bridges back?
Correct.
Okay. And Mr. Kurtz, you have
We have Mr. Collin.
Mr. Collin together, who's here in person, and then you have two remote witnesses yourself, is that
Kathy
correct?
Waddell and Steve Barron.
Okay, and we've excused your other witness.
Kornstein has been excused.
Okay, and Mr. Gardner, you have two witnesses, is that correct?
Just one, Sudie and Kelly.
Okay.
Remotely.
Remotely, and Ms. Kelly can be available today?
As we slow down, I told her to go tomorrow.
That's okay. So let's go ahead and we'll work through everybody else if it does happen today. We may want to see if Ms. Kelly is available. I'd prefer if we could go till, at this rate, maybe 5:30 to see how much we can get done by 5:30. Does anybody have a problem with that?
Yeah, that's fine with us.
Okay. All right. You call, if you don't mind to recall
Sure.
Ms. Bridges?
Yes, Your Honor. Happy to recall Ms. Bridges to the stand, please.
Thank you very much. just, you remain under oath from earlier, so no problem with that. Please take a seat.
Thank you.
And
I don't really have any qualification questions, so we just go ahead and tender the witness for cross-examination on the questions that have been deferred to her earlier.
all right, thank you very much, Mr. Sanford. Ms. Wenzel, you have questions for
Yes,
Ms.
yes, I have,
Bridges?
I do. Good afternoon.
Hi, good afternoon.
These questions are about the depreciation expense, looking at the actual depreciation included in test year and the pro forma adjustments. And let me go to the pro forma adjustments. From testimony we had earlier, it appears that the pro forma depreciation adjustments were based on the 2019 depreciation study conducted by Mr. Spanos. So having that overview background, can you confirm that the pro forma adjustments to the depreciation expense were based on the 2019 depreciation study?
Yes, that is correct.
And then the actual depreciation expense that was included in test year, was that based on service lives or on the 2006 depreciation study rates that were approved by the commission?
It was based on the service lives contained in the 2006 depreciation study.
So if we were to look at it, the service lives are laid out there in the 2006 depreciation study.
Yes, that's correct. That was also referred to in our 2006 472 rate case in sponsoring the new depreciation rates. It was clearly stated that the probable retire dates were used as a basis for production plant, and as is in the footnotes to our financial statements.
I believe that answered the questions we needed.
Okay.
Vice Chair?
Nothing else?
Commissioner Matthews?
No questions.
Ms. Bridges, so just to be clear, the commission approved, I just want to understand your testimony, the commission approved the depreciation study, but then separately approved different depreciation rates for production plant that was not based on the rates in the study, but were based off the service lives that were included in the study.
That's correct. We actually, East Kentucky, in its rate case that was done right after the depreciation study was performed in 2005, indicated that that's how we use the study for purposes of production plant.
Okay. And do you know whether the depreciation expense that would have come out of the rates in that study were higher or lower than the rates, the depreciation expense using the service lives?
I do not.
Okay. Thank you very much. Ms. Bridges, do you have any redirect of Ms. Bridges, Mr. Sanford?
No, Your Honor.
Okay. Can Ms. Bridges be excused?
Yes, you may.
All right.
Thank you.
So, Mr. Sanford, is there anything else from the company?
No, that concludes our presentation of evidence, Your Honor.
Okay.
You ready for Lane?
Call your first witness.
Unless you'd like to just go ahead and give us direct advice, Your Honor.
I've been here when you've tried that before.
I'll step back.
You don't get what you don't ask for.
That's exactly, nobody will give you anything unless you ask for it. That's exactly right.
You're just making a record.
Excuse me, I went ahead and sent a text to try to find out if she's available, but as we thought I heard you say, she's the last witness.
Okay, thank you very much. If she's unavailable, I definitely did say that, and we'll make it work.
Thank you.
But Mr. Kurtz, your two remaining witnesses would be available today. Is that correct?
I better,
Well, let's take a short recess while they go find Mr. Collin and while Mr. All right, we're back now on the record on 2021-00103. Mr. West, you can call your witness.
Attorney General calls Mr. Lane Collin.
All right, Mr. Collin, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
All right, please take a seat. Please state your name and address for the record.
My name is Lane Collin. My address is J. Kennedy and Associates Incorporated, 570 Colonial Park Drive, Suite 305, Roswell, Georgia, 30075.
All right, Mr. West, you may ask.
Mr. Collin, what is your occupation?
I'm the Vice President of J. Kennedy and Associates and an accounting and tax and rate-making consultant.
Did you cause direct testimony to be filed in this case?
Yes.
Do you have any additions or corrections to that direct testimony?
I have one correction. It's on page 16 of my testimony, line 14. The date 2016 should read 2015. That's the only change that I have.
Is it your intention to adopt the direct written testimony as your testimony in this matter?
Yes,
Did you sponsor any responses to data requests in this case?
I did.
If you were asked those same questions today, would your answers be the same?
Yes.
And what materials do you have in front of you at the witness stand?
I have the responses to the staff, one data request, and the responses to East Kentucky Power Cooperative's data requests, as well as my direct testimony and exhibits.
Chairman, the witness is available for cross.
Thank you. I don't think it'll matter in terms of where we go, but I assume, Mr. Sanford, you will not have any cross-examination from Mr. Collin?
I do not at this point, Your Honor.
Okay, thank you. So I'll start with you jointly. So, Mr. Gardner? Ms. Vinsel, do you have questions for Mr. Collin?
I do have a few questions. Good afternoon, Mr. Collin.
Good afternoon.
Were you able to watch much of the earlier parts of the hearing?
I did. I arrived here at about noon, and I've watched everything since then.
I asked because several of the questions I was going to ask you were answered earlier, and that's not to say that you came without a reason, but I guess what I really wanted to find out, I can't really recall if you were able to hear Mr. Scott's response, Isaac Scott's response in regard to the Smith One regulatory asset and how EKPC calculated it versus how you recommended it be calculated versus the settlement, and acknowledging the settlement is there.
Yes.
Were you able to hear any of his discussion?
I did not hear that.
Without revisiting or putting words into his mouth, his argument was that EKPC's position is that the settlement agreement in the 2015 case that set forth how this particular reg asset would be amortized did not address book amortization, and that is why they went with the 63-month. They pegged it to when rates would become effective. Knowing that I'm probably doing a not as great job as he would do if you had heard it, do you have any comments about how EKPC calculated the remaining term of the Smith One regulatory asset, specifically 63 months versus 84 months?
Right. First of all, I support the settlement, but if we were to litigate all of the issues, we do have a difference of opinion as to the amortization period. The company, there are essentially two regulatory assets. One is the amount of the regulatory asset on the company's accounting books, which is based upon a 120-month amortization period, just straight line from what was originally recorded as a regulatory asset, minus adjustments for sales of assets and other things. And then there's a regulatory asset that is for rate-making purposes that is defined in the stipulation in the so-called Smith Solution docket and the Commission's order. And that basically allows for these adjustments, starting with the January 1, 2017 per books amount, but then it reduces the regulatory asset by the amount of the market benefit revenues. And, but that only went through the end of 2019, and then the stipulation was silent really as to the remaining period. Now, so nothing has happened for that regulatory asset for rate-making purposes since the end of 2019. So the company calculated the amortization period running from January 1 of 2017 through December 31 of 2026, the same for rate-making as it did for its accounting purposes. But my read of that stipulation says that the amortization period is 10 years, and since there was a 20-month hiatus, then there would be essentially 84 months remaining, because there had been 36 months from 2017, 18, and 19. And so then 84 months would remain 7 years. But again, I support the settlement, but if we were litigating this, that was a position that I laid out in my direct testimony.
And thank you. Did you hear Ms. Bridges' just recent testimony in regard to the test year depreciation expenses in this case, that they were based on service lives and not on the depreciation rates approved in 2006 rate case?
Yes, I don't think that, I was in that case, and I don't think there was a clear understanding among the parties at that time that there would be a different depreciation methodology other than using the depreciation rates in that 2006 study. And we discovered that but didn't make it an issue in the case. And we were under the impression that the depreciation rates would be used from that point forward after the effective date of the rates from the 2010 case. But then we discovered in this case that they had not been, and instead what the company was doing, and this is specifically for production plant, was each month taking the net book value and dividing it by the remainder of the service life. And our assessment is that my assessment in my direct testimony is that that was a superior methodology, but it was different than what the company had presented. And I don't think Mr. Spanos was aware that they were not using the depreciation rates for the prior study. But that's just a factual matter. So.
Would you agree that retirement dates for coal plants, for example, are occurring sooner than previously estimated industry-wide?
We're seeing that across the industry, particularly the older coal-fired units that require additional pollution control equipment and investment. So, the newer plants, for example, AEP has a plant in Arkansas, the Turk unit. It's a supercritical coal-fired unit. It's fully controlled. We're not seeing any reduction in the life on something like that, but the older ones, yes.
In your direct testimony, you had referenced that, or you recommended that EKPC's short-term investment, interest expense, and interest income be excluded for rate-making purposes. Can you elaborate on your statement that none of the short-term investments are required or necessary to provide utility services or to maintain an investment-grade credit rating?
Yes, the short-term investments are not invested in plant, for example, that is, utility assets. They're simply an investment portfolio. The company also had, at the end of the test year, $50 million of cash and other investments that, in addition to the $111 million of short-term investments. And it would be almost as if the utility had invested in a shopping center or something like that, that really wasn't critical to the performance of its utility function. But anyway, that was, what I reflected in my testimony.
And can you expand upon the statement or recommendation that short-term investments maintained by EKPC are not necessary to maintain liquidity?
Yeah, East Kentucky at the end of the test year had $50 million in other cash and investments that I think they called them general funds or something like that. I used their terms in my testimony. I just don't recall the other than cash or cash equivalents. But the $111 million of short-term investments was in addition to that.
I'm going to switch gears here a little bit and talk about the interest expense and the tier for the environmental surcharge, construction work in progress, or QUIP projects.
Yes.
So we know that in your recommendation, you had discussed, let's just scratch that. Let's just go to the settlement. The settlement uses the interest rate for the credit facility associated with the initial funding of each environmental surcharge project as the basis for the interest rate for the interest expense for QUIP, NES.
Yes. As it turns out, there were really two issues related to the debt and the allocation of the interest expense. And the first issue was what interest rate was being used for all of the projects in the environmental surcharge. And it appears now, based upon my understanding of reading Ms. Bridges' testimony, is that the interest rate was too high. It didn't reflect the credit facility, an allocation of the interest on the credit facility, but rather reflected an allocation of all of the specific debt issues from Mr. Scott's testimony, and that if you then reflect instead an average, including the credit facility interest rate on the QUIP, the Spurlock CCR and ELG QUIP in the environmental surcharge, I think that Ms. Bridges said that was worth something like $7 million in terms of a reduction in the environmental surcharge revenue requirement. And then there is the issue of what is the interest included in the base revenue requirement, which is what I focused on in my testimony. And that is how much of, there was no interest allocated to the QUIP included in the environmental surcharge from the interest for the company in total. And so what I did was I just increased, using the same debt issues that Mr. Scott used, I calculated what the interest would be on that using Mr. Scott's weighted cost of, or the interest expense, the average interest rate on that debt, and then took that out of the base revenue requirement. In the settlement, the assumption is that that QUIP was financed with the credit facility. So that was really the difference between how I had quantified the effect of that issue, the double counting, so to speak, in the base revenue requirement, but the settlement assumed that the financing was done by the credit facility.
And as you said, you support the settlement.
I do. As a whole.
As a whole.
Obviously, I still support my testimony and everything, but
Yes.
the settlement is what it is, and I support that separately.
So going back to the interest expense for the environmental surcharge QUIP, do you agree that the adjustment that's made would have an effect on the surcharge rate of return?
Absolutely, yes. And that's what I was attempting to describe with respect to Ms. Bridges' testimony, but yes, the answer is yes.
Staff has no further questions.
Vice Chair?
Oh, sorry. No.
Do you have any questions?
Nope.
Commissioner Matthews? Commissioner Matthews, do you have any questions?
I do not.
Okay. I just have one, and I know you missed the testimony earlier, Mr. Collin. You were talking earlier about the treatment of the Smith One regulatory asset for rate-making purposes versus book purposes.
Yes.
Was it your testimony or understanding that East Kentucky stopped realizing amortization expense at the end of 2019 for the Smith One regulatory asset?
For rate-making purposes, it did. For book accounting purposes, it did not. And so there were different balances as of December 31, 2019. There was a slightly higher balance on the accounting books of the company than the regulatory asset for rate-making purposes. But since they continued to amortize it for book accounting purposes, I said in my testimony that I asked, or maybe the company gave me the number, but by the end of September of 2021, it would be about $60 million, and the company had $74 million for rate-making purposes. So there's a disconnect there.
But I guess what I'm trying to ask is the regulatory asset, the overall balance is lower, let's say in May of this year, than it was at the books closed December 31, 2019.
The book accounting balance was less. The rate-making balance, the balance that the company has included in this case, is the balance that they calculated off books, okay, just for rate-making purposes. And that was because they weren't getting direct recovery of the amortization expense. They were allowed to retain the market revenues, the capacity revenues, the net benefit, and they were using that to amortize the rate-making regulatory asset. And they stopped that at December 31, 2019. And so they took that rate-making balance and basically did no amortization of it for the 21-month period if you assume that rates go into effect in October of this year.
So let me ask about ASC 980, is that there's supposed to be a realization of some sort of offsetting revenues. That's a precondition to booking a regulatory asset, right, is the expectation of eventually recovering that for rate-making purposes.
Yes,
And
yes.
I guess what I'm trying to say is, what I'm trying to ask is, you're effectively saying when they stopped realizing those offsetting revenues, then for rate-making purposes, for not book purposes, but for rate-making purposes, you're saying when they stopped realizing those revenues for rate-making purposes, they stopped amortizing the regulatory asset.
And again, yes, but for rate-making purposes, they continued to amortize the book accounting regulatory asset because that was just a straight line over 120 months.
Okay, I just want to make sure that was a confusion between yours and Mr. Scott's testimony. I don't have any questions, additional questions for Mr. Collin, and I guess I'll come back to see if you have any cross-examination for Mr. Collin.
No question, John.
Okay, and Mr. Kurtz and Mr. West, do you have any redirect for
I'm
Mr.?
going to do a little bit of redirect, Your Honor, if that's okay.
Please take your time.
Mr. Collin, the $7.1 million environmental surcharge rate reduction in the settlement is larger than your recommended environmental surcharge rate reduction. Is that right?
Yes.
Okay. You're familiar with the 1.4 tier earnings mechanism?
Yes.
Without rendering a legal opinion, could the commission order that, or is that only something that could be accomplished in settlement?
My belief is that it's only something that could be accomplished in a settlement.
Is that a good provision for consumers?
It is. It caps out and requires a rate refund for over collections, but it's asymmetrical in the sense that it doesn't allow a rate increase. So it's very different than typical formula rate plans. It's basically a pure consumer protection. And in my experience, I've never seen that ordered by a commission other than through a settlement of the parties with the agreement of the utility.
Because of the earnings sharing mechanism, which is, I guess, maybe one of a kind in the country, in your opinion, is that a major reason why the settlement is reasonable?
It is a major factor, yes.
Thank you, Chairman.
You, Ms. Vincent, anything else?
Nothing further.
Mr. Covich? Commissioner Matthews? I think you would have probably already unmuted. You had something?
I have nothing.
All right, thank you very much. Can this witness be excused?
Yes, you may.
Mr. Collin, you may step
Thank
down.
you. Thank you very much.
Is this, thank you. Is this all you have, the only witness you have, Mr. West?
It is.
Okay. Mr. Kurtz?
I think what we'd like to do is put Ms. Waddell on, if that's fine. I think staff only has a few questions, and that way she can, I see she's on the computer, so.
That'd be great.
I think I'm supposed to do this. I've seen everyone else do it, so.
Ms. Waddell, can you hear me?
I can. Can you hear me?
I can. You've already called your witness, Ms. Waddell. Do you mind to raise your right hand, please? Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Mr. Kurtz, you may ask.
Thank you, Your Honor. Good afternoon, Ms. Waddell. Will you state your name and business address for the record, please?
My name is Kathy Waddell, and I'm at 4831 Highway 42 West in Gent, Kentucky.
What is your position with Nucor?
I'm the division controller.
What does the division controller do?
I'm responsible for finance, purchasing, HR, IT, and the warehouse.
Okay. You're fairly busy right now?
Yes, extremely busy.
Ms. Waddell, did you have prepared or prepare direct testimony and responses to data requests?
I did.
If I were to ask you those same questions, would your answers be the same?
They would.
Any corrections or additions to make to those data responses or testimony?
No.
Okay. Your Honor, I tender the witness for cross.
All right, thank you. Mr. West, do you have any questions?
No, I do not.
Mr. Gardner?
No, no.
Ms. Vincent?
Yes, I do, just a few. Good afternoon, with Ms. Waddell. Are you aware that EKPC has requested relief from reporting requirements that pertain to its contract with Nucor regarding interruptible service?
No, I was not aware.
You may not be aware that EKPC has a reporting requirement, and it was designed so that the commission could monitor how that service was going and if there were any issues. So let me ask you, would you say that EKPC has followed its interruptible tariff obligations?
To my knowledge.
Speaking on behalf of Nucor, would you have any objections if the commission were to grant EKPC's request to end that reporting requirement?
I don't have an objection.
That's all staff has to ask.
Thank you. Vice Chair Covich?
No questions.
Commissioner Matthews?
No question?
I have no questions. Mr. Sanford, do you have any questions, Ms. Waddell?
No questions for this witness, Your Honor.
Any redirect, Mr. Kurtz?
No redirect.
Okay, can Ms. Waddell be excused? Ms. Vincent?
Yes, she may.
All right, thank you very much, Ms. Waddell. You may step down.
Thank you.
Mr. Kurtz, do you have another witness? Is that
Well, we
correct?
have Steve Barron. We can put him on if you want.
That'd be great. Please call your next witness.
Nucor calls Steve Barron.
All right, Mr. Barron, can you hear me?
Yes, I can. Can you hear me?
I was going to say barely.
Better now,
Yeah,
hopefully.
thank you. Please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes, it is.
Okay, can you please state your name and address for the record?
Stephen J. Barron. My address is J. Kennedy and Associates, Inc., 570 Colonial Park Drive, Suite 305, Roswell, Georgia, 30075.
Thank you, Mr. Barron. Mr. Kurtz?
Thank you, Your Honor. Mr. Barron, did you prepare a direct testimony and responses to data requests?
Yes, I did.
Do you have any corrections or additions to those?
Not that I'm aware of, no.
If I were to ask you the same questions as those contained in your testimony and data request, would your answers be the same?
Yes.
Your Honor, I tender the witness for cross.
Thank you. Mr. West, do you have any questions for Mr. Barron?
I do not.
How about you, Mr. Gardner? Ms. Vinsel?
Yes, I have just a few questions. Good afternoon, Mr. Barron.
Good afternoon.
My first question is in regard to the contract class 10-minute interruptible credit. In your direct testimony, you had recommended that contract class 10-minute interruptible credit be increased to $7.57 per kilowatt month.
That's correct.
And in a separate response to a data request, you noted that the PJM 2022-23 delivery year net cone would support a $6.60 kilowatt month interruptible credit.
Yes. Upon receiving the staff's data requests, I reviewed the recent PJM planning parameters governing the base residual auction. And for East Kentucky, the basic cone rate is the same as Kentucky Power or AEP, but the energy and ancillary services offset is different. So I calculated the specific East Kentucky net cone rate, and that is $6.60 per kilowatt month on an ICAP basis.
Absent the settlement, which amount would you recommend be used for the contract class 10-minute rate? The $7.57 or the $6.60?
Well, as the premise of your question, of course, is very important. I absolutely support the settlement, and the settlement continues the current 10-minute interruptible credit of $6.22, which was set in the 2010 rate case. But putting that aside, I would support the 660 rate, which would be about 38-cent increase, I guess, per kilowatt month.
If the contract class 10-minute interruptible credit should be based on net cone, would you also agree that the contract class 90-minute interruptible credit and interruptible credits in EKPC's rate D should also be based on net cone?
I think it would be reasonable, but there clearly, as some of the discussions earlier today, it's clearly reasonable to differentiate between a 10-minute notice interruptible customer, a 30-minute notice interruptible customer, and a 90-minute. So, for example, the contract class has most of its interruptible load is under a 10-minute notice provision, and that's 622. But the 90-minute notice interruptible credit is only $4.20 kilowatt month, much less. And so it's important to recognize the quality of the value of the interruptible load that is being offered to the company. And so, but to answer your question, the foundation for the credit, I think it's reasonable to use net cone. And I would point out that the basic underlying framework used by Mr. Scott, which was to take the EIA assumption for a new CT and the PJM net cone, they're very similar. Obviously, the PJM analysis is very specific to the PJM entity. The calculation of the energy and ancillary services offset is specific to individual PJM members. And there are other factors that I think Mr. Cruz talked about that the Brattle Group does when they do some of their calculations.
Thank you very much. I'd like to switch gears to rate design and revenue allocation.
Okay.
We asked this to the EKPC witnesses also. In a scenario where the commission found that additional adjustments were necessary to the settlement amount, whether an increase or decrease, if there were additional adjustments, do you have a recommendation about a few ideas here? And the first is the 2.60% rate increase for rates B, C, G, and special contract and steam. Would it be preferable to maintain that 2.6% rate increase or to adjust the rates for all classes proportionally?
Well, my recommendation would be to accept the distribution implied by the settlement proposal in terms of the percentages, and to therefore scale up or scale down the dollar increases on a proportionate basis if the commission were to change the resulting revenue requirement. That's essentially what I recommended in my testimony based on my recommended increases for each rate class. So I would stick with that approach. I mean, there's obviously an infinite number of approaches you could use, but I think that's a fair approach. It incorporates, recognition of the settlement parties' agreements. In the case of Nucor, it represents the Nucor cost. It represents the cost of service evidence that both I submitted and Mr. Mackey submitted in his rebuttal testimony. So I think that would be the way to do it.
Are there any rate classes or components that you believe should not be changed?
Well, I haven't gotten into specific rate design components. So, for example, issues like a fixed charge or what have you, that may it may be appropriate within a rate class to make adjustments to reflect certain objectives or what have you of the company or the commission, if the commission addresses that. But with respect to the overall revenue requirement for each rate class, I think a uniform adjustment to the dollar increases up or down would be a reasonable approach.
And one final question. If the commission were to modify the rate design as proposed in the settlement, in regard to the allocation of revenue between the rate class components, demand and energy particularly, would you recommend that the commission, essentially just like with the rate design, that we keep to the basic distribution?
Yes, all else being equal, I think that would be reasonable to basically do a uniform adjustment. But as I said in my prior response, if there are particular factors that would justify some other tweak of a demand or energy charge for some reason, and like I said, I haven't examined the specific rate design of, say, Schedule E, for just an example, that could be done. But I think in general, a uniform adjustment would seem to be a reasonable approach.
Thank you. Staff has no further questions for Mr. Barron.
Dr. Chair, do you have any questions?
No questions.
Commissioner Matthews?
No questions.
None. Mr. Sanford, do you have any questions for Mr. Barron?
No question, Your Honor.
Can you redirect Mr. Kurtz?
Very briefly. Mr. Barron, about Mr. Mackey's rebuttal testimony that was discussed, based upon his rebuttal testimony and revised cost of service study, under the settlement, is the contract rate Nucor paying essentially almost dead-on cost of service based upon the Mackey revised study?
Yes, Mr. Mackey's rebuttal cost of service study before the adjustment to reflect the scale back of the 49 million to the 43 million request, his cost of service study produced the same result as mine in my direct testimony. But specific to your question, if you were to take Mr. Mackey's cost of service increase and scale it back or basically take his which is based on a different set of revenues, it's not total revenues, but if you go to Mr. Mackey's actual revenue increase on a basis and were to scale it back for the settlement revenue requirement of 38.3 million versus the file request, you would get very, very close to what the settlement is calculating for the Nucor increase. So essentially, at a $38.3 million settlement revenue requirement increase, the increase for Nucor is at cost of service. It's not above, it's not below, it's at cost of service, which is essentially consistent with what at least my experience in recent cases, the Commission has done for very large industrial customers.
One last question. Table 6 to your testimony, where you have identified what you call the full cost of service results, which is correcting the three average and excess issues, as well as allocating purchase power and fuel on an on-peak, off-peak basis. Based upon that full cost of service results, isn't it true that Nucor is paying above cost of service under the settlement agreement?
Yes. When the corrections to the cost of service study are made and the adjustment to reflect the fuel and purchase power expense versus revenue disparity that I discussed in my testimony is incorporated, the cost increase, the revenue requirement increase for Nucor would be about $424,000 versus the stipulation increase of $1.1 million. So it's substantially, the settlement would be substantially above cost of service when all of the elements that I had recommended in my testimony are incorporated.
And that would be a full cost of service increase to Nucor of $424,000 at a $49 million rate increase.
That is correct. It's before a scale back to even the company's $43 million request.
Or scale back to the settlement, the $400,000 becomes $300,000 or something compared to the $1.1 million that Nucor will pay.
Yes, that's correct.
Thank you, Mr. Mayor.
Thank you.
Is that all the questions you have, Mr. Kurtz?
Yes, sir, that's it.
Commissioner Barron, be excused?
Yes, you may be.
Thank you very much, Mr. Barron.
Thank you, Mr. Vice Chairman.
So, those are all your witnesses, Mr. Kurtz?
Yes.
Okay. Mr. Gardner, it's my understanding, correct me if I'm wrong, that your witness, Ms. Kelly, can be available at 9 a.m. tomorrow morning, is that correct?
Yes, Your Honor, it is.
Okay.
And I apologize that, we were sort of tracking, and then once that statement was made.
It happens. No good deed. It's the no good deed day. So what we'll do, if no one has an objection, is we will gavel in at 9 a.m. tomorrow morning to take the testimony and conduct cross-examination of Ms. Kelly. Well, what we'll do, given that she is the last witness that we have, and we're already doing everything we already do to have a remote hearing anyways, is that we will, if nobody has objection, we will take Ms. Kelly virtually and we'll conduct the hearing virtually as we've done for the last year and a half. Does anybody have an objection to doing that?
No objection, Your Honor. We'll just need to be provided with the link.
We can do that. We have the link. Ms. Vinsel has the link right now. With that being said, if any of the council would like to do it here, we're going to be here anyways. Ms. Zachary will be here. Ms. Vinsel will be here. If you all prefer to do it in person, just because you don't trust your internet, whatever it may be, you're more than welcome to come and appear tomorrow at 9 a.m. But otherwise, we'll finish with Ms. Kelly virtually tomorrow at 9 a.m.
Chairman, one caveat. Ms. Cohn may be the one conducting it for Nucor if I can't figure out how to get on it with my iPhone.
That's not a problem. That's not a problem. We will, because more may come tomorrow with Ms. Kelly, there may be additional post-hearing data requests. But I would like to ask everybody to be thinking ahead of tomorrow. We'll have a short discussion about how much time, and I think it's probably just going to be the applicant that's going to have post-hearing data requests submitted to it, how much time you'll need to respond. If staff could get the questions out by Friday, be thinking about how much time you all would need to respond. And then maybe at least discuss amongst yourselves whether you all would like to file in support of the stipulation, support of your application, as amended by the stipulation, whether you all would like to file initial and responsive briefs.
Speaking for East Kentucky, I think we'd like to file a brief, but I don't know that a response brief would be necessary, so I think we could probably just file one brief and be done with it.
Okay.
We'd agree with that, just one brief.
Okay, so be talking amongst yourselves between now and tomorrow. We'll come up with those dates. Is there anything else that we need to address tonight?
No, Your Honor.
Okay, all right. We will adjourn until 9 a.m. tomorrow morning.
Thank you.
Thank you.